prayer by the chaplain.
Let us pray. Almighty God, look with compassion upon the whole human family. Take down the walls that separate us. Unite us in bonds of love and peace. We know that you see the needs of your beloved, but for our memory's sake today, we remember before you those who suffer want and anxiety from lack of work, as well as those who are at times all too easily forgotten, the homeless, the destitute, the sick, the aged, and all who have none to care for them. We pray that you'll let our voices give voice to those in need, and that you'll let our hands be hands that offer help and compassion. Today we pray for Representative Tim O'Driscoll and his family at the recent passing of his father, Jerry. We pray in this moment of silence that you'll hear our prayers for him and his family and all those who we remember at this time who have lost a loved one. Trusting in your grace and mercy, we lift these prayers to you. Amen.
Members, our House Chaplain today is our very own Grady St. Dennis, the House Chaplain. Please remain standing and join me in saying the Pledge of Allegiance to the flag of the United States of America.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
The clerk will take the roll. The clerk will close the roll. A quorum is present. Clerk will read the journal for the preceding day.
Journal of the House, 87th session, 2012, 67th day, St. Paul, Minnesota, Monday, January 30th, 2012.
If there are no objections, further reading of the journal will be dispensed with, and the journal will stand as corrected by the chief clerk. Hearing no objections, the journal stands as corrected by the chief clerk. Reports of standing committees and divisions. A copy of this order of business has been placed on each member's desk. If there are no objections, the reports will be adopted. Hearing no objections, reports are adopted. Second reading of House files.
Second reading, House File 1766.
Second reading. Second reading of Senate files.
Second reading of Senate File 247.
Second reading. Introduction of and first reading of House files. The following House files have been offered introduction today. The Chief Clerk will report these House files and give them their first reading.
Introduction and first reading of House File 2034 through 2084.
First reading House File 2034 through 2084. Reports of Standing Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Dean, for the Committee on Rules, pursuant to Rule 121, designates the following bills to be placed on the calendar for today for Wednesday, February 1st, 2012. Senate file numbers 149, 373, 530, and 429, and House file number 56.
I call the member from Nicollet, Representative Morrow. For what purpose do you rise?
Thank you, Mr. Speaker. I rise on a point of personal privilege.
State your point of personal privilege, Representative Morrow.
Thank you, Mr. Speaker. Mr. Speaker and members, I'm sure many of you know that Robert Sharon passed recently. Robert Sharon was a former Chief Justice to the Minnesota Supreme Court. He also served in the Minnesota House of Representatives for 2 terms in the late 1940s. At his heart, Justice Sharon was a trial lawyer and soon missed the competitiveness of trial. He greatly enjoyed working in court, and he left the House of Representatives to pursue that dream. In 1963, Justice Sharon received a call from former Governor Elmer Anderson, a Republican. Governor Anderson asked him to serve on the Minnesota Supreme Court, and Sharon accepted. Governor Anderson's choice was not popular, but later Governor Anderson remembers Robert Sharon as one of his best appointments and one of the most notable jurists in state history. In 1970, the courtroom again called to Justice Sharon. He left the bench to go back to practice. However, that did not last long. Governor Wendell Anderson, a Democrat, asked Justice Sharon a short 3 years later to return to the bench, this time as Chief Justice of the Minnesota Supreme Court. Justice Sharon served until 1981, when he retired again to return to his love of trial work, stating at the age of 65, "I don't have that much time to fool around." In his capacity as Justice, Sharon spearheaded judicial reforms that are still tenets of our judicial system today, including continuing legal education requirements, criminal procedure rules, and the beginnings of our current Court of Appeals. To those who knew him, Justice Sharon had an innate kindness to him which stemmed from his thoughtful and patient management of a courtroom. His name nationwide is brought up on a list of greats that came from Minnesota's judicial system. To his daughter, current Senator Kathy Sharon, Chief Justice Robert Sharon was a great dad. Mr. Speaker, I would ask for a moment of silence to remember Justice Sharon.
Members, please rise in remembrance of our former colleague and Chief Justice Sharon for a moment of silence. Thank you, members. Thank you, Representative Morrow. Calendar for the day. First bill on the calendar for today is Senate File 530. The clerk will report the bill.
Senate File 530 on the calendar for the day, unofficially engrossed and reprinted for the House to include committee amendments, an act relating to civil actions.
I call on the author of the bill, Representative Mazorol, to present his bill.
Thank you, Mr. Speaker. I present Senate File 530 for passage. Senate File 530 relates to prejudgment interest and prejudgment interest paid on claims from the time the claim is made until the judgment is entered. Current law provides that that interest rate will be at the 1% Treasury bill rate with a floor of 4% for any judgments that are $50,000 or less. For any judgments of more than $50,000, current law provides that it will be a flat 10% interest rate. What this bill does is it lowers the prejudgment rate, that is the amount before judgment is entered, from the flat 10% down to the 1% Treasury bill rate, again with a floor of 4%. This restores interest rates back to their pre-2009 levels, which is the year in which that interest rate for prejudgment was raised to 10%.
There are amendments at the desk. Clerk will report the first amendment.
Atkins moving to amend Senate File 530, the first unofficial engrossment as follows. The amendment is coded A12-582.
Call the member from Dakota, Representative Atkins, to your amendment.
Good morning, Mr. Speaker. Representative Mazorol and members, what this amendment does is that it takes what Representative Mazorol has proposed and said that it will not apply to judgments and awards on harassment or discrimination claims brought against the Minnesota legislature or either of its bodies. And I do have an oral amendment, Mr. Speaker, if I might.
State your oral amendment for the Chief Clerk, Representative Atkins.
On line 1.5, after the word discrimination, insert the words "or wrongful termination."
Wrongful termination.
The Chief Clerk will report the oral amendment to the Atkins amendment.
Atkins modifying his amendment as follows on line 5. After discrimination, insert the language "or wrongful termination."
Member from Dakota, Representative Atkins, to your modified amendment.
Thank you, Mr. Speaker, and I would request a roll call on this amendment, please.
Representative Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the Atkins amendment. Member from Dakota, Representative Atkins.
Mr. Speaker, I'll wait to ask Representative Mazorol to yield, but Representative Mazorol, do you have any idea how incredibly bad this looks today? Any idea at all how bad this looks and how incredibly self-serving this looks today? On Monday, Mr. Speaker, a former Senate staffer introduced his legal counsel for claims that he intends to bring against the Minnesota Senate and against the Minnesota legislature for wrongful termination. 2 days later, Mr. Speaker, we take up a bill that would devastate the claims of a person bringing wrongful termination claims against the Minnesota Senate and against the legislature. Mr. Speaker, I'd move that this bill be laid over. This is the wrong time to be talking about this. It's the wrong reaction, and I'd ask for a roll call.
Representative Atkins, are you asking for the bill to be laid on the table or to be returned to the committee?
Just laid on the table, Mr. Speaker. Thank you.
Representative Atkins has asked for the bill for Senate File 530 to be continued on the calendar for today and has requested a roll call. Seeing 15 hands, there will be a roll call on the Atkins motion. Discussion to the Atkins motion. The member from Hennepin, Representative Mazorol, to the Atkins motion.
Thank you, Mr. Speaker. Members, what this bill does is that it doesn't change the post-judgment interest rate for causes of action over $50,000. All it does is make sure that during the time that litigation is pending, that the party who will owe the money eventually and against whom the claim is being made will be paying interest at a market rate. In other words, the value of that claim remains the same during the time that litigation is pending. And at any time the judgment is finally determined, that a judgment is entered, then the interest rate will move to what it currently is, which is the 1% Treasury bill rate or 4% floor up to $50,000 and 10% for any amount over $50,000. I don't see this at all as a devastating provision. All it does is hold the parties neutral during the time of litigation.
Discussion to the Atkins motion. Seeing no further discussion to the Atkins motion, a roll call being requested, the clerk will take the roll on the motion.
Take 68.
The clerk will close the roll. I call the member from Dakota, Representative Holberg.
Holberg votes no.
Representative Holberg votes nay. There being 58 ayes and 70 nays, the motion to continue does not prevail. We are on the Atkins motion before the body. Discussion to the Atkins amendment. The member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. I thought that was the politest way to approach it. I gave you an opportunity. Representative Mazorol, what you're doing then is you've got a former Senate staffer who on Monday of this week indicated that he's going to bring wrongful termination claims against the Minnesota Senate and against the Minnesota legislature. 2 days later, folks, we take up Senate bills that would, two Senate bills, both of them Representative Mazorol's bills, that would make it harder for that former Senate staffer to present his claims. Representative Mazorol, will you yield for a question?
He will yield. Representative Atkins.
Representative Mazorol, what district do you represent?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative, I represent District 41B, West Bloomington, South Edina.
The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Mazorol will yield for another question.
He will yield. Representative Atkins.
Representative Mazorol, which senator represents District 41?
The member from Hennepin, Representative Mazorol. Mr. Speaker, Representative, Senator Jeff Michel represents Senate District 41.
The member from Dakota, Representative Atkins.
I'm going to let that sink in for just a minute. Representative Mazorol, Senator Michel, is Senator Michel a potential defendant in the former Senate staffer's lawsuit?
Are you asking Representative Mazorol to yield? He will yield. Representative from Hennepin, Representative Mazorol.
Mr. Speaker, Representative, I have not seen any of the documents relating to that lawsuit, and I do not know if Senator Michel is a defendant or potential defendant in the charges being brought.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Thank you, Representative Mazorol. So 2 days ago, a former Senate staffer hired legal counsel to pursue a wrongful termination case against the state of Minnesota, specifically the legislature and the Minnesota Senate. 2 days after that, today, we bring up Senate bills that will prevent that person or make it very, very difficult or even devastating for that person to bring his claims. The same representative that is bringing the bills, his senator, is a potential defendant in that case that will be coming before the legislature. Representative Mazorol, will you still yield for another couple questions, please?
He will yield. Representative Atkins.
Are you aware of any other businesses in Minnesota that could change the rules in a wrongful termination case to make it harder for a person who is suing them for wrongful termination, where they could change the rules midstream so that it would benefit that business and make it harder on the employee? Are you aware of any business at all in the state of Minnesota that could do that?
Call the member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative, I am not, and I would like to point out that this bill was introduced in 2011. It went through the committee process. It was introduced on the floor even in 2011, long before any action or causes of action were raised that you're referring to.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Mazorol, I'm aware of one business that can change the rules, and you're looking at it. It's what you're doing today. It's what you're doing to that former Senate staffer. It's the only business in the state of Minnesota that can change the rules to benefit our business and hurt our employees midstream. We're the only ones that can change the law, and that's what you're proposing that we do today. Just a couple more questions for Representative Mazorol, if he will yield, Mr. Speaker.
He will yield. Representative Atkins.
Representative Mazorol, it's my understanding that the legislature has hired a relatively powerful law firm to defend against the claims of that former Senate staffer. Did they advise this course that we're taking today?
The member from Hennepin, Representative Mazorol.
Mr. Speaker.
1 minute, Representative Mazorol. Member from Washington, Representative Dean.
Thank you, Mr. Speaker, and excuse me, Representative Mazorol, but I probably need Representative Atkins to give me a little bit of help here. It seems as though you're probably drifting a little bit off course, Representative Atkins, in your line of questioning. I think you're probably close to the line if you haven't gotten your toe over the line already. Mason Section 124, I know everybody's probably not broken it out yet, but you might want to check that out before we go any further so that we can save ourselves the interruptions that are probably likely to follow along that line.
Although a point of order was not raised, again, members, sticking to the debate of the bill or the amendment before the body is our charge. Questioning the motives of a member are not appropriate here on the legislature, in the legislature, on the House floor. Representative Atkins, Representative Mazorol, Representative Dean. Representative Mazorol, you have the floor. You had agreed to yield to Representative Atkins to answer his question. Representative Mazorol.
Thank you, Mr. Speaker. Members, I do want to point out that there is nothing in this bill that diminishes or absolves any cause of action that currently exists. And in fact, the interest that is paid on any claim from the time it's made will continue to exist. It's only that we're changing it to be calculated on the basis of market rates rather than a flat 10%. And in fact, the market rate is about that one-year Treasury bill rate. But this bill, in fact, puts a
Mr.
floor
Speaker,
of 4%.
Point of order. I believe I have the floor, and I pose the question. Representative Mazorol is now making a speech on the bill.
I believe you'd asked him a question, Representative Atkins, and he was responding. But if you would like, I don't think he yielded. You asked him the question. I don't know if you yielded back.
It might help if I repeated the question, Mr. Speaker. It was simply whether or not the law firm that's been hired to defend the Senate and the Minnesota legislature advised this course that we take these bills.
Mr. Speaker, point of parliamentary inquiry.
State your point of parliamentary inquiry, Representative Biskins.
Thank you, Mr. Speaker. When a person stands to rise to a point of order, is it not deemed necessary that they actually state what part of Mason's rules, Constitution, etc., on which they're raising said point of order?
Representative Biskins, it is true, yes. Representative Dean raised a point of order, did not raise a point of order. A gentle reminder on the questioning of motives was the point that Representative Dean was making, did not cite a point.
Thank you, Mr. Speaker.
Biskins.
Thank you, Mr. Speaker. However, I do realize that Representative Atkins, in interrupting Representative Mazorol's speech, did rise to a point of order, and he did not reference any section in which he was standing for that point, Mr. Speaker.
Point well taken, Representative Biskins. Representative Atkins, I don't believe you did raise a point of order. Representative Mazorol did have the floor. I believe was attempting to answer the question. If he believes he'd answer the question, then you still have the floor, Representative Atkins. Representative Atkins.
Just, Mr. Speaker, if I might, I'll repeat the question. Did the law firm advise this course?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, I have had no contact directly or indirectly with the law firm that is representing either of the parties in the litigation that you're referencing.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Will the Majority Leader yield, please?
He will yield. Representative Atkins.
Thank you, Mr. Speaker. Representative Dean, Majority Leader Dean, the lawyers that we've hired, how much are we paying those lawyers, and where's the money coming from?
Member from Washington, Representative Dean.
Thank you, Mr. Speaker and Representative Adkins. This is the House, and the House is not part of that. The House has taken up some jobs bills today. We are trying to get forward on Reform 2.0. We are trying to move forward. You would like to do that at a different day. I understand that. I'm not quite sure what the Senate has to do with when we take up this bill or what's going on over there. But I tell you what, we got people out of work across the state of Minnesota. This is a first step forward with Reform 2.0, and we are ready to go. The Senate hires lawyers on that side. This doesn't have anything to do with that. This has to do with a bill that I understand that you are very much opposed to, and we'll hear about how much you're opposed to it all day and how you don't want to take it up today and how you'd rather take it up somewhere else and you're going to amend it. But this is the bill at hand. It doesn't have anything to do with Senate business. It has to do with Minnesota business.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. And with due respect, Representative Dean, Majority Leader Dean, it has everything to do with that. And you know well that it has everything to do with that. As we sit here today, we have a claim being made against the Minnesota legislature. The Senate or the legislature has hired some lawyers to defend us. We don't know how much they're being paid. They don't know if they advised this course that we should adopt and change the rules, literally change Minnesota law to make it more favorable to the Minnesota legislature to defend against this wrongful termination case being brought by a former Senate employee. I don't know how you get more relevant than that, Representative Dean. It's right on all fours on the very issue. It's right here in the well of the Minnesota House. We have the ability to vote on those Senate bills today and change Minnesota law today to our favor, to the detriment of that former Senate employee, and you're saying it's got nothing to do with that. I'll leave the rest of the questions relative to that particular topic. But folks, if that is the direction that you want to go, I would suggest to you that it will not be very well perceived. As a member of this body, whether I vote yes or vote no on this bill, it will be incredibly badly seen by the people that I represent. It's a horrible reflection on this body to take action that would be to our benefit, to literally change Minnesota law to our benefit against a former employee who's bringing a claim for us that he just talked about on Monday. I can't imagine that we are even talking about that today. And with that, Mr. Speaker, I will sit down and rest for a while. I appreciate your patience.
Member from Hennepin, Representative Hortman.
Thank you, Mr. Speaker. My question is to the bill and not to this amendment, so I'll wait until we're done with this amendment.
The member from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. Members, I think that contrary to Representative Mazorol's statement that this bill wouldn't undermine fair access to justice, this case that Representative Atkins is talking about with a former Senate staffer illustrates exactly why this interest rate change is unfair and why this interest rate change just rigs the system against people who actually need to go to the courts in order to get a measure of justice. So imagine you're a Senate staffer, or imagine you have any job, and you are terminated, but you were wrongfully terminated. You were illegally terminated. Usually when you're without a job, maybe you get unemployment, maybe you don't. It could be a wrongful termination that results in no unemployment. And suddenly you have to figure out how you're going to pay your mortgage, you're going to have to feed your family, you have to keep up on bills to the best you can. I think a lot of Minnesotans can understand that. When you are out of a job, you have to figure out a way to make ends meet, and you hope that you're going to find another job on the other end of it. You hope it's going to come out on your side. So what do? A lot of people actually try to spend down savings. If they don't have a lot of savings, they might have to borrow some money. They might have to put more things on their credit card. Some people end up having to put mortgage payments on their credit card. People put groceries on their credit card. People pay their bills on a credit card. Maybe they take out if they have any home equity left, maybe they try to take out a home equity line of credit in order to get a little bit of cash to get through the period of unemployment. So think about that. You're wrongfully terminated. You're without a job. You're trying to figure out how you're going to keep things going until you get your next job. And so what do? You get credit, and the interest rate that a consumer or an individual who's wrongfully terminated, the interest rate that that person is going to get, the money that they're going to have to borrow, is not going to be at a Treasury bill level. If you've got that credit card, Representative Mazorol, you must be a financial magician. Because most people, when they get credit cards or when they have a home equity line of credit or when they have to borrow money, they're paying much higher interest than even the 10% under current law. They're paying 12%, 18%, 25%. So imagine you're wrongfully terminated and you have to sue your former employer in order to get either reinstated or get a severance package. And while you're waiting for the wheels of justice to turn, while you're waiting for that money, you're borrowing. The employer is holding on to money that they owe you, and they are not paying, or they're holding on to the money that they owe you, and you're paying 18% interest. Under the Mazorol bill, under this bill, you're only going to have access in the end to maybe 4%. So you're paying 18%, you did nothing wrong, you get 4% back. That's what this bill does wrong. That's why the Mazorol bill is a bad bill for people who need to go to the courts to get justice. And if you're a former Senate staffer and you've got a good claim against the state Senate, the Minnesota legislature shouldn't be pulling the rug out from under you again. You should wait for justice to work. And when that time comes, the staffer shouldn't be out all of that difference in the interest that they had to pay in order to make ends meet. And that's what's wrong with this bill. There are obviously larger issues involving the state Senate, the state legislature, and a staff member right now. But it's a great illustration of just how bad this bill is for the individual person who has to go out and try to get something out of a former employer who has wrongfully terminated them. The system is already stacked against that person enough. This bill just rigs the system even further on behalf of people who can have better access to resources, lower interest rates, and everything else. So that's why this bill is unfair. I strongly support the Atkins amendment.
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative, the purpose of this is to maintain the value of that claim during the time of litigation. Until there's final entry of judgment, there hasn't been a final determination as to fault, and up until that time, this just assures that the claimant's claim does not lose value over time. And the recognized value is a market value, is a market rate, which this bill proposes to be 1%, or the one-year Treasury bill rate, with a minimum, again, of 4%. These are short-term investments, or short-term time during which this litigation or anything would be invested, so there's no incentive even on the part of the defendant to prolong litigation. So it keeps the value of the claim whole. Mr. Speaker, too, and members, I would like to point out that this effective date of this bill is August 1 of 2012 for judgments that are entered after that date. So the application of that effective date, I think, is informative as to the line of questioning that's going on.
Member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. Members, in this discussion, I thought I detected a calling of, what is the motive behind, and a questioning of advantage. Every bill that I vote on is to the advantage of the citizens, and that's the motive why we bring it forward. And since I'm a citizen, I'm sure there are times where it helps me too. But I think we should discuss the validity of the issue and not be questioning advantage and motive. We're trying to do the work of the people, and I hope everything we pass is to the advantage of the citizens of our fine state.
Seeing no further discussion, a roll call being requested, the clerk... Oh, I'm sorry, Representative Hansen, did you... I'm sorry, member from Dakota, Representative Hansen.
Thank you, Mr. Speaker, and we're new to the session this year, so I wasn't as fast on the uptake there. I don't know if this is a parliamentary inquiry, maybe that's the best way, but the discussion has been related to the Senate, but is there any pending litigation against the House? We had during the interim the action of the termination and then the untermination of Susan Thornton from the Legislative Commission on Minnesota Resources. And my question is, can we, as House members, even be voting on this if there's potential litigation related to the House?
Is not a point of parliamentary inquiry. I will not be able to answer Representative Hansen. Further discussion? Seeing no further discussion, a roll call being requested. The clerk will take the roll on the Atkins amended amendment. The clerk will close the roll. There being 61 ayes and 70 nays, the amendment is not adopted. There's an amendment that asks the clerk will report the next amendment.
Atkins moving to amend Senate File 530, the first unofficial engrossment as follows. The amendment is coded 569.
I call the member from Dakota, Representative Atkins, to your amendment.
Thank you. Maybe we'll have better luck with this one. Mr. Speaker, I will save my comments relative to Susan Thornton's situation, I guess, for the third reading of the bill. But the custom and usage or custom and practice in this body has been that the chief author of an amendment generally gets the last word to express their thoughts on the amendment. I was standing and would hope to be recognized next time. But every time that we've done this, every time that we have made modifications like this, in 1974 we reformed auto insurance and we mandated a reduction in the insurance premiums that insureds paid. In the 90s we did workers' compensation reform and we mandated a reduction in insurance premiums paid. The lowest amount that we've ever mandated was 16%. Relative to auto insurance, we mandated a 30% reduction in insurance premiums. For work comp, we mandated a 16% reduction. You can look those statutes up for yourself. This would simply do the same thing. If this is really for Minnesotans rather than for big corporations, if this is really about middle-class Minnesota and job creation and all the things that Representative Mazorol talks about, then we ought to mandate the insurance premium reduction. And with that, folks, I would appreciate a yes vote, and I'd ask for a roll call.
Representative Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the Atkins amendment. Discussion to the Atkins amendment. The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, in 2009, this bill, this amount was changed up to the 10% that currently exists. And I haven't seen anywhere that, in fact, insurance premiums were authorized or mandated to be raised at that time. And I think that's a job that's within the purview of the insurance companies and the Commerce Department in order to regulate those premiums. I would speak against this amendment.
Discussion. The member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. Will the chief author yield?
He will yield. Representative Atkins.
Thank you, Mr. Speaker. Representative Mazorol, would you agree to any premium reduction, even a 1% premium reduction or a 5% premium reduction? Would any of that be acceptable? Because that'll probably stem some of my amendments. And if you're just going to speak against any premium reduction at all, you'll save yourself a few more amendments.
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, I speak against this body mandating insurance premium reductions because, again, that's in the purview of the business and the Commerce Department.
Discussion. The member from Dakota, Representative Atkins.
Then this will be my final comment on it. You've just confirmed, Representative Mazorol, that the goal with this legislation is to line the pockets of insurance company executives and make big companies more money at the cost to the middle-class Minnesotans that pay the premiums. If that's what you want to do, folks, then vote against this amendment. That's all this amendment does, is it says we're going to pass along the savings that everybody talks about. These bills are going to save everybody so much money, but they're not willing to pass along the savings. That's ridiculous, Representative Mazorol, and I'd urge that we vote for this amendment.
Discussion. Seeing no further discussion to the Atkins amendment, roll call being requested. The clerk will take the roll on the amendment. Clerk will close the roll. There being 61 ayes and 70 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Simon moving to amend Senate File 530. The first unofficial engrossment as follows. The amendment is coded 587.
Call the member from Hennepin, Representative Simon, to your amendment.
Thank you, Mr. Speaker and members. The Consumer Fraud Act is really one of the crown jewels of Minnesota's consumer protection laws. Under the Consumer Fraud Act, it protects everyday people in everyday transactions all over the state from the act, use, or employment by any person of any fraud, false pretense, false promise, misrepresentation, misleading statement, or deceptive practice with the intent that others rely thereon. That last word's pretty key. This only gets to intentional behavior. In other words, a person who loses a case under this act, the Minnesota Consumer Fraud Act, intentionally harmed consumers, not accidentally, not negligently, not even knowingly, but the highest possible standard. They intentionally did something wrong in order to rip people off. Under this bill, those people who a jury has said did something wrong intentionally to rip off Minnesota consumers, those people would get a windfall, essentially, or at least their insurance company would, because they would have a lower interest rate to pay. So it would go from 10% to 4%. I don't think there's anyone in this body, as much as they might like the overriding idea of Representative Mazorol's bill, I don't think there's any Republican in this body or any Democrat in this body that wants to do that. So this amendment, members, is an invitation for you to create an exception for the Minnesota Consumer Fraud Act so that whether it's a financial institution or a pharmacist or someone who is a rogue construction operator, that is someone who comes in from out of state to prey on people who have suffered hail damage or other natural disaster related damage, all of the hucksters and the cheaters and the chiselers and the rip-off artists would benefit, at least indirectly, but maybe directly, from this bill. And as I said, there's not a member in here who I think wants to do that. So this is an invitation for you to say loudly and proudly that we're not going to diminish the protections for Minnesota consumers. And, Mr. Speaker, because the Consumer Fraud Act is so important to so many everyday people who simply want to get their money back or want to get a practice stopped when they've been taken advantage of, I would ask for a roll call on this amendment.
Representative Simon requests a roll call. Seeing 15 hands, there will be a roll call on the Simon amendment. Discussion to the Simon amendment. Member from Hennepin, Representative Mazorol, to the Simon amendment.
Thank you, Mr. Speaker. Representative Simon. This is a prejudgment interest rate statute. The idea here is to hold the value of that claim during the time of pending litigation and until there's actually a final adjudication. It's not intended to be a punitive statute, particularly prior to final adjudication. And there are other statutes that will provide for that sort of relief. This isn't the statute in which to do it. I speak against the amendment.
Member from Hennepin, Representative Thiessen, to the Simon amendment.
Thank you, Mr. Speaker. Representative Mazorol, maybe the big corporations you're standing up for today can borrow money at that rate, but the consumers who are going to be harmed and who are suing under the Consumer Fraud Act, as Representative Winkler pointed out, can't borrow money at that rate. So maybe every person in your district can get rates, credit card rates at 4%, and if that's great, that's wonderful for you. But I don't think you're standing up for your constituents today. You're standing up for big business, and that's really unfortunate.
Seeing no further, the member from Hennepin, Representative Simon, the author amendment to your amendment.
Thank you, Mr. Speaker. Will the author of the bill yield?
He will yield. Representative Simon.
Thank you, Mr. Speaker. Representative Mazorol, let's say someone in Edina or Bloomington has hail damage that's not covered by insurance. And let's say that some huckster comes along from out of state, claims that it will take care of the hail damage on the house, charges an upfront fee. That person in Edina or Bloomington pays that money, is out, I don't know, I'll pick a number, $1,000, maybe a couple $1,000s, maybe more, as a down payment. And that person basically vanishes or pretends to go out of business or for whatever reason doesn't provide the service and comes up with a list of excuses. There's a trial, there's a verdict, there's a judgment. That person, that huckster from out of state, did something intentionally wrong, not accidentally, not knowingly, but intentionally sought to deceive someone. Is it fair that the interest rate on that judgment should go down from 10% to 4%? Is that fair?
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Simon, I believe what's fair is fair adjudication of any action, and in fact, once that judgment has been adjudicated and entered, the interest rate, if it's over $50,000, does remain as it is currently, which is at a 10% rate.
Member from Hennepin, Representative Simon.
Thank you, Mr. Speaker. Well, I guess I'll interpret that answer as a yes, that it is fair, at least under certain circumstances. To me, anyway, members, the division between over or under $50,000 really ought not to matter. Whether it's bigger or smaller, if some out-of-state rip-off artist comes in and takes advantage of our constituents, whether it's weather-related or otherwise, that's not right. And to give them, or at least give any insurance company through this bill, a windfall, I think is wrong. And again, I presume that every single person in this body, regardless of where they're from, regardless of whether they're Democrat or Republican, doesn't want that to happen. And so this amendment, again, is an invitation to show that that's correct and to show that members are willing to stand on the side of everyday Minnesotans and not on the side of the insurance companies who are likely to benefit from this. Thank you.
Member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. The idea for this change is that, in fact, there is no windfall, that the value of that claim maintains its value during the course of litigation for both parties.
The member from Hennepin, Representative Thiessen.
Thank you. So what's the difference between if it's over $50,000 or under $50,000? Why would you pay 10% to maintain the value of the claim over $50,000 and 4% under $50,000 if that's the argument you're making? I don't quite understand your point.
Were you asking Representative Mazorol to... Nope. Okay, member from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. I would ask Representative Mazorol to yield.
He will yield. Representative Winkler.
Thank you, Mr. Speaker. Representative Mazorol, so the Simon Amendment, it leaves the rest of your bill alone, right? It says that the interest rate comes down in all cases except where somebody intentionally defrauds a consumer. So this only applies to cases, as Representative Simon said, where a consumer is intentionally defrauded. And your statement is that by paying a higher interest rate, these people who are responsible for the fraud are being unfairly treated. And I have this handout from the NFIB and for Minnesotans for Lawsuit Reform, and they have all these employers on there. And I'm going to guess that none of the employer associations and I'm going to guess the NFIB don't represent people who defraud consumers. That's not their position. They're not going to say that we are the National Federation of Independent Business and we are going to stand up for people who defraud consumers, who steal money from people. We represent the thieves. They don't want to say that. So why wouldn't you take this amendment? My question is, why not take an amendment that would exempt people who are intentionally engaged in fraud from your bill? What possible good can be served for any of the businesses listed, for job growth, if you're not willing to exempt people who are intentionally defrauding consumers? I don't understand how that serves job growth except in the fraud industry. So could you explain why that would be good for any of these other businesses?
The member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Winkler. This statute is about maintaining the value of a claim. It's not about being punitive, certainly in those situations that we find egregious, There are other ways in which to assess punitive damages, to find additional damages against a bad actor in intentional situations as well as others. However, this statute is really about maintaining the value of a claim during the course of litigation and until final adjudication.
Member from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. And Representative Mazorol, I understand that your bill is about interest rates, although I suspect if you thought it could get passed, there would be another bill that would prevent anybody from getting punitive damages against people who commit fraud. The question you won't answer is, how is this good for jobs? How is this good for business? If you're saying that people who intentionally commit fraud need to get a lower interest rate, who in the state of Minnesota does that help? It helps nobody. It doesn't help consumers. It doesn't help the average person on the street trying to make their way in the world. It doesn't help any of the businesses listed. It doesn't help any job provider. It doesn't help anybody. Nobody in Minnesota benefits from rejecting this amendment. The only reason to reject the amendment is if you don't want to, for some reason, take any amendments at all to the bill, even if they improve it somewhat. So I don't understand why anybody would not vote to accept this amendment. People who commit fraud intentionally shouldn't get the benefit of a lower interest rate by the Minnesota legislature. It doesn't make any sense. Vote yes.
The member from Nicollet, Representative Morrow.
Thank you, Mr. Speaker. Mr. Speaker, will Representative Mazorol yield?
He will yield. Representative Morrow.
Mr. Speaker, Representative Mazorol, would you please explain to me how punitive damages are calculated and assessed? Because what I heard in your answer was there are other avenues available, including the imposition of punitive damages. So I'd like to understand how punitive damages are calculated and assessed.
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Morrill, my reference was to generally to statutes that do exist, and I don't have the cites in front of me, but there certainly are statutes that would allow for punitive damages. In some cases, there are multiple of actual damages. In other cases, they are set as a specific amount. But this statute, again, does not address that particular issue.
Member from Nicollet, Representative Morrill.
Well, thank you, Mr. Speaker. And Representative Mazorol, I don't think that quite answers my question. I'm not so worried about the citations. I think I'm asking a more general concept about punitive damages. And I'm rusty on it, so I'm asking for your guidance. So I will ask if Representative Mazorol will yield.
He will yield. Representative Morrill.
Thank you, Mr. Speaker. Representative Mazorol, I'm going to ask you to find out if my understanding of punitive damages is generally correct. One way the punitive damages can be assessed is, as you said, it can be a multiple of the actual damages. Another way that punitive damages can be assessed is it can be based upon either the net worth or assets of the defendant. That punitive or punish is based on the amount of money that it would take to punish the defendant, the wrongdoer, so that they would not do it again. And it would also hopefully deter future wrongdoers. So, for example, we might see a large corporation, a large petrochemical corporation, paying millions and millions in punitive damages because that's what's deemed to be the amount it takes to have it hurt, so that no one would want to do this again, the punishment. So am I right in understanding that punitive damages in many cases is based upon the assets, the holdings, if you will, of the defendant?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Morrill, I don't know if it's in many cases, but certainly that is another way that sometimes punitive damages are assessed.
Member from Nicollet, Representative Morrill.
So, Mr. Speaker and members, if I understand Representative Winkler correctly, and I think I do, Representative Winkler, and given my work with the Consumer Fraud Division of a major attorney's office, what I understand is that people who do intentional wrongs don't always have a lot of assets. They actually might be bankrupt themselves. They actually might owe a lot of people money. So punitive damages for those types of fraudsters, those people who are ripping off our constituents intentionally, punitive damages is a piece of paper. It's not dollars. It's a piece of paper you'll never collect on. The impossibility of collecting on that judgment. And these are people, I think Representative Winkler said, who are doing the wrong thing intentionally. So deterrence by punitive damages really doesn't work, and it doesn't help our constituents. The ones who are defrauded aren't going to be able to collect on the punitive damages. That's not really an answer to the question that Representative Winkler and Representative Simon have asked. So, Representative Winkler, I join you in opposing, or I favor the amendment, because there is no reason the Minnesota State Legislature should be helping people who intentionally plan and rip off our constituents. It makes no sense as a policy directive for this state.
Member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. I'd like to just address a few of the points that have been raised by other members of the body, Representative Winkler, Representative Morrow. As Representative Mazorol has already said, the purpose of the prejudgment interest rate is to preserve the value of a claim going forward until there is a judgment, right? So we're conflating things here. Representative Winkler, you know you are conflating things that shouldn't be conflated. Not that I can read into your intent or mind, but the fact of the matter is that is the purpose of the prejudgment interest rate. Representative Morrow, if you're saying that these horrible fraudsters out there, there are horrible fraudsters, right? If you're not going to be able to recover any punitive damages against them and that's ineffective, you're not going to recover any damages against them because it's not effective, you're not going to be able to recover damages as enhanced by a little bit of prejudgment interest either. So that point doesn't seem to work logically. Now, there are other avenues for relief in statute already to punish fraudsters. Prejudgment interest rate statute is not where we do that. Section 8.31, the Private Attorneys General statute, which allows private individuals aggrieved by consumer fraud under the Consumer Fraud Act to sue sort of on behalf of the Attorney General, if you will, and on their own behalves to recover damages, allows for not only just the recovery of monetary damages to compensate them for their loss due to fraud, due to consumer fraud, but also for their costs, for their reasonable attorney fees, and other equitable relief as determined by the court, and anything else that the Attorney General could recover. So civil penalties and the like. Plus we have punitive damages, and you're correct, punitive damages are calculated so as to deter, so that they're sufficient to deter the actor from continuing that kind of fraud in the future, or perpetrating that kind of fraud in the future, and they take into account a number of factors which really aren't relevant at all to prejudgment interest. But the Private Attorney General statute handles all of the concerns you're raising. The prejudgment interest rate statute is an entirely separate matter. This has nothing to do with whether we are helping or hurting fraudsters. This is just about whether the prejudgment interest rate is too high right now. And if reducing it, we get some reduced cost to businesses and improvement in Minnesota's business climate and competitiveness. So perhaps more businesses will move to Minnesota. Businesses already here will expand in Minnesota. And entrepreneurs will feel more free to start up businesses here in Minnesota because, of course, any money we free up from litigation costs is money that a good business, because most businesses are not fraudsters, can use to expand, grow, and create jobs.
The member from Grant, Representative Westrom.
Mr. Speaker, members, Representative Morrow, Representative Winkler, I've heard you talk about the injustice of this bill that Representative Mazorol is bringing forward. I would like to remind us of discussions and a bill that has passed through the body when the DFL was in charge, exempting government from the 10% interest rate. That at that time, I think it was Representative Marquardt that carried it through the Civil Law Committee. 10% was too exorbitant for government, but now you're here arguing today that government should get treated better than the citizens of the state of Minnesota. So members, listening to those arguments, understand that government gets 4% right now. That was offered by Democrats a couple of years ago to correct what they said was too expensive for government to pay a 10% interest rate. And now today you hear them arguing that the private sector of our economy and the citizens of our state should have to get it socked to them, but government shouldn't have to pay. So you've got a divide here of people that want to protect bureaucrats and large government institutions, but the citizens and the constituents and the taxpayers who pay the bill and generate wealth to pay taxes to operate government shouldn't get treated the same as government. So be mindful of that when you hear Representative Winkler, Representative Morrow talking about how, and Representative Atkins, I heard you talking about it earlier. Representative Atkins, I don't know how you voted, but I would dare to guess that you probably voted to lower government to the same standard we're talking about today. You can correct that if that's not right. Representative Marquardt carried the bill. So, members, what's good for the goose ought to be good for the gander, but that's the argument you're hearing today. Government should be treated at a much better level than the taxpayer and the citizens paying the bill.
Member from Nicollet, Representative Morrow.
Well, thank you, Mr. Speaker. Mr. Speaker, first to Representative Westrom's point. Representative Westrom, the word I'm focusing on here is intentional. It's the intentional wrongdoing. I don't think I, for one, ever stood on the House floor and defended local governments intentionally defrauding our constituents. It's that narrow case of intentional wrongdoing that the amendment focuses on, and that's the very narrow focus I'm focusing on as well. I would concede in part what Representative Wardlow had said, and I don't see Representative Wardlow on the floor, about the ability to collect. I just think it's more likely to collect prejudgment interest than it is the punitive damage against many of the folks who would defraud our constituents. But it's the 4%. The 4% does not capture the loss that the constituent might experience, and I think it was either Representative Winkler or Representative Simon who touched on this. If one takes out a credit card to try to cover the expenses of the loss of having been defrauded, the credit card rate is not going to be 4%. If this legislation would guarantee my constituent that my constituent could borrow money at 4% interest to cover the losses of being intentionally defrauded until the judgment were awarded, I'd be right with you, Representative Mazorol. But the problem is I think my constituent may be taking out a credit card that might be at 20 or 22% to cover the losses of having been intentionally defrauded, and then gets a 4% payback in interest if our constituent prevails. It's that gap. I don't understand why we would expand that gap. I know it's 10% now. The gap already exists. We have constituents who are borrowing money at more than twice the interest rate they're going to get reimbursed at. They're already borrowing money at twice the interest rate. Now we're making it 5 to 6 times the interest rate if we go down to 4%. That's why, Representative Mazurel, I respect what you're trying to do. It's just the narrow case of someone who's been found to have intentionally defrauded one of our constituents. Representative Westrom, I'm not talking local governments. If they do intentional fraud, then yeah, they should be treated the same way as I think Representative Simon's amendment would work. So members, it's a narrow case. We're not talking about the majority of Minnesota businesses. But when somebody intentionally does something wrong, we shouldn't harm the victim even more by saying when you borrow money to get through to Judgment Day, you get to borrow it now at 5 to 6 times the interest rate you're going to get repaid.
The member for Hennepin, Representative Mazurol.
Thank you, Mr. Speaker, members. It's been a number of years since I practiced law, but it seems to me that if there are, in fact, additional damages that are incurred as a result of having to borrow at a higher interest rate, that may, in fact, there may, in fact, be an argument that that is part of the damages that are claimed. And I wouldn't represent that because, again, it's been a number of years since I've practiced. But again, let's get back to what the core of this statute is about. It's about maintaining the actual claim of plaintiff or defendant in these cases at the value at which that claim is first made, so that it doesn't lose value in real dollars during the pendency of the claim. Also, let's not lose sight that this is about prejudgment interest. We talk about bad actors here, and we're all sympathetic to those situations, but until that judgment is actually adjudicated and entered, there is no fault legally. And in fact, this interest, again, is just in order to maintain the value of the claim.
Member from Hennepin, Representative Simon, to your amendment.
Thank you, Mr. Speaker. And members, we've been talking here a little bit about why you even have this stuff to begin with. Why do you have something called prejudgment or post-judgment interest? One of the rationales, one of the reasons we haven't talked about, the reason you have it in the first place, is so people who are deemed liable, when you got a jury verdict against you, you pay up. You pay the bill. If we didn't have this kind of thing in our laws, and if all 50 states didn't have them, you'd have someone who gets dinged by a jury for, in this case, in this example, intentional misconduct. That's what we're talking about with the Consumer Fraud Act, someone who intentionally harms consumers. So a jury says they did wrong. They got to pay up because the meter is running. The meter is running on that claim and on that judgment. And so one of the reasons that you have an interest rate at some sort of happy medium, which I would argue that the current law is, it's not too low, it's not as high as some credit cards, it's right where it pretty much ought to be. One of the reasons you do that is you want to make sure that when a jury says that someone did something wrong, they pay. They don't flee, they don't delay, they pay. And the problem with lowering it is intentionally or unintentionally, and Representative Mazorol, I know in your case it's unintentional. I know this isn't why you're carrying the bill, but I fear that unintentionally what will happen here is this just more of an incentive for someone who's gotten dinged by a jury for intentional misconduct, intentionally scamming Minnesota citizens, will now be able to delay just a little bit longer, or wait just a little bit longer, or play around just a little bit longer. And I don't think that's right. I don't think anyone in this room thinks that's right. So members, I urge a yes vote on the amendment as a way to show that this body is on the side of everyday Minnesotans who are done wrong by people intentionally in their everyday transactions.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Will Representative Mazorol yield, please?
He will yield. Representative Atkins.
Representative Mazorol, on it's lines 3.23 and 3.24, you create an exception for judgments and awards upon which interest is entitled to be recovered under Section 60A.0811. Could you explain that, please?
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, that I believe is in fact in the law currently, and was part of the bill that was passed in 2009, or actually I think it was an amendment in 2010.
Member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. And Representative Mazorol, will you yield yet again?
He will yield. Representative Atkins.
With all due respect, my question wasn't when it was passed or how it was passed, is what does it do?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, it excludes breach of contract claims against insurance companies from this particular statute because there's a flat 10% interest rate that applies in those situations.
Member from Dakota, Representative Atkins.
Will you yield again? I just want to make sure that I'm clear on that. Will he yield, please, Mr. Speaker?
He will yield. Representative Atkins.
So you just said that you're exempting out businesses that make claims. They still get the 10% when they go after their insurance companies. They get 10%, but members of the military and elderly folks and disabled people and victims of fraud who are intentionally defrauded, you'd reduce them to 4%. Is that what you're saying, Representative Mazorol?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, no. These are situations in which the insurance company is the judgment creditor, and that in those situations on a breach of insurance contract case, insurance companies need to pay the 10%, not as the claimant, but as the judgment creditor.
Member from Dakota, Representative Atkins.
Members, listen to what Representative Mazorol just said. He said no, and then he proceeded to explain how businesses will get 10%, and elderly victims of intentional fraud and people with disabilities and veterans will get 4%. There is no way that I would ever vote for something like that. That is campaign flyer stuff by my opponent. That is the absolute craziest thing I have ever heard, Representative Mazorol. So you're going to single out businesses that make claims under commercial and professional policies. I just looked it up here. They get 10%, but victims of intentional fraud and the elderly and disabled and veterans, they get 4%. That is absolutely obscene. Vote no.
Member from
Vote
Cotton.
no on the bill. Vote yes for the amendment.
The member from Cottonwood, Representative Hamilton.
Thank you, Mr. Speaker. Would Representative Atkins yield for a question, please?
He will yield. Representative Hamilton.
I'm just an uneducated hog farmer. Could you tell me what percent that the attorneys receive?
The member from Dakota, Representative Atkins.
I wish I understood and thank you for the question, but I don't understand the question.
So, well, Mr. Speaker,
The member from Cottonwood, Representative Hamilton.
Mr. Speaker. I'm sitting here listening to the debate and everything else, and we have heard from many attorneys, and we're talking about frauds and individuals lying in their pockets and stuff like that. And the argument goes on and on and on. And I just want to know about what percentage the individuals are receiving, what percentage the attorneys are receiving on these settlements as well. We hear a lot about that. And I just want to, not saying that there's any fraud or abuse there, but I just want to interject here as well. We're trying to do good work here. We're trying to do work to protect people. We're trying to bring transparency to this and everything else. And I'm being a little, like I said, a little facetious here, and I apologize if I offended anybody. But I'm thinking of potentially some amendments here as well. That's my point.
Further discussion. Member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. I wonder if Representative Atkins would yield to a question, Mr. Speaker.
He will not. Representative, I'm sorry, he did. That was a yes nod. I'm sorry. Representative Lesh, he will yield.
Thank you, Mr. Speaker, and thank you, Representative Atkins, for that quick change of heart. My question for you is, you brought up this Minnesota statute 60A.0811, and Representative Mazorol was trying to explain it. I'm wondering, I think I heard him say that this refers to breach of contract claims with an insurance company. Did you hear that correctly, Representative Atkins?
The member from Dakota, Representative Atkins.
Yeah, Mr. Speaker, thank you, Representative Lesh. That's what I heard too, but the short answer is yes, I believe that's what Representative Mazorol said.
Member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Atkins yield to another question?
He will yield. Representative Lesh.
Thank you, Mr. Speaker. Well, my question, Representative Atkins, is I thought if I got injured and I have an insurance policy that says the insurance company has to pay me money, well, then they pay me money and I don't need a lawyer. Is that right? Is that your understanding, Representative Atkins?
The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Lesh, in a perfect world, that would be how it should occur, yes.
Member from Ramsey, Representative Lesh.
Well, Mr. Speaker, thank you, because I'm kind of confused with Representative Atkins' description of a perfect world, because I can't understand why we would ever need an attorney to have an insurance company pay what a contract says is rightfully mine in the case of any kind of injury that I would sustain when the policy says I should get the money. So maybe as we go through this debate, I'll understand a little bit better about the necessity of why we have trials by jury so that my peers can decide what I'm owed under a contract instead of an insurance company. Thank you, Mr. Speaker.
Further discussion. There is an amendment to the amendment at the desk. The clerk will report the amendment to the amendment.
Dean moving to amend the Simon Amendment to Senate File 530 as follows. The amendment is coded 610.
Call the member from Washington, Representative Dean, to your amendment to the amendment.
Thank you, Mr. Speaker and members. Mr. Speaker, I'd like to make a verbal amendment on line 1.4, delete 50 and insert 100.
Representative Dean offers the following oral amendment. The clerk will report the oral amendment.
Mr. Speaker, point of order. This is an amendment to an amendment. Maybe, I don't know, maybe he can modify it, but I don't think he can amend it.
Representative Dean is allowed to modify his amendment as the author. Representative Dean, do you choose to modify your amendment?
Yes, Mr. Speaker.
The clerk will report the modification to the author's amendment.
Dean is modifying his amendment as follows on line 4, delete $50 and insert $100.
Discussion. Member from Washington, Representative Dean.
Well, thank you, Mr. Speaker and members, and somewhat persuaded by some of the arguments put forward to try to make things a little bit more equitable, and I think a reasonable limitation on attorney's fees would be in order. I thought $50 an hour, and as from my profession and from being out of it for a few years, I've been reminded that it probably needs to be a lot higher than $50 per hour. So I thought I would amend it to $100 per hour to try to put some reasonable limitations on fees with this within the Simon Amendment. I think it makes it significantly better, and I would appreciate the support of the body, and I would ask for a roll call.
Representative Dean requests a roll call amendment. Seeing 15 hands, there will be a roll call on the Dean amendment to the amendment. Discussion to the amendment to the amendment. Seeing no further discussion, the clerk will take the roll on the amendment to the amendment. Members, please vote. Clerk will close the roll. There being 129 ayes and 0 nays, the amendment to the amendment is adopted. We are on the Simon Amendment. Discussion to the Simon Amendment. The member from Hennepin, Representative Simon, to your amended amendment.
Well, thank you, Mr. Speaker and members. I think we've had a good discussion here. This amendment is an invitation, or its intent is to be an invitation to show that we're on the side of everyday people, everyday consumers, where you've got fraudsters, con artists, rip-off artists coming in and intentionally trying to take advantage of our people. I think it's wrong to give them or to give the insurance companies who represent them a break, and we shouldn't. So I urge a yes vote.
Discussion. The member from Washington, Representative Dean, to the Simon Amendment.
Well, thank you, Mr. Speaker. Would Representative Simon yield for a question?
He will yield. Representative Dean.
Thank you, Mr. Speaker. And Representative Simon, could you please explain how your amendment would make Minnesota relative to North Dakota, South Dakota, Iowa, and Wisconsin relative to the exact format of the bill that we have before us? If we were to put your amendment on, and maybe we will, maybe we won't, where would that put Minnesota with relative to those adjoining states?
The member from Hennepin, Representative Simon.
Well, thank you, Mr. Speaker and Majority Leader Dean. It's interesting. The U.S. Chamber of Commerce, just a year or two ago, came out with a study of the lawsuit climate in all 50 states. And while I can't tell you where our neighboring states rank offhand, what I can tell you is that they said, this is the U.S. Chamber of Commerce, hardly a left-wing radical organization, they said that Minnesota has the 10th best business-friendly lawsuit climate, the 10th best in the country. So unless North Dakota, South Dakota, Iowa, Wisconsin are in the top 9, and I don't know if they are or not, we're in pretty good shape. And I don't think we should mess with a bad thing, whether it's with the interest rates prejudgment or with any of the other bills that we're going to hear today. This is not about businesses under siege by lawsuits. Civil filings are down in Minnesota, not up. Across the board, civil filings are down. So it's not about businesses. It's not about some impediment to growth or economic dynamism. It's about insurance companies who don't want to pay. They take in the premiums and they just don't want to pay. That's what it's about.
The member from Washington, Representative Dean.
Well, thank you, Mr. Speaker and members. And unfortunately, this will make Minnesota less competitive with our neighbors directly if we were to put the Simon Amendment on this, unfortunately. And for that, Mr. Speaker, I would ask a no vote on the Simon Amendment and appreciate that from the body. Thank you.
Further discussion, the member from Hennepin, Representative Thiessen.
Thank you, and I guess I won't ask anyone to yield. My question is, how is exempting consumer fraud, this one exemption that Representative Simon is making against fraudsters from this change in the law, how is that going to create any single new job in the state of Minnesota? It's not going to create any single new job. The myth underlying your argument on this bill is incredible. This bill is not going to create any new jobs in Minnesota, and you don't even try to make the case that it's going to. Just by saying, I know you like to believe that just by saying things, they're true. We saw that all year last year. You're doing it again on this bill, saying just because we passed this bill, we're going to create jobs. That's absurd. You just heard Representative Simon make the point. Business litigation climate in Minnesota is near the top of the country, not the opposite. So I don't see, though, specific to this amendment and to the argument Representative Dean was making as you figured out what to do with this amendment, but the argument that Representative Dean made that exempting out fraudsters from these interest rate changes is going to make any difference to create any single new job in the state of Minnesota. You can't make that claim, so please don't stand up in the House floor and do it.
Member from Scott, Representative Biskins, to the amendment.
Well, thank you, Mr. Speaker and members. The Simon amendment has been brought forward as a protection against, and I do believe he said, con artists, rip-off artists, and earlier he even claimed hucksters. And the Dean amendment, of course, put some protections against shyster lawyers, and so I suppose that's probably a good thing also. But understand, members, that what we have here is these are for claims, not for actual judgments. Good practicing business people can have a claim of fraud brought against them. Understand that. These aren't for actual judgments. Anyone can sue for any reason, all right? And unfortunately, good businesses get caught up also, and so I think it's appropriate that we keep that in mind. We err on the side of good business people, because the people of the state of Minnesota, the people of the United States, I believe, are really good folk at heart. All right, and so I would encourage a no vote on the Simon amendment, even as amended.
The member from Hennepin, Representative Thiessen.
Well, just to maybe Representative Mazorol will yield for question. Representative Biskins just argued that this applies to claims and judgments, but in fact, you can't recover any interest until you actually recover a judgment, aren't I right? So Representative Biskins, in his characterization, was incorrect. Am I correct?
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Thiessen, no, I believe Representative Biskins is correct. The idea here is that claims are being made, and interest rate begins to accrue from the time that the claim is made, and certain triggers to begin that interest. But in fact, once judgment is adjudicated and entered, the latter part of the statute kicks in. And it looks like I may not have caught your question, Representative Thiessen, so if that's the case, I apologize.
Member from Hennepin, Representative Thiessen.
Representative Mazurov, have you read your bill? You don't get the interest until you collect a judgment, until a judgment is entered. That's the whole point. And I think I am right on that. I won't ask you to yield about that. So, Representative Biskins, I get your argument. I don't think is correct.
The member from Grant, Representative Westrom.
Mr. Speaker, would the minority leader yield, please?
He will yield. Representative Westrom.
Mr. Speaker, Representative Thiessen, we talked about government getting treated different than the current law. What's your thoughts? Would you support the government having the same rate on these types of claims as the taxpayers of Minnesota?
The member from Hennepin, Representative Thiessen.
Thank you, Mr. Speaker. What I would support is exempting out consumer fraud claims, which is what this amendment is, from getting reduced interest rates.
The member from Grant, Representative Westrom.
Mr. Speaker, if the author of the amendment would yield.
Representative Simon will yield. Representative Westrom.
Mr. Speaker, Representative Simon, what's your thought on that same question? Should we treat government the same as the citizens of the state of Minnesota?
The member from Hennepin, Representative Simon.
Thank you, Mr. Speaker. Mr. Westrom, Representative Westrom, yes, I think when it comes, as Representative Morrow said, when it comes to intentional preying on consumers, absolutely. If that were to happen, I would agree. They should be treated equally. We can have a good faith disagreement, you and I or others, about whether one group's interest rate should be increased or the other should be lower, or they should meet in the middle. But I do think it's probably fair in terms of intentional misconduct that there be no difference. I think that is fair.
The member from Grant, Representative Westrom.
Mr. Speaker, the author of the amendment yield again.
He will yield. Representative Westrom.
Mr. Speaker, Representative Simon, does your amendment treat government and the taxpayers or the citizens of Minnesota the same?
The member from Hennepin, Representative Simon.
Representative Westrom, yes, it does. I don't know of any case, so someone can correct me if I'm wrong, but I don't see any reason why there couldn't be a public defendant in a consumer fraud case. It's certainly possible. I think you and I and others could dream up a hypothetical. But if some government entity, whether it's a city or a township or a county, intentionally defrauds a consumer under the terms of this act, absolutely. The amendment doesn't say one way or another. It just says any defendant under the act. So to the extent that a governmental unit of some kind, it could be a public school, it could be a city, whatever, is intentionally defrauding our people, our constituents, I think they should be on the hook exactly the same as some sort of private defendant.
Member from Grant, Representative Westrom.
Mr. Speaker, Representative Simon, it's my understanding that they would be treated differently just under the different statutes, but is it your understanding that this amendment covers them both the same? Because that's not how I understand it, but I might be wrong, but I'm not positive from your answer that you knew exactly if they're treated the same or would be different. So if you could give us any further clarification on that, that would be helpful. But nonetheless, I think they ought to be treated the same per my conversation or points earlier. And so, members, I would just suggest rather than have a lot of questions on the floor on the different sections of the statute, this didn't come up in our committee hearing, Representative Simons. I wish you would have brought it up then and we could have had a little more time for insight on it, but I'd be concerned that government's being treated differently as one of my concerns on this amendment.
Seeing no further discussion, roll call being requested on the amended amendment. The clerk will take the roll on the amended amendment. The clerk will close the roll. There being 60 ayes and 70 nays, the amended amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Falk moving to amend Senate File 530. The first unofficial engrossment as follows. The amendment is coded 584.
Call the member from Swift, Representative Falk, to your amendment.
Thank you, Mr. Speaker. Members, this is deals with farm equipment dealers, and it's going back to the point that if a dealer is wronged by a manufacturer and it takes time to settle that claim, the dealer should be able to have access to fairer compensation than just getting 4% interest, or it should be back to the 10%. Being that agriculture is such an important part of our state and we have so many small businesses that are agricultural dealers, I really think that this changing could very disproportionately affect a number of small businesses, and we're trying to protect small businesses here. Perhaps if Representative Mazorol would yield to a question.
He will yield, Representative Falk.
Thank you, Mr. Speaker. Representative Mazorol, I come from a rural district, as you maybe know. I believe you're from the metro area. How many farm equipment dealerships do you have in your district?
Member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Falk, I don't know that we have any farm equipment dealers within 41B.
The member from Swift, Representative Falk.
Thank you, Mr. Speaker. Well, Representative Mazorol, I understand that maybe this isn't an issue that you thought of when you put this legislation together, but there's many pieces of agricultural equipment that have values of less than $50,000 that if the dealer, the independent business, the dealer somehow is wronged, whether by the manufacturer, and they're trying to be made whole, and it takes a long process, and there's a lot of consolidation in the manufacturing world, and I think that there's fairly sophisticated large companies, that the small independent business person is not going to have the ability maybe to go and deal with the expensive high-paid attorneys as the big company would have. And so when they are trying to get their just compensation, and this is a long drawn-out process, they may be expending resources at significantly higher than just 4% rate, and that's just not fair. I'd ask, I'm looking for Representative Torkelson. I don't see him here. Would Representative Anderson yield?
Which Representative Anderson? Representative Falk?
Representative Paul Anderson.
He will yield. Representative Falk.
Thank you, Mr. Speaker. Representative Anderson, we both come from farm areas, and I think we've got a fair amount of small businesses that are farm dealerships or farm equipment dealerships in our areas. And this section of law, 325E 065, this was put in during the farm crisis back in the 1980s. And if I wasn't farming then, I was still pretty young, but I think you may have been involved in agriculture. What were the interest rates that farmers were paying back in the 80s, or farm dealer equipment manufacturers? What were some of these rates? Were they, I think they were quite high.
The member from Pope, Representative Anderson.
Thanks, Mr. Chairman. Representative, yes, I was farming back in those days, so I guess I somewhat date myself. And as I recall, I bought a tractor and I paid 18% interest.
The member from Swift, Representative Falk.
Thank you, Mr. Speaker. Representative Anderson, I appreciate the history lesson there. And that's what the farmer's paying, but if the dealership is in some type of disagreement with the manufacturer, and they're no longer able to get credit from the manufacturer, and they have to go out and secure credit at those high rates from whether it's a bank or some other lending institution, they're going backwards very quickly through really no fault of that business of its own. So I do not understand why we would want to put this undue burden on many of our small businesses, specifically in rural areas where we don't have many small businesses that are supporting, if not, I think the most important industry in our state, which is agriculture. I believe it's still the #1 economic driver, and so we want to continue to support those small businesses. And I really do not think that limiting their ability to collect when they are wronged would be fair. I feel so strongly about this, Mr. Speaker, I'd ask for a roll call on the amendment.
Representative Falk requests a roll call. Seeing 15 hands, there will be a roll call on the Falk amendment. Discussion of the Falk amendment. Seeing no further discussion, a roll call being requested, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 70 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Hortman moving to amend Senate File 530. The first unofficial engrossment as follows. The amendment is coded 574.
I call the member from Hennepin, Representative Hortman, to your amendment.
Thank you, Mr. Speaker. Representative Mazorol, my amendment would say that a judge or an arbitrator could disregard the statutory interest rate in cases where there was good cause shown. And I wanted to ask you a few questions about your bill and talk about what I think the application of my amendment would be. First, with regard to your bill, I want to know what is current law that is the problem, And how do we know that's a problem? What cases have come up? What situations show that current law is unfair or anti-competitive or not working? And then what are you changing it to? And what is the evidence we have that what you're changing it to would be better than what we currently have in place? If Representative Mazorol would yield.
Representative Mazorol will yield. The member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Hortman. Under the current law, we've got a pre-judgment interest rate for judgments over $50,000 that is at the 10% rate, far above what the market rate is. At that point, the case hasn't been finally adjudicated and entered, and the idea of this legislation or of this bill is to, again, just hold the parties equal to the value of their original claim until such time as there's a final adjudication. Once there's that final adjudication and entry of judgment, then we move to a one-year Treasury bill up to $50,000 or 10% over $50,000. The reason for the 10% over $50,000 is for those larger judgments, you're getting into a situation where you do want to have a more immediate payment on that final judgment by the party that has already been adjudicated to be at fault, owing that money and having that judgment entered. Up until that time, there is still litigation adjudication pending.
The member from Hennepin, Representative Hortman.
Thank you, Mr. Speaker. Representative Mazorol, if a case goes to trial and there's a finding that the defendant is guilty or has committed wrongdoing, haven't they committed wrongdoing for the entire time? It's not like the wrongdoing starts the date of the judgment. Hasn't the wrong existed at all times? It's just now the court has figured it out and issued a ruling. So I guess what I'm asking is, why should there be a different rate of interest for pre-judgment than post-judgment? If somebody's wrong, aren't they wrong the whole time? If he'll yield.
He will yield. Representative Mazorol.
Mr. Speaker, Representative Hortman, what the bill does is it maintains the same value. You're correct. You know, at some point they're adjudicated to have wronged someone, and at that point, this statute isn't intended to punish them for having been wrong. That happens within the case itself and within the damages awarded. This statute is only intended to maintain the value at that time as it may have been at the time that the claim was first made, so that it doesn't diminish in value by the time value of money.
The member from Hennepin, Representative Hortman.
Okay, thank you, Mr. Speaker. Well, to see if I understand, I'd like to try to use a really simple example. Say there's a veteran and he applies for a new job and he goes all the way through the interview process and he is offered the job. And the day before he's going to take the job, the boss at the new company says to his hiring coordinator, "Oh, this guy's a veteran? Well, I don't want to hire him because he might get called up and have to go to Iraq or Afghanistan. And so, you know, tell him, no deal, sorry." Well, say the veteran's already quit his other job, so now he has no income. And say he litigates for 2 years, and after 2 years of discovery and dealing with a lawyer and going to court, finally he wins. Let's say, just for the simple math, let's say during that 2-year period he's out $100,000. Let's say he would have been paid $50,000 a year at the new job. If he gets a judgment, shouldn't he get interest for the whole time he's been fighting in court to get fairness for the job that he really should have gotten that was unfairly taken from him? Shouldn't he get judgment, a rate of interest for the entire time that's the same before the judgment's entered and after the judgment's entered? If Representative Mazorol will yield.
He will yield. The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Hortman, he will get interest. The amount of the interest will be that which maintains the value of that claim. The reason that the interest rate goes up after judgment has been fully adjudicated and entered is only to expedite payment, final payment of that amount. Up until that time, the prejudgment interest statute is about maintaining a single value. Again, after adjudication and entry, you switch into a mode where for larger judgments at least, you do want to encourage expedited payment.
The member from Hennepin, Representative Portman.
Thank you, Mr. Speaker. Representative Mazorol, I'm a little confused by what you said. So you're saying that the same rate of interest would apply, but under the bill, I thought the pre-judgment rate of interest is 4% and the post-judgment rate of interest is 10%. So say this veteran has been living on credit cards and he's been paying 14%. Let's say he has a really good credit card and he's paying 14% interest or 8% interest the whole time. Doesn't he just, under your bill, isn't he only entitled to 10% interest for the time period after the judgment is entered and not that entire 2-year period where he was charging his groceries and his gas on his credit card bill?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Hortman, that's correct. Under this bill, that's what he would be entitled to collect.
The member from Hennepin, Representative Pepin, for what purpose do you rise?
Mr. Speaker, a point of personal privilege.
State your point of personal privilege, Representative Pepin.
Well, I just rise to announce that our own Representative Glenn Gruenhagen is having a marquee birthday today, and his family has brought some treats in the back when members get an opportunity to go and have them. So please join me in in wishing Representative Gruenhagen a happy birthday.
The member from Sibley, Representative Gruenhagen.
Thank you, Mr. Speaker, members. I've turned 39 for the 21st time, so I think that puts me at 60. All right. Second thing is, my daughter brought 2 cakes in the back, and they're in the spirit of compromise. One cake is bipartisan, the other cake is nonpartisan. So you're welcome to either one, and hopefully it'll temper the debate here on the floor today. Thank you.
Thank you, Representative Gruenhagen and Pepin. Representative Hortman, you have the floor.
Thank you, Mr. Speaker. So if we're interested in being both bipartisan and nonpartisan, we can have 2 pieces of cake. Mr. Speaker, I think Representative Mazorol has answered the question that I was after, which is I think that a plaintiff in the case of the veteran that I described, who's unfairly been had a job offer rescinded because the boss doesn't want to deal with the uncertainty that he might go to Iraq or Afghanistan, I think that that veteran should be entitled to the 10% interest for the time before he won and for the time after he won. And I think it's such an important issue, Mr. Speaker, I would like a roll call on my amendment.
Representative Hortman requests a roll call. Seeing 15 hands, there will be a roll call on the Hortman amendment. Discussion to the Hortman amendment. Seeing no further discussion, a roll call being requested, the clerk will take the roll on the amendment. The clerk will close the roll. There being 59 ayes and 71 nays, the amendment is not adopted. There's an amendment that asks the clerk will report the next amendment.
Purcell moving to amend Senate File 530, the first on official engrossment as follows. The amendment is coded 588.
Call the member from Beltrami, Representative Purcell, to your amendment.
Thank you, Mr. Speaker. I request a roll call on this amendment.
Representative Purcell requests a roll call on the amendment. Seeing 15 hands, there will be a roll call on the amendment. Member from Beltrami, Representative Purcell.
Thank you, Mr. Speaker. Members, this kind of takes off on some of the things that Representative Hortman was talking about in her amendment, looking to basically keep the interest rates that we're talking about here, prejudgment interest rates, in place for several purposes that would be applicable to military service personnel, and there would be the sections 325G.54, 325G.55 refer specifically to .54 is wireless contracts by military personnel, and .55 is club service member travel contracts by military personnel. So this is some pretty specific stuff to military folks. And you know, this comes from actually a case, I don't know, with a real live example. No names here, but a sergeant that was deployed to Iraq and had a cell phone contract, and he canceled that contract, or he thought he did. And it just so happens that his wife kept getting calls from the cell phone company that he owed money. And she didn't really know what to do, argued with him a little bit. You know how it is when we get these bills and somebody on the other end is trying to tell you owe money. And so this went on for some months, and she didn't know what to do, so she paid. Ended up, she had about $1,000 that she'd paid into this thing, and then finally the cell phone company called and said, "Hey, we're sorry, it was our mistake. Hope you have a good day." Well, then her husband gets back and they decide they're going to go after this, try and get that money back. And so they do. They go after this $1,000. And so the way as I understand the Mazorol bill here, they'd only be able to get $40 on that $1,000 prejudgment as far as interest goes, instead of the current law would be 10% at $100. And first of all, I think that's egregiously wrong. And secondly, if this individual had paid this on a credit card bill, and the credit card interest is going to be 15, 18, 20%, you know, we're putting this this sergeant and his wife in kind of a hole here, and that's not right. I've done quite a bit of work around my district and others with this Beyond the Yellow Ribbon. I think it's good stuff. We're bringing veterans back. They're coming back in big numbers here now. Some of them are going to have issues like this. I think it's a far cry from a welcome back to say, oh, hey, by the way, we just cut back on how much interest you're going to be able to get on any prejudgment court costs that you have. You know, that's like a slap in the face. There's a lot of things to go along with going in the military and going somewhere and coming back. And, you know, I don't know what the sergeant's pay is now, but I can tell you what it was 40 years ago. It wasn't very dang much. So I think we need to look out for our military personnel. I've heard everybody in this room say that. Thank you for your service. That's a good thing to say. Well, let's don't say thank you for your service, bam, and slap them in the face, okay? Please support my amendment.
Discussion to the amendment. A member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker, and thank you, Representative Purcell, for raising an amendment that recognizes the high regard with which we hold our military personnel. I speak against this amendment. And the reason I do is because this bill, again, is about maintaining the value of the claim during the pendency of adjudication. And the integrity of that process, I think, says that until the claim is finally adjudicated, we don't have an adjudication. And once the claim is entered, then we can move into a higher interest rate. But for all persons, this is just maintaining the value of the claim from the time it is first brought. And some of those, I think we need to keep in mind, some of the defendants in these cases are going to be consumers as well. This isn't all about business. This is about lawsuits, generally, in which money damages are claimed.
Member from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. And members, you might not know very much about the statute that Representative Purcell is referencing. I've now served here long enough, too long for some, I'm sure, to have passed a bill and now see that same bill subject to amendment by a new majority. So I guess that's a coming of age of sorts. But members, this law was passed in 2007, and it's based on a gap in federal law. In federal law, starting in 1940, there was a law called the Soldiers and Sailors Civil Relief Act, which attempted to deal with exactly what Representative Purcell was talking about. When members of the military are posted overseas, they shouldn't be stuck with the kinds of court actions or contracts and so on that they can no longer live up to, and so they're given some relief. In Minnesota, we realized that there were a number of contracts that the federal law didn't address, despite the fact that Congress actually rewrote and expanded the law in 2003. So in 2003, Congress expanded a law from 1940 to protect service members. In 2007, Minnesota further expanded that to include wireless contracts, rental clubs, service memberships, travel contracts, the kind of things that sailors and soldiers and service members generally are stuck paying when they're posted overseas. So we protected them in 2007. Governor Pawlenty signed that into law. It wasn't controversial in the least. I'd be surprised if there was a single no vote in the legislature on that bill. But what we're doing now is with the Mazorol amendment is changing the interest that those members are going to be paying if they're stuck paying for a contract they're not supposed to be paying. Keep in mind, they're not supposed to have to pay for it. They're supposed to be able to get out of it. If there are businesses that won't agree to it, and if you talk to service members, they will tell you that the law exists, but compliance with the law is far from perfect. And there's a lot of bureaucratic headaches and nightmares that they spend trying to deal with cell phone companies and other companies in trying to get these payments resolved, to get their obligation released as they're serving the country. So what this bill does is say that those soldiers who are having a dispute with the cell phone company about a bill they're not supposed to be paying are stuck with the difference in interest between what the money they have to pay for it and what the law says. They're being hit by this. Representative Purcell isn't doing anything to hurt the law or to hurt the bill that Representative Mazorol is proposing. Again, if you look at the list of people who are supporting this legislation, from the NFIB and the Minnesotans for lawsuit reform, all those businesses, I'm going to guess, are probably trying to honor their obligation, their legal obligation to let members of the military out of contracts when they're posted overseas. I bet those businesses are all trying to do the right thing. Yeah. So why would we be unwilling to exempt those service members from this law? We are weakening the protection that Minnesota passed in 2007, and I would strongly urge a green vote on the Purcell amendment.
Discussion to the amendment. Seeing no further discussion, a roll call being requested, the clerk will take the roll on the Purcell amendment. The clerk will close the roll. There being 63 ayes and 67 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Atkins moving to amend Senate File 530, the unofficial engrossment as follows. The amendment is coded 605.
Calling the member from Dakota, Representative Atkins, to your amendment.
Good afternoon, Mr. Speaker. I've tried to sit quietly by for a little while, but in listening to the debate and listening to what Representative Mazorol has to say about his bill, what this gets at is for only in those situations where the person, the victim, the fraud victim, the elderly person that's been taken advantage of, the veteran like Representative Purcell tried to protect, only where they prevail. And only, it's a very specific amendment, only where they prevail against the defendant and only where they have had to go out and get high interest loans or higher interest loans would they be able to avail themselves of getting that level of interest. So for example, if you got somebody that's had huge medical bills and they had to go out and literally put them on their credit card, or they had to take out loans at 10% or 11%, or if it's on your credit card 22%, only then would they be able to collect that rate of interest. And I would note parenthetically, Representative Purcell, I didn't get up and speak, but I just found any number of cases. Minnesota National Guard, if you go online, folks, they talk about all kinds of horrific situations where people have been deployed. Sergeant Johnson from Lakeville, whose wife Deborah was home when he was deployed, a debt collector was calling her a scumbag for not paying her bills. They threatened to put liens on their home. This is the sort of thing that we're talking about. So this is, my amendment is crafted very narrowly. It's only where they've actually incurred a greater interest rate and only where they have prevailed. And with that, I would ask for a roll call, Mr. Speaker.
Representative Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the Atkins amendment. Discussion to the Atkins amendment. The member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative, I think, again, the intent of this bill is to maintain the value of that claim during the pendency of litigation. It's not intended to be another source of damages to be awarded a claimant. And I believe that the interest rate that's proposed here, the one-year Treasury bill through prejudgment 4% floor, accomplishes that purpose.
Discussion. The member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. Then a question, Representative Mazorol. You're locked in, buddy. You are an absolute no on protecting veterans and intentional fraud victims and disabled people. I get that. Can you tell me what are those people supposed to do? Representative Purcell just talked about a veteran who's got the person puts it on their credit card. They are paying out. Let's say they've paid out $1,000 plus interest. They prevail against somebody that took advantage of them, maybe intentionally took advantage of them. Should they just eat that? Or is there something in your bill somewhere in your heart perhaps, that would allow them to still collect what they're actually out? Not anything extra, just what they're out. Representative Erickson, you just gave me this crazy-eyed look. Like, what are you talking about, Representative Atkins? What I'm talking about, Representative Mazorol, is if in fact you got $14,000 in medical bills and you had to put it on your credit card and you make the claim and you recover $14,000, but you owe your credit card company another $2,600. Is there any place, Representative Mazorol, where you can get that $2,600 where it actually came out of your pocket? You prevailed against the party that hurt you. Are you able to get that somehow, any way, under your bill? And will you yield, Representative Mazorol?
He will yield. Representative from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, no, under this bill, that's not available because this bill is intended to maintain the time value of money. I would anticipate that if you feel that this should be a cause of action that's available, that we might see a bill coming from you that would allow that sort of cause of action as damages in a case.
The member from Dakota, Representative Atkins.
Representative Mazorol, that is one of the most heartless, harmful things I've ever heard. So if somebody literally incurs that, it's out of pocket. It's not an attorney fee. It's not anything extra. It's not pain and suffering. It's not non-economic damages. It's not all the things that Alec and your folks talk about in your tort reform boot camps. If it's just something that they're literally out of pocket, they had to go get a loan, you won't let them get that back. I'm ashamed of this bill. This is an obscenity. It's an insult to the people that have been intentionally hurt. It's an insult to the veterans that Representative Purcell expected to protect. I'm just shocked that anybody would vote against that sort of amendment. And with that, I'd ask that you vote green on this amendment and you vote red against this bill when it eventually comes up for a vote.
The member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Would Representative Atkins yield for a question?
He will yield. Representative Wardlow.
Representative Atkins, thank you, Mr. Speaker. Representative Atkins, I'm just trying to understand your amendment here. Could you tell me what charges related to a judgment award are? What you mean by that? In particular, related to? How close of a nexus do we need there?
The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Wardlow, I'm so glad that you asked that question. It's got to be an absolute, strong, direct, close nexus. It's the interest rate that you paid if you had to have a medical bill that you had surgery and you're out $14,000 and you went and you took out a loan so that you could pay that medical bill. It's that interest that we're talking about. If it's that veteran that Representative Purcell talked about that's had to put a health club membership or whatever the contract is, or a cell phone contract that they've continued to pay on their credit card, it's that interest. It's whatever interest rate that they paid in order to then pay for that bill that's in question. Thank you for the question, by the way.
The member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Thank you, Representative Atkins, for that question. So it sounds to me like with a nexus that close, these charges related to the judgment award are actually charges related to the fraud or whatever we're talking about, the underlying bad act. So a prevailing party would be able to recover these as consequential damages as part of the award. This is something that should be handled in the context of damages, consequential damages. Perhaps there is a bill that needs to be brought forward on this, but it certainly does not belong in the prejudgment interest rate bill that we're talking about here or statute.
Further discussion, the member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Will Representative Wardlow yield?
He will yield. Representative Atkins.
What the hell are you talking about? In all seriousness,
Representative Atkins.
You just said, and I apologize for using the word, what the heck are you talking about? You just said that those are consequential damages, that they can somehow already be collected? No practicing lawyer in Minnesota would ever tell you that you can collect if you had to put a medical bill on a credit card. It absolutely is not something that you can make a claim for right now, Representative Wardlow. And to even insinuate that you could is betraying the trust of this body and leading them astray. The fact is that you can't do that. That's why it's so important to be able to at least get a reasonable rate of interest if you've had to go out and take a loan to pay your medical bills, or if you've been defrauded as a veteran and you put that on your credit card. You've got to be able to at least get your out-of-pocket that you've paid out. So thank you very much for pointing that out.
Representative Atkins.
I'll withdraw my question.
And Representative Atkins, Representative Kahn is not on the floor, so we'll just have a friendly reminder to watch our language here on the House floor. Discussion to the Atkins amendment. The member from Grant, Representative Westrom.
Mr. Speaker, would the author of the amendment yield?
He will yield. Representative Westrom.
Representative Atkins, clarify. So it's going to award the interest that somebody has to pay. Am I understanding that right? I don't see where it's capped at any level. It's just whatever they find was paid. Is that correct, or can you refresh my interpretation of that? Your amendment.
Member from Dakota, Representative Atkins.
Sure. Thank you, Mr. Speaker, and thank you for the question, Representative Westrom. You're exactly right. It would be exactly not 1 penny more, not 1 penny less. It would be exactly the amount that they paid out in interest on whatever the bill was that's in question. Very good question that you asked.
Member from Grant, Representative Westrom.
Mr. Speaker, if the member would continue to yield.
He will yield. Representative Westrom.
So, Mr. Speaker, Representative Atkins, explain to us a little about how you're going to administer this amendment. somebody's going to have to prove they paid 8.375% interest, and then that would become the new interest, or 11.7 or 875 or 19.95 or any of those interests. How are we going to manage this unwieldy way of trying to prove or disprove what somebody had to pay? And then do we charge interest on interest at the same rate? Explain to us a little bit of how unwieldy this might be, and how you have it conceived to make this flow easily for the courts.
The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. And Representative Westrom, if you'd like it referred back to your committee so you could explore this unwieldy possibility, I'm sure we could accommodate. In seriousness, I don't think it's terribly unwieldy at all. You get this thing in the and I want to be a smart aleck about it. But if you took it out, the $14,000, and you put it on your credit card, you would bring your credit card receipts. I'm not suggesting anybody should just take your word for it, or my word for it, or anybody's word for it. You bring in the receipt that shows how much you put on the credit card, what it was for. Judges go through this stuff all the time, so do juries, where they would look at and see what's attributable to what, and then they would have to decide if that's a reasonable thing to do or not.
Member from Grant, Representative Westrom.
Mr. Speaker, Representative Atkins, that sounded sort of like a broad brush approach, but let's dissect it a little further. Somebody charges up $14,000 on their credit card. That's probably not in one transaction. It might be $3 at Caribou Coffee. It might be $52 for filling gas. It might be $6 to get lunch. All these costs of living that they're having to charge up for whatever the reason is, and that expense or that reason they've had to charge is because of this injury or this loss that they've incurred. But Representative Atkins, from your own answer, just think about how unwieldy it would be to go through somebody's credit card and mark which ones are expenses and interest that they have to pay because of their loss or damages, and which one are for their own pure entertainment. They wanted to go to TGIFs on Friday night and meet some friends and had a few bumps. Representative Atkins, that appears to me to be pretty unwieldy to figure out and ask the courts and ask both sides to go through and dissect every last charge on a credit card. I think our current system recognizes that, and that's probably why it's at 10% or a flat rate. We don't even allow the difference right now, and so I just think your amendment would be very tough to implement, very time-consuming for the courts. And Mr. Speaker, members, I would almost suggest this could have a fiscal note if we add it to the bill, because anybody that thinks about it, in the time to review that, you're going to have to get accountants involved, Representative Atkins, to really dissect these charges and then figure out what they were for. And so, Representative Atkins, I think maybe on its face it sounds kind of nice, but as you know, we also have to find ways to have an efficient system, and a flat rate is typically one way we do that, and everybody gets treated kind of the same. If they paid 11% interest or 8% interest or 3% interest, there's just kind of this group that some are going to win a little more, some are going to lose a little more, but I think we've got to at least stick to a process that isn't so unwieldy to have everybody in this category bring in their $3 Caribou Coffee charges and see if that's a relevant charge and if interest should be paid on that or not. And so I think you've got problems with your amendment, of course. On the fly, on the floor here, that's understandable. And if I can go back to your question, well, I'll just leave that alone. Your comment to the body, I was going to respond to Representative Atkins, but upon further review, it's probably better I keep that in my own head.
A member from Nicollet, Representative Morrow.
Well, thank you, Mr. Speaker. Mr. Speaker, would Representative Wardlow yield to a question?
He will yield. Representative Morrow.
Representative Wardlow, I want to make sure I understood your statement. Are you telling this chamber that interest that a plaintiff pays on a credit card to cover their losses is part of actual damages?
Member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Thank you very much for that question, Representative Morrow. That's not what I was intending to convey. Representative Morrow, Representative Atkins, what I was saying is that, and Representative Westrom's comments actually explained the point I was trying to make a little better than I did, but I think what we're talking about here in your amendment, Representative Atkins, is something that is more akin to consequential damages, and if you want to make a change in law with respect to that and have a hearing process or something to determine that, that should be a bill that should be brought forward and go through the committee process, and we shouldn't make that kind of change, which I think respects something closer to damages in the award than it does the prejudgment interest rate statute, which gives one rate to all and applies across the board. That's something, it's a separate bill that should not, we shouldn't just do that from the hip on the floor here. That was my point. It respects consequential damages. Thank you.
Member of Nicollet, Representative Morrow.
Well, thank you, Mr. Speaker. And Representative Wardlow, if I understood what you said earlier, you were acknowledging at least the possibility that the interest payments a plaintiff makes might conceivably be part of the damages that a plaintiff suffers. That they suffer $14,000 in medical bills, they put it on a credit card, they pay $2,600 in interest on that credit card until they get a judgment. Do I understand correctly if you, would Representative Wardlow yield?
He will yield. Representative Morrow.
Representative Wardlow, if I want to make sure I'm understanding correctly that in your suggestion maybe this should go through a committee process, is that actually the credit card charges that someone pays, an injured plaintiff pays, might actually be part of the consequential damages. I'm not asking you to agree. I know that you probably want to hear the bill. I'm not even going to ask you the question. What I'm going to tell you, members, is that what Representative Wardlow was saying was that, yeah, the credit card charges that someone might pay because they have lost, because they were intentionally defrauded, might actually be part of the loss that a plaintiff suffers. But under this bill, we're going to cap it down to 4% interest on the judgment. Representative Atkins, you're right on the right path. Just make that part of the damages. Now, I know there's a suggestion, well, I'll go through the committee process, Representative Atkins, but the problem here is that the bill is changing the interest rate. So maybe this bill should go back to committee along with your idea, Representative Atkins, and we should have the full discussion on what we do on prejudgment interest when people are intentionally hurt, when they're a veteran, when they're disabled, when they're a farmer. Representative Atkins, I wonder if the motion shouldn't be that this bill should go back to committee, as Representative Wardlow is suggesting, so we could have a full discussion of all these options.
Discussion to the Atkins amendment. Further discussion. Member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. And perhaps I'll be the final word. I'd never want to foreclose anybody from talking, but I do take a little umbrage at Representative Westrom's making fun of this. We're not talking, these are people that have huge amounts that they have had to borrow. They're getting calls from collectors. They're being called, in the case of some of our military veterans, they're being called scumbags. They're being threatened with mortgages being placed on their homes. This is not money that they are trying to bloom into some larger amount than what they're actually owed. Representative Erickson gave me this funny look earlier. This isn't anything that they're not out of pocket. Even Representative Wardlow granted us the fact that this is consequential. These charges, these loans, these interest rates flow directly from that medical bill that's been paid or from that fraud that caused you to go into debt. We're not talking, Representative Westrom, about a couple of bumps at a bar. We're not talking, Representative Westrom, about some coffee. My credit card statement comes just like these poor people's credit card statement comes, and it's got an itemization on it, and it shows how much they paid for the surgery at St. Croix Orthopedic, and it shows how much they paid for the treatment, the physical therapy that they got following that. That's what we're talking about, not a couple of bumps. Representative Westrom. This is out of pocket. These are real dollars. This is no more and no less, Representative Mazorol, than exactly what they had to pay. And the amendment only kicks in if they prevail. Only if they prevail. It's as common sense as you get, folks. Vote yes.
Seeing no further discussion, a roll call being requested on the amendment. The clerk will take the roll on the amendment. Clerk will close the roll. There being 60 ayes and 70 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Falk moving to amend Senate File 350, the unofficial engrossment as follows. The amendment is coded 580.
Call the member from Swift, Representative Falk, to your amendment.
Oh, thank you, Mr. Speaker. Members, this is a simple amendment. I mean, we've already thrown all kinds of, groups, people, individuals, farm equipment dealers, veterans, everybody else under the bus by saying that they shouldn't get fair compensation and they shouldn't be able to be entitled to the fair rate of interest. But I know that there's been a strong mentality in this body to protect small businesses, and so this amendment would simply go and award any small business that, once again, is successful in a claim that higher rate of interest. So for businesses with less than 100 employees, I think this is very relevant, specifically when many of our small businesses have had to go through some very tough economic times, and if they have been harmed by an action that a court has found to be wrongful, committed by some other entity, they should be entitled to that just compensation. I guess, Mr. Speaker, would Representative Mazorol yield for a question?
He will yield. Representative Falk.
Thank you, Mr. Speaker. Representative Mazorol, a question for you. Has a small business ever been harmed, a small business less than 100 employees, ever been harmed by a financial institution?
The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Falk, I don't know the answer to that question. I don't have firsthand knowledge of that.
Member from Swift, Representative Falk.
Thank you, Mr. Speaker. Representative Mazorol, I'd be willing to bet that it's quite likely that there have been small businesses harmed by financial institutions. I mean, we had a financial meltdown that happened in 2008. I think a lot of small businesses were impacted. So my question is if I'm a small business owner and the entity that wronged me was, say, Lehman Brothers or other large institution that went bankrupt or committed some type of serious securities fraud, as some of these large companies are being investigated for now, and they are the one that provides me with my lending, they may be charging me a very high rate of interest, and until I am able to proceed with that case and to prove that I was wronged, which this is still ongoing, they're going to be asking me to continue to pay a higher rate of interest. But when I am found to have been wronged and asked to be made right, I can only be made right at less than a rate that my lending institution, a large bank, is going to be asking me to pay. How is that fair? I'm just perplexed. And I think it was stated once before, but this idea of the market rate of interest, that's not the cost to my business. I'm investing capital and resources to earn a return on that, hopefully in excess of what the bare minimum I can earn from, Treasury bills or the risk-free rate. So I'm not being treated fairly. I'm being asked to take out of my own business's pockets to go and be made whole. I don't understand this. I mean, in light of all of the all of the absurd policy that's being pushed here, that's been highlighted by so many people, at least with seemingly the will of the body here to try to help small businesses out. We keep talking about Reform 2.0 and improving the job climate. let's at least not kick some small business that's been hurt even harder. Let's not kick them when they're down. I mean, they're having to go through a very tough situation, fighting for their right to be made whole by somebody that's willfully and intentionally wronged them. Excuse me, why would you want to further kick them when they're down? Mr. Speaker, this is such an important thing that I have to ask for a roll call vote.
Representative Falk requests a roll call. Seeing 15 hands, there will be a roll call on the Falk amendment. Discussion. Discussion to the Falk amendment. The member from Carver, Representative Hoppy, to the Falk amendment.
Thank you, Mr. Speaker. Mr. Speaker, members, and Representative Falk. Last year and since then, but last year specifically, we went and took a tour of the state, and we went and visited small and medium-sized and a few large businesses around the state in different geographic areas. During that trip, or trips actually, and since then, as the chair of the Commerce Committee, the number one thing I hear from small businesses and medium-sized businesses in every part of our state is get us tort reform. If you want to help small businesses, reject this amendment, vote yes on this bill.
Discussion. The member from Hennepin, Representative Thiessen.
Mr. Speaker, I'm just a little surprised that Representative Hoppy said he heard get us tort reform as the number one thing here from businesses. Coming from your side of the aisle, I'm surprised it's not lower our taxes, because that, I imagine, would be what we would first hear coming out of your mouth. But maybe they want all this stuff. To me, the most important thing, and the reason why these bills are so bad, is that what we ought to be focusing is on getting people back to work. And instead, you're spending your time on bills that have nothing to do with getting people back to work in Minnesota. No jobs bill has moved in any committee in any part in the House of Representatives since we started this session. We're supposed to come into this session talking about jobs, jobs, jobs. Let's get people back to work. No progress has been made on doing that at all, and instead you spend your time on bills like this that no one is making any claim is actually going to get anybody back to work. Representative Falk is trying to do something here to actually help some small businesses so that they can actually sustain themselves when they're suing a big corporation who's holding out and trying to crush them in litigation. That's what his amendment is all about, and that's what big corporations and insurance companies do. So I think that if you really want to get to what's going to help small businesses, you ought to be voting for Representative Falk's bill. And then let's move on from these things. Maybe we could adjourn today and we could get some task force together to talk about what jobs bills we might be moving when we come back from our precinct caucus vacation.
The member from Carver, Representative Hoppy.
Thank you, Mr. Speaker, and thank you, Representative Thiessen. I agree, tax reform is important. But tax reform, while it's important to small businesses, and I think everybody wants to see lower taxes, people don't want to see no government, but they want to see us and every level of government treat their money fairly and respectfully and do a good job with the money that we give them through taxes. But the reason I think that we didn't hear taxes as number one is people were already assuming that the legislature understood that their taxes are too high in the state of Minnesota. Every place in the state that we went, from small and medium businesses, they said get rid of duplicative rules, streamline regulation, but the number one thing we heard everywhere is tort reform.
Member from Swift, Representative Falk.
Thank you, Mr. Speaker. I guess, Representative Hoppy, I wasn't along on your tour of small businesses. I don't think you invited me, but that's all right. The thing I'm wondering about is, did you talk to any small businesses that are going through litigation? Or maybe we could talk to some of our farm cooperatives or some of our other entities, because they're trying to get their money back from a company that went bankrupt that the regulator said was great and fine and they had insurance and everything else there. Maybe you heard of MF Global. But we're going to say that they're going to have to go through that long, drawn-out process, and they're not going to be able to be made whole at anything more for that time value of money at 4%. Excuse me, that's not fair.
Further discussion. The member from Ramsey, Representative Mahoney.
Thank you, Mr. Speaker and members. I was partaking in the birthday cake back there, and I heard someone talk about the fact that they went around to small businesses and all they heard was tort reform, tort reform, tort reform. My colleague on the other side of the aisle, the chairman of the committee I sit on, Mr. Gunther, knows that I do spend a lot of time going around to small businesses. I'm a bit of a labor thug, but I do understand that Minnesota needs businesses. You know what I heard? I heard workforce training. I heard job skill gap. I did hear regulations, so I'll give you that one. I heard financing. I heard figuring out how to do bridge loans with banks. But I did not hear one. I did not hear one of them bring up tort reform. I heard workforce training, educational costs, loans, no tort reform.
See, the member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Would Chairman Hoppe yield?
He will yield. Representative Atkins.
Thank you. And Chairman Hoppe, how does this bill accomplish what you're talking about? What does this do relative to tort reform, this particular bill, that would be beneficial to the businesses it's shocked to?
Member from Carver, Representative Hoppe.
Thank you, Mr. Speaker, Representative Atkins, and members. I think when, in general, we're looking at this bill and the bills that we're hearing today, I think that businesses want to see a greater, we've talked about different things, and Representative Mahoney and others, and they want to see a better regulatory environment in terms of tort reform. I think that this bill is one of a package of things that small businesses and other businesses are looking for, that they feel is going to make this a better environment to do business in the state of Minnesota.
Member from Dakota, Representative Atkins.
And would Representative Hoppe continue to yield?
He will yield. Representative Atkins.
I apologize. I just didn't track. What does this bill specifically do to aid small businesses in job creation, that kind of thing? You talked about the package of bills, and I understand, but this specific bill, what does it actually do for businesses?
The member from Carver, Representative Hoppe.
Thank you, Mr. Speaker, and Representative Atkins. You know, I think this bill and the other bills that we're looking at today, when these bills pass, I think what they do for businesses is they give them a signal that we're paying attention and we're listening to the things that they tell us, and we're doing what we can to help them operate businesses better, their businesses better in our state of Minnesota.
Member from Dakota, Representative Atkins.
And one final question, please, Representative Hoppe.
He will yield. Representative Atkins.
Relative to that specific comment, where does Minnesota rank relative to our litigation climate? Are we one of the worst? Are we one of the best? Where are we in that grand scheme of things?
The member from Carver, Representative Hoppe.
Thank you, Mr. Speaker, and Representative Atkins. I don't know specifically where Minnesota rates in relation to the climate for the workforce lawsuits. Representative Atkins, I would suppose that you know, because generally you don't ask questions you don't know the answer to. But I think, again, wherever we rate, when we look at these bills or tax bills or anything else that we can do to help businesses, all of the things that we like to come here and spend money on, and all of the things that we do in state government are made possible by people that have jobs, own businesses, and employ people. And all those people, the business owners and the employees, pay taxes so we can do all the things that we want to do. And I think whether we're first or 49th or 50th or 23rd, whatever the number is, I think these bills send a signal to people that we're moving in the right direction.
The member from Dakota, Representative Atkins.
And thank you, Mr. Speaker. And that actually leads to my next amendment, because this bill does nothing for businesses, and that's why you can't get an answer from anybody about how does it help business. It doesn't do a darn thing. And as far as the rankings go, we're having them passed out. The U.S. Chamber of Commerce report shows that Minnesota has the 11th best litigation climate in the country. The 11th best. We don't have a crisis. The number of claims in Minnesota are down. Personal injury claims are down 20+%. Death claims are down. Medical malpractice claims are down. Everything is down. There is no crisis. All this is a grab for the insurance companies to get a whole bunch more of people's money and not give any of it back as a reduction in premiums. I asked earlier for a 16% reduction. Every time we've done these sorts of reforms for 40 years, folks, we've built in a reduction that goes to the insured, the actual person. When it was auto insurance, it was 30%. When it was work comp insurance, it was a minimum of 16%. Representative Mazorol wouldn't agree to 16%, which is the lowest ever given. I'll have an amendment that comes up next that would require just a 1%, Mr. Speaker, a 1% reduction. And we'll see if we can get at least a vote for a 1% reduction. If we're going to do all this stuff and we're going to stick it to veterans and the elderly and people who've been defrauded intentionally, then the people that pay insurance premiums ought to at least get a 1% reduction. Thank you.
The member from Swift, Representative Falk.
Thank you, Mr. Speaker. Representative Atkins, I was going to help you understand something. My amendment, which is the one we're speaking about here, would help small businesses by making sure that they are treated fairly when they are wronged. But as you did allude to, this does actually help one group of businesses. It helps very profitable large insurance companies. And so I wanted to make that aware to the body that when you vote against this amendment, you're voting against small businesses in favor of large insurance companies.
Representative from Hennepin, Representative Winkler. Members, there is an amendment to the amendment at the desk. Friendly reminder, as we are early in session, if you're going to have amendments either for the bill or to the amendments, to have them at the desk prior to the amendment coming up or for the bill coming up in order to be fair to the front desk staff. As we wait for the amendment to be collected, or excuse me, to be printed and then distributed, we will take a brief pause.
Mr. Speaker.
The member from Swift, Representative Falk. For what purpose do you rise?
Being this is on my amendment, I was just hoping I could get a copy so I could actually see what I'm talking about, so thank you.
Representative Falk will treat all members on the House floor equally. As soon as the amendment is distributed to each member, we will not take the amendment up, so he'll have plenty of time to go through the amendment.
Oh.
I believe all members now have the amendment to the amendment. The clerk will report the amendment to the amendment.
Drazkowski moving to amend the Falk Amendment as follows. The amendment is coded 320.
Calling the member from Wabasha, Representative Drazkowski, to your amendment to the amendment.
Thank you, Mr. Speaker. Mr. Speaker and members, the amendment to the amendment basically removes the section that talks about small businesses with fewer than 100 employees and replaces it with a union member or fair share payer against a union. And so what this would do, members, is provide union members when they are within a lawsuit against their union with that 10% better rate that people are talking about. And this is a pro-worker amendment, and I would appreciate your support. And Mr. Speaker, ask for a roll call vote.
Representative Drazkowski requests a roll call. Seeing 15 hands, there will be a roll call on the amendment to the amendment. Discussion. The member from Swift, Representative Falk.
Thank you, Mr. Speaker. Representative Drazkowski, I'm not sure what you're doing here. This is kind of an anti-small business amendment, so I'd urge members to vote against it.
Discussion. Seeing no, the member from Wabasha, Representative Drazkowski, to the amendment to the amendment.
Mr. Speaker, this amendment would conform this amendment in the end to the same type of thing we've been seeing here for the last 2.5 hours, Mr. Speaker. These are maneuvers for us to put forward some sort of political statement so that we can take gotcha votes. And I see Representative Atkins laughing. But, Mr. Speaker, there are a lot of different groups in Minnesota that would like to have this better interest rate in these prejudgment offerings. And certainly union members would in lawsuits against their unions. Certainly we know that there's a good number of people, at least on this side of the aisle, that are very much pro-worker in our state and would like to support them, just like many of the amendments that came forward. Mr. Speaker, we've got to end the bringing forward of these types of amendments and get to vote on this bill. Mr. Speaker, the underlying bill passed 64-1 in the state Senate, and Mr. Speaker, I withdraw my amendment to the amendment.
Representative Drazkowski withdraws the amendment to the amendment. We are on the Falk Amendment. Seeing no further discussion, a roll call being requested. The clerk will take the roll on the Falk Amendment. Members, please vote. Clerk will close the roll. Representative Gunther votes no. There being 59 ayes and 71 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 530, the unofficial engrossment as follows. The amendment is coded 314.
Calling the author of the amendment, the member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. Representative Drazkowski, you may be joking around. We're not. I laughed because I knew you were going to withdraw that amendment. That was as bad of an anti-business amendment as I've seen in a long time. And as soon as you figured out what it said, my guess is that you probably realized, and as Representative Falk pointed out, bad amendment. The amendments that we've offered are deadly serious. These have huge consequences on middle-class Minnesota families. And what you're talking about with this bill will just harm middle-class Minnesota families again and again and again. All this one does is, this amendment, and I'll be very brief to it, is it says that it would mandate at least a 1% reduction in insurance premiums. That's all. Let's figure out who this bill really is for. You keep talking about it's going to be good for business. If it's really good for business, there will be an insurance reduction, right? 1%. That's all. Please vote green.
Discussion to the Atkins amendment. Representative
roll call, please.
Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the Atkins amendment. Discussion to the Atkins amendment. Member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Atkins, same response as I had to the proposed 16% reduction. This is a matter to be taken with the Department of Commerce and with individual insurance companies. It's not a matter for the prejudgment interest rate bill.
Discussion. Seeing no further discussion, a roll call being requested, the clerk will take the roll on the amendment. The clerk will close the roll. Biskins changes from aye to nay. There being 61 ayes and 69 nays, the amendment is not adopted. Seeing no further amendments at the desk, the clerk will give the bill its third reading.
Third reading, Senate File 530.
Third reading. Discussion to the bill. The member from Dakota, Representative Atkins.
And believe it or not, folks, I'll be relatively brief. We've now just gone through a series of very serious amendments. Amendments that would have protected military personnel, people with disabilities who've been defrauded relative to assistive devices, consumer fraud cases where people have been intentionally defrauded. We've got protections in this bill for folks that take advantage of people, and it would enable folks that use the Lemon Law to no longer get the interest rates to which they've been accepted. Representative Erickson was kind enough earlier to point out or to pass out the code of conduct for members, and I deeply appreciate that because she points out, I'm sure that her reference was to the Senate staff case that we talked about earlier. We've also got another employee, I don't like to indicate people by name, but Representative Hansen pointed out a case that's pending right now with the House, whose claim she's been, I guess I've never heard this term before, but the majority temporarily suspended her termination with the LCCMR. So there's a pending wrongful termination claim by that employee against the Minnesota House. Possibly there is a absolute wrongful termination case being brought by a former Senate staffer. And thank you so much, Chairman Erickson of the Ethics Committee. She wrote that on the Code of Conduct. Thank you so much for pointing out that every one of us on this stands to look just terrible, not just in terms of whether or not we have a conflict in voting on it, but this absolutely looks ridiculous. It brings shame, in my opinion, to the House to be voting on something that came up on Monday where a former Senate staffer indicated that he was going to bring a wrongful termination claim, and on Wednesday we're taking up two Senate bills today that would devastate that former Senate employee's claim. We're the only ones in Minnesota who can change the rules midstream, and that's exactly what we're doing if you vote for this bill. Whether you vote for it or not, though, it brings shame to this House, in my opinion. And the bottom line is it at the expense of veterans and disabled people and folks who've been intentionally defrauded. It lines the pockets of corporations and insurance company executives. It's a bad bill, and I'd urge a no vote.
Further discussion. The lady from Olmsted, Representative Liebling.
Thank you, Mr. Speaker. And this is the first time I've been up today on this bill, and I've been trying to listen to this long discussion and follow it. And so forgive me if I haven't heard this piece of information, but I think when we come here and we put forward a bill, there ought to be a problem that we're solving. And I have heard some discussion that this is about jobs and, without anything to back that up. And frankly, I haven't heard anything that would convince me that this has anything to do with jobs or would create a single job. But But another piece of information that I haven't heard and that I really would like to hear, if the author would yield, Mr. Speaker, would the author yield?
He will yield. Representative Liebling.
Thank you, Mr. Speaker. The piece of information I really haven't even heard is about how much interest has been paid in the state. We've heard something about, I think it's pretty clear that Minnesota is not viewed as a as a state with bad tort climate. That's been established quite a number of times, that we're 11th best according to the U.S. Chamber of Commerce. But what I haven't heard is even anything about the numbers here. How many judgments have been affected by this in the last few years? How much money are we talking about? If we think that making this change in interest and saving these insurance companies money is going to create jobs, what are we even talking about here? Are we talking about $1,000 difference? Are we talking about $50,000 difference? Or are we talking about millions of dollars that these insurance companies are going to be saved by this? So I think that makes a difference. What is the scale of what we're talking about? So if the author has any information about that, even approximate information, what are we talking about here? How much is this going to, if this had been in place, say, 2 years ago, how much money would these big insurance companies have saved on the interest that they wouldn't have had to pay on their judgments?
The gentleman from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Liebling. I don't have a figure on how much has been saved. What this bill does is it just moves and allows our citizens against whom claims are made to have a certainty that the claim at the end of the adjudication period is equal in time value to the claim at the beginning of the adjudication period. And that's the intent of the change in the interest rate.
Representative Liebling.
Well, thank you, Mr. Speaker. And, it's quite surprising to me. Thank you for attempting to answer that, Representative, but it's quite surprising to me that you don't have the answer. And the idea that this is going to save some jobs or create some jobs when we don't even know what we're talking about, I think that does kind of undermine the premise here that this is about any kind of jobs. But what I think that it does do is it makes it harder for people to get redress in court, and that's been discussed here today. So this is a bill. Most of these people who are going to be have a judgment against them are going to be covered by insurance. So this is really about insurance companies, and it's about making it easier for insurance companies to drag out claims and making it harder for the ordinary person or the small business to sue and to survive through what can be a very long period of a lawsuit until they get some redress. That's really what this is about. And I haven't heard the term 99% used very often, and maybe it hasn't been used at all today, but this bill really exemplifies a bill that is an attack on the 99%. This bill makes it harder for ordinary people to use the courts to get redress of their claims. And we know that one of the things our courts do, one of the very important things about our courts, is that they level the playing field between the ordinary person who's relatively powerless and big corporations who have lots and lots of money and can wait things out. And we've seen that time and time again. This bill makes that a lot worse, not better. It doesn't create a single job. I haven't heard anything, even that the author knows how much money is involved here. I would urge a no vote on this bill.
Further discussion to the bill. The gentleman from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. Representative Hoppe, I was inspired by your comments about the hue and cry for tort reform from businesses all over the state. And those of us who work in the private sector spend our time talking to business people, and when they hear you're in the legislature, they'll often bring up political issues, most often the Viking Stadium. I've never once heard a single person talk about tort reform as being an issue. Never once. But of course I don't work in the insurance industry, so that might explain it. So I thought I'd look at the Minnesota Chamber of Commerce. I know the Chamber spends more on lobbying than any other organization in the state. state by far. They call the shots in a lot of cases at the legislature. So I thought, well, let's look at their 2012 priority list. They should represent business. And, you know, I don't agree with all of their priorities. I don't think all of them are good for all of business in Minnesota, but their categories are budget reform. And under budget reform, they're not talking about torts. Their second category is education. Again, they're not talking about lawsuits. Energy, not lawsuits. Environmental permitting, not lawsuits. Healthcare, not lawsuits. You might think, well, on healthcare, maybe it's medical malpractice. They think that medical malpractice is an issue for healthcare. And you know what? It's not on there. It's not on there. Maybe that's because Minnesota has the lowest medical malpractice rates of any state in the country. The lowest. We are the very best state for medical malpractice rates because we have a court system that works. We didn't need insurance company lobbyists from ALEC to write legislation for us to make that work. We didn't have to have a set of anti-consumer, anti-individual, anti-business provisions written into law in order to make Minnesota's court system the best in the country for medical malpractice. We just did it by making the system work, by not putting partisanship and an out-of-state agenda in front of the interests of our constituents. Yet when given the chance time after time after time on this bill to put our constituents first, to put businesses first, to put veterans first, time after time the Republicans voted with the insurance companies. Time after time. They didn't vote with business. In fact, I missed the last one for the chamber priorities. Tax reform. Tax reform. And in fact, just to your point, they actually call for revenue-neutral tax reform. We could actually do that, members. Mr. Speaker, Representative Dean, if we were actually interested in getting something done, we could do revenue-neutral tax reform. It would take some work, but it could actually be done. And that would be living up to a priority from business. Doing something like this, which has no bipartisan support, which hurts our constituents, hurts business in Minnesota, except for insurance companies, that's not living up to a business priority list. That's not living up to a jobs agenda. That's not living up to the best interests of our constituents. That's not living up to doing the right thing for the state in any way whatsoever. This is about living up to a corporate lobbyist agenda from insurance companies, cookie-cutter bills from ALEC and other organizations that just kind of walk in, hand you the bills, hand you the talking points. The talking points that we've heard today on the floor, the same talking points in the boot camp document that Joe handed out, that Representative Atkins handed out. This isn't about business. This is about pleasing the people who pay the bills. And the people who pay the bills are the insurance companies around here today. They're the ones who are sponsoring this debate. Members, this should say, this edition of the Minnesota Legislature brought to you by the Minnesota Insurance Federation. And then we could just dispense with debate, take a vote, and move on.
Further discussion to the bill. The gentleman from Hennepin, Representative Mazorol.
Mr. Speaker, members, thank you. We've heard allegations about this bill that it's egregious, it's anti-business, it's shameful, and I've learned that I'm heartless. You know, this is really just about giving a little certainty to the judicial process. There are two parties to every lawsuit, at least two parties, and this is just a matter of maintaining a value throughout the course of adjudication that is equal to the value when the claim is made, no more, no less. I'd like to point out that there's been reference to the ALEC, the American Legislative Exchange Council Tort Reform Boot Camp. I've had no conversations with them. I don't know what their position might be on this particular bill. I'm not a member. But what I do know is we've got an organization known as the Minnesotans for Lawsuit Reform, which involves 145 chambers of commerce, trade associations, businesses representing over 62,000 individuals. That organization is behind this bill, and it includes organizations like 3M, General Mills, Wells Fargo, and a number of local bowling alleys, trucking companies, tree farms. This is what Minnesota business is about, and they are behind this legislation. In terms of this being a bipartisan bill, it's clear that the vote here may not look to be very bipartisan. In the Senate, this same bill passed 64-1. Same language. Members, let me tell you that what this bill does is it restores the prejudgment interest rate back to the pre-2009 levels, same as it was until that change was made a couple of years ago, and I ask for your support.
Further discussion to the bill. The gentleman from Washington, Majority Leader Dean.
Well, thank you, Mr. Speaker and members. Thank you, Representative Mazorol, for bringing the first of the lawsuit reform bills to the House floor for some honest discussion about some much-needed reform in the state of Minnesota about bringing jobs back. And thanks to the minority party for a good and spirited debate, particularly from the legal folks, Representative Adkins and Representative Winkler and others. In 2005, when I was a freshman, my favorite committee was the Civil Law Committee. Because we had Representative Emmer and Representative Ellison and Representative, the lawyers that were here, many that were here. And I would love to listen to the arguments because I learned more in that committee than I probably learned in any other committee, because you learn a lot by arguing on the extremes. And they're very good and they're very talented at arguing the extremes. But if you're not just a amateur student of the law and like to listen to lawyers as I do, especially those in our body, and you were watching at home, you might wonder, what are they talking about? What are they talking about? This is a partisan bill. This is an ALEC boot camp bill. This is outrageous. We can't do this. And then we hear over here, what did it pass the Senate? 64-1. They had one vote against it. This is the least controversial of these bills. But you know what? Representative Winkler, what I did notice when I was listening to the chamber folks talk, they had some very clear concepts when they laid out their agenda. They said they want fairer rules and fewer delays in the state of Minnesota to bring on jobs. And that's what this does. We need lawsuit reform in the state of Minnesota to make jobs more competitive for job creators in Minnesota relative to North Dakota, relative to South Dakota, relative to Iowa, relative to Wisconsin, relative to other states in this country, because we are in a fight for our lives for jobs. Being 11th, we can say, hey, we're 11th. That's status quo. Good enough. Good enough, job creators. We're already doing enough. No need for change here. Don't look at this. Move along. That's not good enough for job creators in the state of Minnesota. Governor Dayton, starting out the year, Governor Dayton and DFL legislators present jobs plan to get Minnesota back to work. Jobs, governor's priority. Jobs, the Democrat priority. Jobs, our priority. Let's start working at some common sense reform and pass the Senate 64-1. January 23rd, Representative Thiessen. He said this legislative session, jobs should be our top priority. Well, we agree with you. We understand that we need to work together with job creators. They're not our enemies. They're the people who are going to sign the fronts of paychecks, desperately needed paychecks to support families in the state of Minnesota. Representative Mazorol's bill is the first step towards that in lawsuit reform. Employers understand that we need to do this. We need to do this. The business community is desperately looking towards the legislature for a ray of hope. Just give them a little ray of hope that it's going to be a little brighter for people who sign the front of paychecks. I would urge members to vote for the Mazorol bill, and let's take a step forward for reform.
The gentleman from Hennepin, Minority Leader Thiessen.
Thank you, Mr. Speaker, and I apologize for the reverse order on this bill, Majority Leader. We do want to focus on jobs. Unfortunately, this bill doesn't create a single job, and nobody on that side of the aisle can point to the fact that it does create a job. We talk about what small business wants. We talk about what business wants, and there was some claim that tort reform is the gold standard for what business wants. This is a Gallup poll of business. Consumer confidence improving. Lack of consumer demand is a problem. We ought to be focusing on improving the lives of middle-class families so they have money in their pocket to actually go and spend on businesses. Lack of credit availability, cash flow, competition from big business and overseas. Those are the kind of things that we ought to be focusing on that's actually going to improve business and create jobs. Again, you have not brought a single bill during this whole, as we've started this entire session, not had a single hearing on a bill that will actually get people back to work. And there's no claim on your side of the aisle, no proof whatsoever, that this bill will actually put any Minnesotan back to work. That's a problem. In fact, it's going to hurt that. It's going to decrease jobs, just like you did with your budget last year. This bill, you're starting off on the same tactic. You're going to squeeze the middle class, you're going to hurt ordinary Minnesotans, and you're going to hurt our ability to grow our economy. Because the way we grow our economy is not just talking about business, it's talking about growing a strong middle class. And this bill is just emblematic of the tactic you're taking, which is absolutely opposite of that. So I would encourage a no vote on this bill and on all the other bills that are coming down. Let's get these bills out of the way so that we can actually get down to the business of getting people back to work and growing our economy. That's what Minnesotans want us to focus on. That's what we should be focusing on, and you're not doing it.
Further discussion to the bill? Seeing none, the clerk will take the roll on the bill. Clerk will close the roll. There being 75 ayes and 55 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 149. The clerk will report the bill.
Senate File 149 on the calendar for the day, an act relating to civil actions, unofficially engrossed and reprinted for the House to include committee amendments.
The author of the bill, the gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Members, this is the second in a series of tort reform, civil lawsuit reform bills, that all of which are part of a package that will grow jobs in Minnesota and unleash the power of free enterprise. Because as we all know, people in Minnesota and businesses create jobs. Government does not. Lawsuits only create a limited amount of jobs. They kill more jobs than they create usually. So the goal here is to create a fair and efficient civil litigation system in the state, to improve the efficiency and fairness of our litigation system. Now, the U.S. Chamber survey puts us at 11th in the nation, but that survey, members, is based on attitudinal data of a few different companies' general counsel. We have other indications that the tort system and the civil litigation system in general in Minnesota is failing our business community and failing our citizens. For example, the 2008 update on U.S. tort costs by Towers Perrin estimates that, this is nationwide, the U.S. tort system cost $252 billion in 2007. That's $835 per person. So that gives you kind of the national picture. A 2011 working paper, a study for the U.S. Chamber Institute for Legal Reform by NERA Consulting, details the impact of an inefficient civil litigation and tort system on Minnesota in particular. It states that total tort costs in this state, $4,573 million. The study also estimates that if you were to raise Minnesota's civil litigation system up to the most optimal, efficient, and fair system possible, now we can't get all the way there, perhaps, but we're moving in that direction. If you could do that, that would alleviate costs on the order of $516 million, translating to an increase in employment in the state of Minnesota of somewhere in the range of about 0.5% to 1.2%. So that's thousands and thousands of jobs. Those are numbers, hard numbers, from respected economic consulting institutions and groups that show that the closer we get to a more fair, optimal civil litigation system, the more jobs we have. And it just makes sense. We drive economic growth if we get the courts and officers of the courts, in terms of attorneys, playing according to fairer rules that don't allow attorneys the ability to bring frivolous claims forward, or to bring claims that are stale forward, or to operate according to rules that are less than maximally efficient. So with that general picture, and understanding that this suite of bills is directly related to job creation, let me talk a little bit about Senate File 149, formerly House File 211. I'm going to address the second piece of it. Section 2, interlocutory appeals for class actions. What does that mean? Well, Minnesota's litigation climate, civil litigation system is far less than ideal. It is suboptimal in the area of class action litigation and rules therefore. Unlike the federal court, unlike courts in states like Colorado, Kansas, Ohio, Florida, Missouri, and others, Minnesota does not allow for immediate appeal as a matter of right of class certification orders. That is, in Minnesota, when a lawsuit is brought forward, and like in every other state, a judge needs to make a determination as to whether the lawsuit is a proper class action. A judge needs to classify a lawsuit, if plaintiffs are seeking a class action suit, as a class action. The initial order near the beginning of the case, where the judge certifies the class and goes forward, is very important. Oftentimes, in appeals of class action lawsuits, jury verdicts, at the end of the process, the entire appeal will hang, or much of it, on that initial class certification order. All this bill does, it's a small but very significant and important change for our business community. It allows for an immediate appeal right after the judge orders the class certified. Right after the judge says, yes, this lawsuit is a proper class, based on a variety of factors, the defendant can go ahead and get an appeal as a matter of right to the Court of Appeals right away to see whether the judge did the right thing. If the appeal comes back and the Court of Appeals says, no, the judge did not do the right thing, this is not a proper class, then the lawsuit goes away. If the judge says, yes, this was a proper class, then the lawsuit goes forward, perhaps all the way through to a jury trial. What does this do then? It filters out the non-meritorious cases at the beginning before the expense of litigation has been incurred by the defendant. And it allows judicial resources to be focused on the claims that do have merit going forward. So it optimizes outcomes, and it decreases unnecessary and unfair litigation costs for businesses. It does another thing too. Oftentimes the class certification decision at the outset of the case, the judge says, okay, it's a class action, it's proper, let's go forward. Because it's very difficult to appeal that before the end of the case, a defendant company, a defendant job creator, will be frightened into settling, even if the claim isn't all that meritorious, because it's difficult to predict what a jury might do, because there might be very large damage claims, because a jury might award a very large damage claims on a claim that doesn't have much merit. And they won't be able to appeal it. And maybe they would be able to get redress, but they won't be able to do that until the very end of the case, after they've incurred all sorts of costs with going through discovery, and depositions, and interrogatories back and forth, and document exchanges, and attorneys, by the dozens perhaps, working on these cases. Then they can appeal that initial decision. Well, so they just say, we're going to settle now and avoid that expense. That is a lot of money that businesses pay out that we can avoid with this bill. And when we decrease the cost of litigation for job creators in Minnesota, that money is available to expand business, to create new jobs, and also it makes our business climate more attractive to people looking to move to Minnesota and start a business here. And it empowers entrepreneurs a little bit more, encourages them to go ahead and pursue their dreams, maybe start that business that they are worried about starting because of our business climate, taxes, and everything else. So the tort system, the civil litigation system, is a critical part of our state's business climate and competitiveness for jobs. and growth of jobs. So if we really want to unleash the power of free enterprise, the power of the entrepreneurial spirit, then we should all vote green on this bill. Thank you.
The gentleman from McLeod, Representative Szymanski.
Thank you, Mr. Speaker, and thank you to Representative Wardlow on carrying Senate File 149. Today I want to address you on Section 1 of the bill. Subdivision 3 talks about raising the limits in conciliation court. Conciliation court was established back in 1971, but since 1974 the limits have not been increased for conciliation court. Conciliation court offers the opportunity for small business owners and individuals to take their small claims to court without incurring the expense of district court hearings and associated attorney's fees. So today we have the opportunity to raise those limits for conciliation court hearings, and I encourage your green vote on this bill. Thank you.
Discussion? There is an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 149, the second unofficial engrossment as follows. The amendment is coded 602.
The gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. It's nice to see you up in that chair again, Representative Davids. The first thing, if the Chief Clerk would be so kind, I have a slight oral amendment to my amendments. It would start on line 1.5 and continue on to line 1.6, and it would delete the words spoliation of evidence.
If the Chief Clerk could report the oral amendment.
Atkins is modifying his amendment to Senate File 149 as follows. In his amendment on line 5, delete spoliation of, and on line 6, evidence, comma.
Discussion? Excuse me, Representative Atkins, you're just incorporating that?
Thank you, Mr. Speaker. I'd like to explain the amendment and ask the Chief Author to yield. And I believe that I moved the language and I've incorporated that into my amendment.
You incorporate the oral amendment. If you could please describe the amendment as amended.
Thank you, Mr. Speaker. What this amendment does is it says in the instance where these appeals takes place, if the party that has appealed is engaged in destroying evidence or witness tampering, dissipating their assets, or retaliation, that would require judgment against or in favor of the other party. And regardless of whether or not you support staying discovery, which I'm sure we'll have some discussion about, if the party that's at fault for this is witness tampering or destroying evidence, that shouldn't be the sort of conduct that we condone. And I would ask for a roll call on this amendment, Mr. Speaker.
Are there 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Dakota.
Thank you, Mr. Speaker. Would the Chief Author yield, please?
The Chief Author will yield.
Thank you, and thank you, Representative Wardlow. How many of these class action cases have there been in the last year?
The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Atkins, I don't have an exact number of class action cases in the last year. I do know that the fiscal note, which is very small on the bill, indicates that the Court of Appeals would anticipate 5 to 7 additional interlocutory appeals as a result of this bill. So that gives you a sense of the scope of the bill. So a significant number of additional appeals will be generated, but not a very, very large number.
Representative Atkins.
If he would continue to yield, Mr. Speaker.
He will yield. Representative Atkins.
Thank you, Mr. Speaker. And on appeal, Representative Wardlow, I guess you don't know how many there even were, but on appeal, have any of them been decertified? Have they been knocked out of court on appeal, or are we just doing one of those solutions in search of a problem kind of thing? How many appeals have been thrown out on appeal? Or how many class actions have been thrown out on appeal, say, over the last year, 10 years, whatever figure you want to use?
The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Atkins, I don't have exact numbers. I know I was just informed that there were 8 class actions last year. I'm not certain how many were thrown out on appeal. But the point here is that we're making a change that makes sense from just a common sense point of view. And this is something that the the Minnesota Chamber has made a priority, their top tort reform priority, and we've already heard about Minnesotans for Lawsuit Reform, and those businesses are also seeking this bill. 62,000 different businesses, from 3M to local bowling alleys to tree farms and trade associations, banks, etc. They all seek this across Minnesota, every part of the state. Businesses want this reform because it makes sense, and because it puts Minnesota's rule in line with the federal courts and in line with many other states, including Colorado and Ohio, Missouri, Kansas, etc.
Thank you, Mr. Speaker. I thought my question was just how many got thrown out. I didn't. The amendment is fairly simple. Number one, we don't have many of these cases. We had 8, apparently. The chief author can't tell you how many got thrown out on appeal. And we got one of those solutions in search of a problem, folks. But in the very least, if we're going to mess around with something that's already doing just fine, we've got the 11th best litigation in the country according to the U.S. Chamber of Commerce. Not according to Joe Atkins or according to some trial lawyers, but according to the U.S. Chamber of Commerce. But in the very least, if you're going up against somebody and they literally destroy evidence, they shouldn't be allowed to prevail. That's all this amendment does. I'd appreciate a green vote. And I asked for a roll call, I believe, Mr. Speaker. Thank you.
Further discussion to the Atkins amendment as amended. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. On the Atkins amendment, the amendment doesn't actually do anything because this could already be done on summary judgment or a motion for sanctions. Part of the bill is that the automatic stay of proceedings while the appeal is pending can be lifted upon a motion by any party for good cause shown. So if there is good cause, that could be brought, the stay could be lifted, and a motion for sanctions or a summary judgment could yield the same results. So this doesn't add anything. This is just a distraction. Thank you.
Further discussion to the amendment as amended. The clerk will take the roll on the amendment as amended. The clerk will close the roll. There being 61 ayes and 69 nays, the amendment as amended does not prevail. There is an amendment at the desk. The clerk will report the amendment.
Simon moving to amend Senate File 149, the unofficial engrossment, as follows. The amendment is coded 576.
The gentleman from Hennepin, Representative Simon.
Thank you, Mr. Speaker and member. This amendment gets rid of the second part of the bill. Here's why. The bill basically guts class action lawsuits in Minnesota. Now, I know that in some circles, whether it's ALEC or others, it's sort of tempting sometimes to snicker at class action lawsuits because you hear examples of cases that cost a lot of money where the individual consumer in the end of it gets a coupon for a few bucks. And I can understand the surface kind of appeal of someone saying, well, wait a minute, a real expensive lawsuit, and in the end people got just a few bucks per plaintiff, and there may be 1,000 or 10,000 or 1,000,000 plaintiffs in the class action. I would bet that almost everyone in this room, whether you knew it or not, has been part of a class in a class action. It might be all consumers who purchased X product between these years, and you might be in it. And maybe you've gotten that piece of junk mail mailed to your house that asks you whether you want to opt in or opt out or something like that. But the thing about class actions is it makes sure that we can right certain wrongs when the amount of harm done per individual is small. So if someone asked you whether it's wrong for someone to swindle someone out of $1 million, you'd say yes. But I don't think anyone would say that there's any difference in that answer, that yes answer, if it was one person swindled out of $1 million or 1 million people swindled out of $1. The wrongdoer has still gotten away with something bad. They've still gotten away with swindling someone. So the whole idea behind a class action is if you get enough people together, you can get your money back or you can be restored to where you were. But on your own, you're not going to go out and sue for $1 or $10 or 100 or probably not even 1,000. It takes a lot of people to band together in a class action. That's one way to do it, but not the only, to get some sort of justice and to make sure that those people are made whole. So in the end, it's about the wrongdoing, not about how much each individual person gets at the end. And there are a lot of examples that we could go over about why this is a good thing. The reason that this bill in Section 2, which this amendment would get rid of, the reason it guts class actions is it allows someone who's been sued in a class action to basically run out the clock. It says that in the middle of all of this, A, there has to be an appeal, has to be, and B, during that appeal, everything else freezes. So the parties may be in the process during this lawsuit of trading information, taking down the statements of the other side, interviewing witnesses. They may be in the process of taking statements under oath, basically gathering evidence, both sides. And what this bill says is if there's appeal, which now there has to be, in the middle of the case, right in the middle of when the sides are investigating and doing what's called discovery, everything stops. And that could be years. And during those years, certainly many, many months, memories fade, people leave employment, people die, evidence disappears, and that can happen on both sides, members, not just the person defending against the claim, but the person bringing the claim. So to repeat, what Section 2 does is it says in the middle of the lawsuit, not at the end when one side or another doesn't like the result, but in the middle of the lawsuit, A, there has to be an appeal, has to, and B, during the appeal, freeze. Freeze everything. Neither side gets the chance to interview people, to discover information about their claims or their defenses or anything like that. This rigs the system. This is a flat-out rigging of the system for defendants in class actions. And I just want to say a word about this, too. Sometimes you get the impression, not so much on the floor debate today, but when you hear other people talk about class actions, that it's something that's easy to do. That the system's just full of these certified class actions of people banding together by the hundreds or thousands or even more sometimes to get a little bit of money. But in reality, as I suspect Representative Wardlow knows, it's a very, very hard thing to do. Because in order to even be recognized as a class, in order to do a class action, you got to jump through a lot of hoops. You got to jump over a lot of hurdles. For example, both on the state and the federal level, you've got to prove to a judge before you can even go forward. Before you can even go forward, you've got to prove that you have enough people to make it a viable class. If you got 3 people, the court's going to say, well, you guys can sue on your own. You don't need each other necessarily. But you got to make sure you got enough people. The other thing you got to show is you've got to show that you've got common interests. And then the last thing you have to show is that the class representatives, if there are 4 people representing 1 million who are in the class, you got to show that they're typical of the whole class. The point is not to go through all these hoops and hurdles, but just to say it's a hard thing. Just know that. It's a really, really hard thing. It doesn't happen often for a reason. It was made to be hard, and it is hard, and it should be hard. But what Section 2 of this bill does, and the reason this amendment would get rid of it, is it rigs the game in class action for the defendant. Rigs the game because they can wait it out and they can freeze. So again, what Section 2 does is it says automatic appeal right in the middle of the lawsuit, right in the middle. And number 2, during that automatic appeal, everyone has to freeze their investigation, basically, their investigation of the facts from the other side. And we know what that will lead to, and we know where that result gets skewed. That's not fair. So, members, I ask you to vote for the amendment so we can preserve the system we have now, which even in the face of very few class action lawsuits, because these are not very common, is a fair system. It allows both sides, plaintiffs and defendants, to air out the facts, to air out their differences, to basically make their various claims and defenses, to duke it out, to argue it out, and then at the end, if one side or the other is disappointed in the result, then they can appeal. But members, we shouldn't make consumers, you and me and our constituents, who may have been done wrong, we don't want to make them wait so long that the evidentiary trail goes cold, that they can't even get the relief they're seeking. They can't even get the justice they're seeking because you got an automatic appeal, and during that appeal, which could be many months or years, you absolutely freeze all activity. That's not right. That's unfair, and I ask for a yes vote on the amendment. And I ask for a roll call.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be roll call. Discussion to the Simon Amendment. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker, and thank you, Representative Simon, for your comments to your amendment, to Representative Simon's amendment. Let me just clarify Section 2 of the bill. The amendment would gut the bill, but the bill would not gut class actions. The bill simply states that a class certification order, that initial order where the judge determines whether the class is proper, is appealable as a matter of right. It's not an automatic appeal. It doesn't happen automatically. Rather, the defendant has a right to ask for an appeal. And if the defendant asks, then yes, they get the appeal. That's the point. Appealable as a matter of right. That's a small point. More importantly, we know that the Court of Appeals projects there will be 5 to 7 approximately additional class certification appeals as a result of this bill each year. So that means 5 to 7 cases are certified as class actions and go forward. And you have to remember, members, that these are often very, very high dollar amount cases. So 5 to 7 cases could represent potential liability of millions and upon millions of dollars for Minnesota businesses all around the state. Now, you can lift the automatic stay of discovery upon a motion for good cause shown. So everything is frozen, but if there's a good reason to unfreeze it, the district court judge may unfreeze it. What does the automatic stay do? Why is that important? Because it prevents court costs and litigation costs, the cost of discovery, the cost of taking depositions and all of that from accumulating while the Court of Appeals takes a look to see whether the judge got it right as to the class and whether the class should go forward. And again, this is in line with the federal courts, moves us in line with the federal courts and several other states where the sky has not fallen and class actions still continue. The good thing about this bill, members, is that it just sets up a filter near the beginning of the proceeding, because we're talking about very high dollar, very expensive litigation where a lot of money is at stake. It sets up a filter early on to determine whether there is any merit to the class and whether it should go forward. If it isn't proper, we shouldn't put businesses and employers through the costs of litigation unnecessarily. If it is a proper class, it continues forward, and it doesn't take years to have an appeal. It takes a matter of months. There's a 90-day turnaround time on appeal at the Court of Appeals once everything's submitted, approximately. That's the goal, at least, of the Court of Appeals. At the Minnesota Court of Appeals, that's right. Now, it would take some time for briefing and all of that once it's submitted to the decision. So we're talking about a matter of months. This does not rig the system in favor of defendants. In fact, it helps us focus our judicial resources by weeding out those meritless claims early on the claims that do have merit. And it decreases litigation costs that are unfair to businesses who are hauled into court for any manner of silly things that class actions, or maybe not silly, but for any manner of things that one might bring a class action lawsuit on the basis of. So you can lift the stay for good cause shown. And just for the record, this is not an ALEC model bill. And even if it were, I don't know that matters, but it isn't. This is a priority for 62,000 plus business and trade association members of Minnesotans for Lawsuit Reform and the Minnesota Chamber of Commerce and many regional chambers. This is an important bill. It actually improves how we handle class actions in Minnesota. It improves our class action rules It puts them in line with federal and other states' courts, and will lead to better results and fairer outcomes for plaintiffs and for defendants, and will also create jobs by reducing unnecessary costs on our businesses.
Discussion to the Simon Amendment. The gentleman from Hennepin, Representative Simon.
Thank you, Mr. Speaker and members. Representative Wardlow, I appreciate the discussion. 2 points, though. One, I think you misspoke when you said, or at least I think I heard you say, that this was just put us in line with the federal rule. I have the text of the federal rule right here, and my reading of it is that's not the case. This would make this far more defendant-friendly than the federal rule, which I'm looking at right now, and I won't inflict that language on the chamber here. But I will say that it's not right. That's not true, and maybe I misheard you. Second thing, though, that I think is important to bear in mind and bears repeating. I think sometimes when you listen to the sort of over-the-top, cartoonish version of class actions, I'm not saying that's what you talked about, Representative Wardlow, but in other quarters, when you hear about that, you think of individuals suing businesses. But the reality is that oftentimes classes are made up of businesses. It's either smaller businesses suing bigger businesses, or it's just plain businesses suing other businesses. So I'm just trying to understand why this is somehow pro-business, when very often the people who initiate class actions are businesses who have been cheated either by a wholesaler, allegedly, or who think they've been done wrong by some other business entity. So that's very often the case. It's not just individuals. And I guess one of the frustrating things for me generally about some of these tort reform bills, if I can just make kind of a general comment, is so often many of the people outside this chamber, not members of this body, but outside this chamber who talk about tort reform, what they really seem to be saying, at least to me, is they don't like lawsuits, but they don't like lawsuits when it's individuals suing entities, mostly businesses. But they're perfectly okay with using the court system when it's businesses suing other businesses. That they don't mind. So what they really mean by tort reform and reining in litigation, abuse, and all the rest is reining in people suing businesses. They don't mean reining in businesses suing other businesses. And last session there were many handouts on the floor, and maybe there will be before the day is done today, about how businesses rightly, by the way, rightly make use of the courts in order to remedy some sort of injustice. I think that's a good thing. I don't think it's bad at all when Honeywell or 3M or General Mills or Best Buy uses the court system to go after someone who's wronged them. That's a good thing. That's a healthy thing. So I'm not knocking it at all. I'm just saying it's curious to me how sometimes we don't hear the same objections to that kind of litigation, that kind of use of the courts, but we do when it's individuals, Ma and Pa and Mr. and Mrs. Minnesota, who are going after folks who may be in a corporate setting. So I think this is one example, unfortunately, of singling out just one type of litigation and not everything. So I'd urge support for the bill, or not for the bill, but for the amendment.
Further discussion to the Simon Amendment. The clerk will take the roll on the amendment. Members, please vote. The clerk will close the roll. There being 62 ayes and 69 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Huntley and others moving to amend Senate File 149, the unofficial engrossment, as follows. The amendment is coded 149A5.
The gentleman from St. Louis, Representative Huntley.
Mr. Speaker and members, this amendment relates to a particular class action suit, and probably the most famous class action suit, at least in the medical industry, that this country has ever seen. It had particular interest in Minnesota because one of the key attorneys in this class action suit was Michael Cerisi, and the federal judge that heard it and ruled on it was Judge Miles Lord from Minnesota. In addition to that, the University of Minnesota had a key role in testimony and in subsequent analysis of what actually happened. Now, this was a federal class action suit, not a state one, but I think what we learned from that case is how important it is that we not delay the implementation of class action suits. And any delay allows who's ever being sued to start mucking around with their records, getting rid of their employees that they don't want around to testify. And these cases take a long, long time. And you should pay particular attention to the times. This relates to what was called the Dalkon Shield lawsuit. The Dalkon Shield was a birth control device that was basically implanted in women, and it was based on studies in the late 1960s by a Hugh Davis, an MD at Johns Hopkins Law School. I want to tell you, Johns Hopkins has a tremendous reputation, and it was very much hurt by this particular case. He designed this device in 1971. He sold it to a large pharmaceutical and medical implement company called Robbins, and they brought it nationally, advertising starting in 1971. And had national advertising. They knew at the time that when they started this national advertising, that Dr. Davis had fudged some of the data that he had published when he first invented this thing. They knew that. But they still kept up the advertising, and it sort of blew up, and in mid-1974, Robbins quit selling this product. And the product caused some things. First of all, it destroyed a lot of fetuses, and one of them, the process was called septic spontaneous abortion. And it was because of infections in the woman's uterus that led to the death of this abortion. Physicians had never seen this kind of thing before, except in cases of criminal abortions, where there was not proper care and cleanliness involved. As I said, in 1974, they quit selling this. But the case went on and on and on. Ultimately, the Robbins Company filed for bankruptcy in 1985. It was then sold at a cheap price to the company we all now know as Wyeth. And if you want to talk about big cases, more than $3 billion in payouts were made to women who had been harmed by this device. That never would have happened if we hadn't had a class action suit. And while $3 billion sounds like a lot of money, Robbins actually made more profit from 1971 to mid-1974 selling this device than they had to pay out when the court finally ruled against them. 200,000 women collected money from this lawsuit. They averaged $21,000. The highest award was $2.2 million, and that was for a family that, because of this device, had a severely deformed child. Even before the settlement, the FDA decided, maybe we ought to regulate things a little tougher, and so in the late 70s, the FDA got authorization that if you had a medical device, it had to be approved by the FDA. And again, I don't think that would have happened if we hadn't had this class action suit. Most of the awards, the $3 billion, weren't given out until the 1990s, more than 20 years later. And if the Robbins Company had been allowed to delay this thing and change their records, those 200,000 women would never have received a penny. So what this bill does is delay. What this amendment does is simply say that whatever this bill is doing, it won't apply to interuterine devices. And again, you should know that when these things failed, what it led to was a spontaneous abortion and damage to the women's uterus. We need to protect those women. What this amendment does is says for IUDs, whatever this law changes is not going to have any effect. I urge you to support this amendment.
Discussion to the Huntley Amendment.
And I would like to ask for a roll call.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Members, this amendment is unnecessary. The bill here does not stop class actions. It allows meritorious class actions to move forward as before. It actually focuses judicial resources on meritorious claims. And if there's any reason to lift discovery, a motion may be made by a party to show good cause and the stay can be lifted. So this bill does not stop class actions, and the meritorious class action that was just discussed would not be affected by this bill. It could still go forward. So please vote red on the amendment.
Discussion to the Huntley Amendment. The gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Wardlow, with due respect, you're wrong. What this bill does is it stops discovery. It stops the victims from being able to find out anything about what happened. During the delay, people die. That's not exaggeration. That's exactly what Representative Huntley's talking about. During that period of time, when you want to stop discovery, that's when people find out what all of the harm was. And during that delay, which can sometimes be months or even years, people die. Vote for the Huntley Amendment.
Further discussion to the amendment. The clerk will take the roll on the amendment. The clerk will close the roll. There being 62 ayes and 69 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Winkler moving to amend Senate File 149, a second on official engrossment as follows. The amendment is coded 149A7.
The gentleman from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. I'd first like to ask for a roll call.
Roll call having been requested. Are the 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Hennepin.
Thank you, Mr. Speaker. Well, members, I don't like having to offer this amendment because the problem with it is that we're writing, one of the problems in general, but the problem with this amendment is that we're writing into statute a specific exception for a specific kind of case. And the problem is that we shouldn't be writing in statute rules for how the court is supposed to conduct litigation. Representative Wardlow's bill takes the discretion or the authority out of the courts for how class actions should be reviewed and says that the legislature knows better. And I'm going to just tell you that after the last year being in this body, I don't think there are very many things that the legislature knows better than what's going on in other parts of government. The Minnesota courts deal with class actions. They have rules for class actions. They have rules for appeals. They have rules for when you get to appeal something in the middle of the case, and they have rules for when you get to appeal something at the end of the case. And Representative Wardlow's bill says that if you're a big company, you get to appeal class action in the middle of the case instead of waiting till the end. That's the Minnesota legislature substituting our judgment for the Minnesota Supreme Court on what rules are good for judicial efficiency, what rules are good to make the judicial system work better. And you don't really, I mean, you can just look at the section of statute that he's adding this to. That would be the only section of statute that actually tells the court how to run its own business. And members, I really think we should be carefully considering this session whether we really know better about how to run our business, run other people's business than we do our own. The amendment says that if you get an automatic right to appeal in the middle of the case, it doesn't apply for claims against Philip Morris or Altria for fraudulent marketing of light cigarettes. Now that seems kind of specific. But actually it's highly relevant because the Minnesota Court of Appeals just reinstated a lawsuit against Philip Morris for its fraud in its claims about the health benefits of light cigarettes. Philip Morris not only was making false claims, it knew that it was making false claims, and it was hiding the evidence from discovery by the plaintiffs in the case. So it was hiding evidence about the fact that it knew that its claims about light cigarettes were false. So what Representative Wardlow's bill does is say that you can't get access to information about what's going on in the case until you get your class action certified. You have to stop. And at the same time, we have a current case underway where Philip Morris is intentionally hiding the information from discovery. So they're not even following the rules. They're not even following the rules of court as they exist. They're hiding it. And this Court of Appeals case was just reinstated last month in January. We have a current case going on, and this changes the rules for it. Now you might think, well, what's the big deal? I mean, eventually they'll solve this. He makes this claim about 90 days. It's all it's going to take. A similar case in Missouri, actually the same case in Missouri, took 11 years to get to the jury. 11 years. And the way this works is, if you're a company and you're making money and you're doing something that you know you're eventually going to have to stop doing, you delay as long as you possibly can. There are plenty of law firms who are more than happy to take your hourly rate, far more than $100 an hour, Representative Dean. They'll take that hourly rate and they will invent ways to delay cases as long as they possibly can, for the sole reason to protect the money they're making and to make it more difficult for the plaintiffs to have a day in court. 11 years to get to a jury. And when there's not even a question that there's a damage, and there's not even a question that the tobacco company was concealing information. So I don't like having to create this narrow single exception for this one case, but that's the real problem that we're creating if we don't create these kinds of exceptions. That's why the court system exists, to sort these things out. And much like in the last case, it's laughable, frankly, that the Minnesota legislature thinks it knows better how to run the court system than the courts do. We can't even run our own business. So, members, I would ask for a green vote on the amendment and let this case go forward. And if you don't care about the legal system, you don't care about the courts, it's not a big issue for you, think about it another way. If we don't allow litigation against tobacco companies to go forward, we can't even balance our budget. Think about that. Last January, because of a tobacco case, we were able to sell bonds against money coming in down the road because some people were able to sue tobacco companies. So if for no other reason than the desire to borrow more money in order to cover up your unwillingness to make tough decisions, you might want to vote yes on this amendment so we can keep that money flowing back to the state from tobacco companies. Because otherwise, we're going to actually have to do some hard work around here and maybe focus on actually doing our job instead of telling the courts how to do theirs.
Discussion to the Winkler Amendment. The gentleman from Dakota, Representative Wardlow.
Would Representative Winkler yield for a question?
He will yield. Representative Wardlow.
Thank you, Mr. Speaker. Representative Winkler, are you aware of, and can you cite any other instances in statute where individual companies are called out by name, as in your amendment here?
The gentleman from Hennepin, Representative Winkler.
Mr. Speaker, Representative Wardlow, I don't really recall if there are other individual companies called out in statute or not. The reason it's necessary is because you are changing the court rules in the middle of a pending case.
The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Thank you, Representative Winkler. In fact, you won't find that in any other statute because it's not allowable under the Constitution, federal or state. You can't have a law pertaining to one person or one enterprise or one company. So, just for that reason alone, we need to vote right on this amendment. But also, as I said before, the underlying bill does not stop class actions. I don't know the procedural history in the case that Representative Winkler is talking about, but if a case is delayed for 7 years or 11 years, it probably was not because of any kind of interlocutory appeal rule. So this is just not relevant. And if there is good cause to lift the stay of discovery, it may be lifted so that discovery can proceed. So that takes care of that concern with regard to discovery. Members, please vote right on the amendment.
Discussion to the Winkler Amendment. The gentleman from Hennepin, Representative Winkler.
Mr. Speaker, I would like to I'd like to modify my amendment.
Please state your modification.
Mr. Speaker, Representative Wardlow, thank you for pointing that out. And a good way to improve this is to strike the following words. So in line 1.3, strike against Philip Morris or, and in line 1.4, strike Altria. And the clerk will report it, but members, it'll say in the end, except for claims for fraudulent marketing of light cigarettes.
If the clerk could report the oral amendment, please.
Winkler is modifying his amendment to Senate File 149 as follows. On line 3 of his amendment, delete the words against Philip Morris or, and on line 4, delete Altria.
Discussion to the amendment as amended. The clerk will take the roll on the amendment as amended. Members, please vote. Clerk will close the roll. There being 61 ayes and 70 nays, the amendment as amended is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 149, a second unofficial engrossment as follows. The amendment is coded 149A12.
The gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. This just gives an exception for cases like Enron, WorldCom, and a Minnesota connection, the class action cases that were brought by charities against Tom Petters. This provides for those sorts of claims to continue to move forward. I'd appreciate a green vote.
Discussion to the Atkins amendment. The gentleman from...
Mr. Speaker, I'd appreciate a roll call, please.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Again, members, the underlying bill here does not stop class actions. It filters out class actions that do not have merit early and allows class actions that do have merit in terms of class certification to go forward and focuses judicial resources on those meritorious classes. So we don't need to carve out anything from the bill here because it doesn't stop class actions, and you can lift the stay of discovery upon a motion for good cause shown. Please vote right for the amendment.
The gentleman from Dakota, Representative Atkins.
Thank you, and I'll be brief. So while Enron and WorldCom and Tom Petters and others are off destroying documents during this stay of discovery, and you've got no ability to stop that except for making now an order rather than being able to proceed with your discovery. If you are thinking that Enron and WorldCom and Tom Petters are not the best of actors, and you support the victims of those crimes, the people who've suffered securities fraud, the charities have been defrauded, the elderly folks that have been defrauded, you want to vote for this amendment, please vote green.
Further discussion to the Atkins amendment. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Very briefly, there are very severe sanctions for spoliating, for destroying evidence, for shredding documents, things like that, including granting summary judgment to the opposing party. So, very extreme jail time, large fines. So, there are significant things in the rules already to deter such actions. That's taken care of. This bill doesn't have anything to do with Enron or WorldCom. Please vote red on the amendment.
Further discussion. The clerk will take the roll on the amendment. The clerk will close the roll. There being 63 ayes and 68 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Falk moving to amend Senate File 149, a second on official engrossment as follows. The amendment is coded 149A4.
The gentleman from Swift, Representative Falk.
Thank you, Mr. Speaker. Members, there's been a lot of talk about seemingly making class actions more difficult. And we forget about what it means to not just the victims or the people who've been wronged, but maybe as a state as a whole. We've been talking a lot about invasive species, namely Asian carp, zebra mussels, and what this could mean for our tourism, fishing, recreation industries. And these invasive species are posing a huge challenge, and they're going to require substantial taxpayer dollars to go and address them, which I think is something we have to seriously consider. We should perhaps be looking at those responsible being held accountable. So why on earth would we want to go and make it more difficult or easier for those companies or individuals or entities that have allowed these species into our state and to cause problems for these very valuable industries to get away with it, to get a free ride. I guess if Representative Wardlow would yield for a question.
He will yield. The gentleman from Swift.
Thank you, Mr. Speaker. Representative Wardlow, who is responsible for these invasive species? Where do they come from?
The gentleman from Dakota. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Thank you, Representative Falk, for that question. I was actually going to ask you that same question. Who is responsible for this, and what would the theory of liability look like in a lawsuit seeking relief against whoever is responsible? I don't know. I also know this, that whatever the case may be, whoever's responsible, if there is somebody responsible, and if there is some theory of liability, if there is a valid cause of action, and if there could be a class action against whoever is responsible, if that's possible, then that class action, if meritorious, would proceed through this bill and proceed through the procedure. There'd be a check to see whether the class is properly certified by the judge. If it's a proper class, it would proceed forward. No meritorious claim will be stopped by this bill. Please vote red on the amendment. And
the gentleman from Swift.
Thank you, Mr. Speaker. Well, the problem is we don't know exactly where all of the invasive species come from. They've come from a variety of sources. Some have traveled through waterways, but others have been brought in, whether it's through boats, whether it's through different types of bait that have shown up in our state. And the problem is that for all of these small businesses that can be negatively impacted by this huge problem that's looming in our state, it's very difficult for each and every one of those, whether it's a small resort owner or whether it is a large resort owner or whether it is somebody who is a guide on one of the lakes taking people fishing, they might have a very difficult time addressing these challenges. And we know the problem is here. I guess, Mr. Speaker, would Representative McNamara yield for a question?
He will yield. Representative McNamara, or excuse me, Representative Falk.
Thank you, Mr. Speaker. Representative McNamara, I know in your committee we've been talking quite frequently about the issues regarding invasive species, specifically aquatic invasive species, and there have been some relatively large numbers thrown around, taxpayer dollars that will have to be appropriated to deal with some of these challenges. Does it not seem, I don't know, interesting that we would want to make it more difficult for those responsible or those liable for the spread and threat of invasive species in our state to actually be more likely to be brought to justice or to be held accountable for what is now a taxpayer cost?
The gentleman from Dakota, Representative McNamara.
Thank you, Mr. Speaker. Representative Falk, would you mind repeating the question?
The gentleman from Swift.
Thank you, Mr. Speaker. Representative McNamara, I'd be happy to. Is it fair for a business, a person, an entity who transports aquatic invasive species into the state, allows them to move freely throughout the state, let's just say it's a business that is dealing with minnows, and we find Asian carp in those minnows, every single one of those resort owners or any other small business that relies upon tourism and our outdoor heritage would have to go and work very hard to go and be compensated for any damages that are brought because of one unscrupulous or one neglectful operator. So would not it be fair to make it, why should we not hold that operator accountable or that entity accountable instead of asking the taxpayers of Minnesota to go and foot all of the costs of cleaning up somebody else's mess?
The gentleman from Dakota.
Thank you, Mr. Speaker, and Representative Falk. Actually, as you heard today, we're working on our committee to make it harder for people to ever run the risk of bringing Asian carp minnows into the state. So I think I look forward to your support and help as we try to stop the importation of those minnows into the state. So that's what we're trying to do to fix that problem. Thank you.
The gentleman from Swift, Representative Falk.
Thank you, Mr. Speaker. I understand that, Representative McNamara, but we're talking about taxpayer dollars, and here, when we're making it harder for those people who are affected to band together as a class, and we're limiting their ability to discover whether or not somebody's actually liable or at fault, we're going to have to pick it up as taxpayer dollars instead of actually holding the person who is liable accountable and getting just compensation. And so I don't understand why it is that we are trying to allow basically the bad operators, the people who are wronging individuals, companies, small businesses, the state as a whole, to have an easier ride. If there is a judgment, if there is a certification of a class, if there is an award by a jury, it's because somebody was found to have committed an action that was injurious to another person, another group, another entity, the state as a whole. And so what we're saying here is, go, all right, corporation or company or whoever, we'll give you an easier way. We can't prove that this creates any jobs. I really don't even understand why we're talking about it. But we're going to ask, in some of these bigger instances, for the taxpayers of Minnesota to pick up the cost, not hold the person accountable. We're going to say, taxpayers, it's your responsibility now. And we're going to let the person who created the problem or the people who are confounding the problem continue to get by, just a slap on the wrist, make it more difficult to actually go and get the justice that Minnesotans deserve. I would ask for a roll call on this vote, Mr. Speaker.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. Further discussion to the A4 amendment. The gentleman from Dakota, Representative Hansen.
Thank you, Mr. Speaker. Would the author of the bill yield?
He will yield. Representative Hansen.
Thank you. And I'm trying to understand where we're at here and thinking about a potential situation. Let's say you had a lake association where you had multiple property owners around the lake, and one of them, or maybe an outside corporation or individual, brought in a dock with zebra mussels on that dock. And the rest of the lake association or the property owners around that lake decided to take action. It appears that Representative Falk's amendment would allow that to go forward and that discovery and proceedings wouldn't be automatically stayed. I'm trying to think of this as a situation that probably is realistic out there, and can it would Representative Falk's amendment provide relief for that lake association that's trying to deal with an action that may have contaminated their lake with an aquatic invasive species forever?
The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Hansen, assuming for the sake of argument that your scenario could constitute the basis for a class action against whoever the tortfeasor or negligent party was in this hypothetical, the underlying bill would not prevent an action from going forward. Thank you. Please vote right on the amendment.
Further discussion to the A4 amendment. The clerk will take the roll on the amendment. The clerk will close the roll. Pepin votes no. There being 61 ayes and 71 nays, the amendment does not prevail. The clerk will give the bill its third reading.
Third reading, Senate File 149.
Third reading. Any further discussion? The gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Well, I've listened very carefully to what this bill is and what it's not, and listened to the chief author, and I know what it's not at this point. It doesn't create one job. There's not been one reference to a job that it creates. In fact, the chief author himself, who didn't know the answer at first but now knows the answer, is that there were only 8 class actions brought in Minnesota. He also didn't know how many had been overturned on appeal. The answer is not a single one. What it is, this bill is, I noted that the last bill that came up came from Alex's playbook, page 22. That was Representative Mazorol's bill from the Tort Reform Boot Camp. Now we've got this bill, which is from Alex's playbook on page 19. As Representative Winkler said, there at least ought to be a disclaimer, because these are all ALEC bills prepared and paid for by the Koch brothers and a bunch of giant corporations. That's really what ALEC is. Whether you like them or not, they're funded by the Koch brothers and a whole bunch of giant corporations. And at least put a disclaimer, because you're not accomplishing anything with this bill, as the chief author readily admitted. Who suffers, though? The victims of these cases. Representative Huntley alluded to the birth control cases involving the Dalcon Shield. You delay that discovery for months and months and months and months and years, and nobody knows what's going on. And people suffer for that. It delays in cases versus tobacco companies. It delays in cases versus the Toyota company over safety recalls. It's the victims who suffer for this. It's cases, and the most bald-faced example that nobody on the other side would even vote for, in cases involving Enron, WorldCom, Tom Petters, on behalf of class actions involving charities, nonprofits, elderly folks, regular middle-class Minnesotans who've been defrauded intentionally, who've been swindled intentionally, and it allows them for many months or years to delay the ability for anybody to know what was going on, so that they can continue to hide their swindles from the folks that have been victimized. If that's what you want to do, in a situation where we've only got 8 class action cases in the last year, then more power to you on the other side. But this is one bad, ugly bill. Please vote no.
Discussion to the bill. The lady from Olmsted, Representative Liebling.
Thank you, Mr. Speaker. Well, members, this bill has been discussed quite a bit, and we've had a lot of amendments, but we haven't heard a lot about the first part of the bill, which is the change of the limits on conciliation court. And I have a judge in my district who has talked to me many times with concern about this. She believes that the limits for conciliation court should actually be reduced and not raised. And we really didn't hear much debate about this today, and so I wonder if Representative Szymanski would yield to a question.
He will yield. The lady from Olmsted.
Thank you, Mr. Speaker. And Representative Szymanski, I know you started out the debate here by referencing this section, but unfortunately I'm not on the Civil Law Committee. I assume this was discussed. But obviously when we change the limits in conciliation court, what we're doing is changing who gets to come to conciliation court and who goes into the regular court system with their claims. And part of the concern is that when you take, you put more, what this does when you raise the limits, as this bill is doing, you're putting more people into conciliation court, and a lot of these cases can get complicated. They can be complicated cases, but in conciliation court you really don't have procedural protections. Another thing that you're doing is you are, and a good thing I guess, is you're reducing fees for people because it costs less to file in conciliation court than it does in regular district court. But I'd like to hear a little bit more from you, if you would, about why you've picked these numbers, or if they're, I don't know if they're yours, but why you think these numbers are good numbers. And secondly, I'd like to hear a little bit about the fiscal note on this bill. I assume that when we change these limits, we're reducing the fees that go to the court, so I'm assuming that there's a substantial fiscal note on the bill. Thank you.
The gentleman from McLeod, Representative Szymanski.
Thank you, Mr. Speaker, and thank you, Representative Liebling, for that question. The limits on the conciliation court, At one point, we had proposed a $15,000 maximum and a $7,500 on claims involving consumer credit. In the process of going through the Senate, the number has changed, and we have agreed to that number. But this bill was brought to me and supported both by the legal aid groups and the co-ops and small businesses that, the conciliation court limit had not been increased since 1994. And when you have a small business that needs to collect a debt from a consumer, they need to resolve that. And by raising the limit, we simply allow more of those cases to be resolved in conciliation court without the necessity of filing for district court proceedings and hiring attorneys to represent the parties. The fiscal note on this, which I have, that was prepared March 14th of 2011, showed a general fund total net savings of $78,000.
The lady from Olmsted.
Well, thank you, Mr. Speaker. And well, Representative Szymanski, I'm glad that the fiscal note isn't a problem here, but it raises some issues for me, your answer. And first of all, the numbers, you didn't give me any justification for these numbers except that other people think they're good numbers. That doesn't give me a lot of comfort. But especially given, as I told you, that a judge who I respect very much is quite adamant, and she does a lot of work with conciliation court, and she's really adamant that we should be lowering the limits, not raising them. But the answer that you gave me is that it's easier for businesses to act against consumers. So here we go again. You know, the problem is that not every claim is a justified claim. And there's already an imbalance of power. And if I'm not mistaken, a business goes into conciliation court with a lawyer. But a consumer does not have a lawyer. So the more you put into, when you put more of these claims into conciliation court, I think that you're basically leaving more consumers without any protection. They're just there to defend themselves. And I would dare say that many consumers are not as eloquent and as knowledgeable as the people on this House floor and would have a lot of trouble dealing with this. So, you know, again, I'm concerned about this. Certainly, I have many other reasons to vote against this bill. So, and I think most members, at least on our side, many members already have many reasons to vote against this bill. So this debate today isn't so much about conciliation court. But I did want to raise that because, as I told you, this judge has raised this to me many times over the years. She oversees these cases day after day, hundreds and thousands of these cases, and she really feels that we should be reducing these limits and not raising them.
The gentleman from Hennepin, Representative Mullery.
Thank you, Mr. Speaker. Representative Szymanski, you said that legal aid supports this. My understanding is that Ron Elwood from Legal Aid testified against it, but also on top of that, I worked many dozens of hours with Ron Elwood on the debt buyers legislation that we're trying to stop what's happening here in Minnesota now. Two of the biggest debt buyers agencies are in Minnesota, and on the East Coast and going through the Midwest, that's become a horrible thing that's happening there. Total fraud by companies. And one of the ways that they best get away with it is conciliation court. I've met with the court personnel in Hennepin County, including the chief judge, the head of the courts, some of the other people involved in this, and they were talking about the fact that they are going to try and, through the court system, require a lot of proof of these debt buyers. and their agencies that are ripping off people across the country. And by the way, if you aren't aware of that, the federal government has done studies, and there's just enormous amount of fraud going on that. This will totally aid that fraud to get a huge jump in Minnesota, because you're allowing them to sue in the court where there's no requirements or procedures that they're going to go through. There's no rules of evidence that they are. That's the way they're stopping these debt buyers in some of the eastern cities now, is by using the court system with their rules of evidence. You're abolishing the protections of the consumers, your people, my people. Now, that does not seem to be going the right direction, and I know you, Representative Szymanski, we disagree on some issues, but I think you try to do the right thing, so I really think you need to reconsider this bill and maybe send it back for some reworking on that.
Further discussion. The lady from St. Louis.
Thank you, Mr. Speaker and members. This is the first time I've spoken to this bill or any today, but I just wanted to talk a little bit about the class action portion of this bill. And many members, if not all, and Representative Wardlow, I'm sure you know too, that I come from an area of the state where there was a pretty famous class action. And it was a group of women who were being harassed and discriminated against at Eveleth Taconite. And Representative Wardlow, I'd go into details about some of the things that those women endured, but I think that it's probably too lewd to talk about on the House floor. But it was nothing that anybody should have to face at the workplace. And, you know, I'm looking at this portion of your bill that puts discovery on hold while the appeal on the class action is in process. And I think of what that would mean to women like that. You know, not only at that time does the company have time to destroy evidence and to intervene in the proceedings, but they have time to intimidate members of the class. And in the case where I come from at Eveleth Taconite, the women actually initially started the claim by filing a complaint with the Minnesota Human Rights Commission. And a week after she filed that claim, she went back to work and all 4 tires on her car had been slashed by her male coworkers. And you know, there's really nothing more intimidating than that when you finally start a court action against the men that are harassing you and assaulting you and discriminating you at work, that then all of a sudden now your tires are being slashed, you're being intimidated, you're being threatened. And they're threatening you to get you to drop the lawsuit and to drop your case. And you know, luckily in that case, the women, through all the threats and discrimination, were able to stick together, and eventually the class action did go forward. Most of those women had to leave their jobs. One of them was actually diagnosed with post-traumatic stress because of what she endured at work. Class actions are not something that Minnesotans take lightly. Something like that is not something that women take lightly, to have to relive those moments again and again in depositions, in front of attorneys from all parties, in front of the judge, in front of witnesses. You relive the trauma over and over again. And when those women get courage to finally come forward and to finally say that they want to be able to go to work and not live in fear, we should not continue to put barriers in front of them. Members, I would just ask you to take into consideration class actions like that have occurred in Minnesota and vote no on this bill. Thank you.
Further discussion on the bill. The gentleman from Dakota, Representative Wardlow. The gentleman from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. We want to give Representative Wardlow the courtesy of the final attempt to justify this piece of legislation. Members, it's easy to dismiss or to not really pay attention to a bill like this. You know, it can be lawyers debating lawyers and see who can work in the most Latin phrases or references to obscure constitutional provisions or court rules. But what it really is about is justice. And it's about who bears the risk in our society for harm. The purpose of a class action is to shift the responsibility to the company that's who's conducting its business, who's engaged in selling products, in marketing products, in convincing consumers to do something like buy their cigarettes, or to buy a law school review course, or to purchase a birth control device. The purpose of class action litigation is to put the people who put the products out there on the hook for the effects of their product, is to make them responsible for the effects of it. Now, and as Representative Simon talked about, it's easy to ridicule those kinds of cases because the harm to each individual person in some cases can be trivial. But there is no other mechanism for preventing companies from engaging in wrongful conduct, making massive profits with just a little sliver taken out from everybody else, from everybody. That's what class actions are designed to accomplish. They're designed to prevent that. Class actions are also designed to prevent major harm from happening to people who are dispersed over large areas. Again, we've talked about Delcon Shield. We've talked about tobacco cases. We've talked about a number of situations where companies are putting their own interests and their own reputations above the safety, the health, and the well-being of their customers. That's not good business. Class actions don't target good business practices. Class actions target harmful business practices that hurt the companies themselves. And members, the attempt here is to make this bill look like, well, this doesn't do anything. I mean, this just kind of clears away the debris of the bad cases in order to let the really good cases shine through. And, this isn't an ALEC bill. This is just, common sense. This is how we make Minnesota courts work better. Yet that doesn't really account for the fact that identical legislation has been introduced in almost every state. That the tort reform boot camp talking points say that it's about reining in the abuse of class action mechanisms. It's about encouraging class actions to serve their proper function. It says it's about deterring the use of class action where individual claims are appropriate. The same talking points that we've heard today, the same justifications about how this is just common sense reform for Minnesota, are being used everywhere in the country. And they're being used everywhere in the country to stop ordinary people from being able to get justice in the courts against companies that are doing the wrong thing. In a lot of other countries, they don't do it through lawsuits. A lot of other countries do it through intense regulation from government agencies. We have a comparatively light regulatory scheme in the United States compared to a lot of other countries. I know it's hard to believe, but in a lot of other places there is much greater government involvement in consumer goods and services that are being sold. So the alternative to an effective tort system is the heavy hand of government coming in to investigate businesses and make sure they're doing the right thing. I actually think our class action system serves our country and our economy much better because it focuses on the people who are doing harm. But this bill essentially kills class action lawsuits. And the reason is the people who have the resources are able to use delay to their advantage. It allows them to delay proceedings long enough so that the people who are trying to fight those companies run out of resources. They run out of money. If you don't have money to fight somebody, you don't fight him. That's the whole point of this. So it sounds, technocratic. It sounds lawyerly. It sounds like this is just common sense reform. But really, this is part of a national effort to prevent individuals from getting justice in the court system. And it's something that we, as legislators, I think should take seriously. And finally, members, there's no shortage of ability for courts to rein in fraudulent or wrongful or abuse of the legal system. The U.S. Supreme Court just recently ruled to limit class action lawsuits based on the type of class that's being certified. The court system deals with this. That's the whole point. The legislature is ill-suited to do it. And really what we're doing, members, is just making it more difficult for the average person to get justice in the court system. And yet again, Republicans are trying to rig the courts in order to benefit the very wealthy and the very powerful at the expense of everyone else.
Further discussion to the bill. Gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Members, Section 1 of the bill is good legislation, as is Section 2. With regard to interlocutory appeals, this is a common sense reform. This is not an ALEC model bill. I have no idea who funds ALEC. The fact that ALEC apparently, allegedly, is stealing my talking points is not relevant. But the real facts here is that this is a common sense reform in the context of lawsuits that have very high dollar amounts and that cost businesses extremely large amounts of money to defend. And many of these lawsuits are meritorious and many of them are not. But because appeal of the class certification order is so important, because oftentimes when you're appealing a decision in a class action case at the end of the process, at the end of the litigation, perhaps after a jury trial, because the appeal hangs so much and so often on that initial order, it makes sense to check whether the judge got the class certification right at the outset, especially since simply certification of the class will often scare a company into paying out a large settlement to avoid the risk of very large and unpredictable awards at the hands of a jury and continuing costs along the way in discovery. Because the bill allows for the stay of discovery to be lifted upon motion for good cause shown, we don't have any concern, and there should be no concern, that any evidence will be spoliated or anything will be lost. The delays that we keep hearing about are not as significant as you would be led to believe. There is some delay, but it is a justified delay to check whether that very important order the judge makes at the outset was correct or not. Because if it's not correct, to stop class actions that do not have merit from going forward. Those class actions that do have merit, those classes that have been properly certified, still go forward as normal, without any question as to whether it's a proper class. That whole question has been removed by the judge, by the Court of Appeals, reviewing the initial order certifying the class. So this just makes sense. It brings some balance to the system. It's fair to all types of litigants, from claimants, plaintiffs, to the defendants, regardless of type, business, individual, consumer, what have you. This is good common sense litigation reform that will create a better civil litigation environment in Minnesota. And of course, in Minnesota, according to the Pacific Research Institute, we have the ranked 47 in terms of tort laws that are unfair to defendants. So we have room to improve. This is one improvement that will decrease litigation costs for businesses, increase certainty, and therefore unleash money and the power of free enterprise to create jobs in our state. I urge a green vote. Thank you.
The gentleman from Hennepin, Representative Thiessen.
Thank you, Mr. Speaker. Coming off the shutdown last summer, Minnesotans would have expected their legislators to work on issues that matter this session. Instead, we've been bogged down with constitutional amendments and other bills like this one that do nothing to create jobs or to strengthen our economy. A week in, we are already off course, members, not addressing jobs in the economy or any of those issues that are important to middle-class Minnesotans. Who do these bills benefit? They benefit big corporations, multinational insurance giants, and special interests. That's who. After these bills are voted on, and it is, I think, relevant as we talk about the significance of this bill to note that there were 8 class actions last year in Minnesota that would have been affected by this bill. I would ask you to compare those 8 transactions with the 150,000 plus Minnesotans who are out of work. I think 150,000 Minnesotans ought to grab our attention more than 8 class actions. But after these bills are voted on, we're going on vacation. And as Democrats, we're going to be going around the state talking to Minnesotans about jobs and a middle-class economy. And I hope when you get home, you actually listen to your constituents and understand and hear the urgency that they have about restoring our middle-class families and getting people back to work. The people who live in your district are the ones you ought to be listening to when you go back home, and not these big corporations and special interests. That's what we're elected to come down here to do, to represent our constituents, middle-class families across the state. So when you go back on vacation, I hope you do what the Democrats are going to be doing and talk to your constituents, the people who live in your neighborhoods and in your towns, about what matters to them. And they are going to tell you, they're not going to tell you they're worried about 8 class actions. They're going to tell you, I'm worried about getting back to work and retaining my job. That's what our focus needs to be. And when we get back from vacation, let's get some urgency around that. Vote no.
The gentleman from Washington, Representative Dean.
Well, thank you, Mr. Speaker, and thank you, Representative Wardlow, for bringing this forward. I agree with you entirely, Representative Thiessen. We need to be focusing on jobs. And when you go back homes to your districts and talk to folks, talk to some of the people who would like to be working more hours per week, drive by some factories that maybe were open a few years ago that are closed today. Talk to some business owners as long as you're there. Ask them what the difference between opening a plant in Hudson, Wisconsin, and opening a plant in your town is. Ask them what the difference between opening a company in Sioux Falls, South Dakota, and opening a company in your town is. And they will tell you that the cost of doing business in those places is lower. The cost in terms of taxes is lower. The cost in terms of regulation is lower. The cost of time is lower because there's fewer delays. We need to become more competitive, people, and focusing on jobs is really important, and sometimes it's difficult. Sometimes it has to do with changing things that we've done the same way for a very long time. And we've got a very good series of bills we call Reform 2.0 that we've been working on for a long time. Part of that is regulatory reform. Part of it is agency reform. Part of it is tort reform, lawsuit reform. That's what we need to focus on. And actually, when you say that we need to be focusing on jobs, I know sometimes folks on the other side of the aisle like to say that if we're doing a jobs bill, we're spending the government's money on something, and that somehow equates into jobs. And sometimes it does for a short period of time here or there. But we got to focus on real job relief in the state of Minnesota. That is private sector industry, Main Street jobs, the jobs that built this state into the great state that it is and that it will continue to be if we have the strength to make some real change. Not fake change, not spending money change, but real change to the way we do business in the state of Minnesota. Thank you, Representative Wardlow, for bringing this common sense jobs initiative forward. I'd appreciate a green vote.
The gentleman from Hennepin, Representative Thiessen.
Thank you, Mr. Speaker. Representative Dean, do you know of any single business that relocated to Hudson, Wisconsin, or to South Dakota because of those 8 class action lawsuits that went to the court last year or any year before that? The answer is no. I'm not asking you to yield because you know that that's the case. The fact of the matter is this bill doesn't create any jobs, and you can't point to any job that it creates. And so don't go on with this myth that that's the case, that what's going on, to justify your willingness to serve big corporations and special interests. Let's stand up for the middle-class families of this state instead of those big corporations and special interests, and actually focus on the facts.
The gentleman from Washington, Majority Leader Dean.
Representative Thiessen, perhaps you're asking job creators across the state of Minnesota to suspend belief in what they see. And what they see is jobs moving from our state to adjoining states. They see states in California, they see jobs in California that should be moving to Minnesota that are going to Texas. They see jobs in Eagan, Minnesota that are going to Hudson, Wisconsin that should be staying here because of taxes, because of regulation, and in many cases, yes, because of the cost of doing business, because of the court system in the state of Minnesota. The cost of jobs in Minnesota is higher. You may not like to admit it, but part of the problem has to do with lawsuits, and we need to reform that. Other states are getting it. If we don't keep up, they will continue to eat our lunch with jobs. We need to start fighting for jobs for all Minnesotans.
The gentleman from Hennepin, Representative Thiessen.
I agree we need to be fighting for jobs for all Minnesotans, but your bill doesn't do it, and you didn't answer my question because the answer is no. Of course it's no. This bill is not going to cause having this law in place is not going to either keep any business or send any business anywhere else. Let's focus on bills that actually get people back to work, support our businesses, and one of the best ways we can support our businesses is actually getting money in the hands of middle-class families, which you squeezed with higher property taxes last year, which you squeezed with higher tuitions last year, which you squeezed with any number of bad policy decisions, borrowing from our kids with the way you settled the budget last year, stealing money from our schools with the way you balanced our budget last year. All those things take money out of middle-class families' pockets, and when they don't have money in their pockets, they can't go and support their local businesses. We need to actually get at the underlying cause of this, build a strong middle-class economy, and not carry the water for big insurance companies and big corporations.
The gentleman from Washington, Majority Leader Dean.
Well, thank you, Mr. Speaker, and I do think that we need to focus on middle-class jobs. And you know what? If you're getting $20 an hour, you're doing pretty well. If you're getting $50 an hour, you're doing even better. A lot of the arguments that you bring forward, Representative Thiessen, are brought forward by the Trial Association. I understand that lawyers really don't like a lot of these reforms. Sometimes I understand their arguments, sometimes I don't understand their arguments. But these are common sense reforms. And it's true that the trial lawyers in the state of Minnesota don't like to change our laws very much. I understand that, I get that, I understand how this place works. But if we are serious about rebuilding Main Street, Minnesota, we're going to have to keep up with Main Street, Wisconsin, and Main Street, South Dakota. Right now, we're not doing that because a lot of the status quo arguments that have gone on here. I would appreciate one small step forward to make jobs a little bit easier to create in this state. Appreciate a green vote. Thank you, Mr. Speaker.
Further discussion? The clerk will take the roll on the bill. The clerk will close the roll. There being 72 ayes and 59 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 373. The clerk will report the bill.
Senate File 373 on the calendar for today, unofficially engrossed and reprinted for the House to include committee amendment, an act relating to civil actions.
The gentleman from Dakota, Representative Wardlow, to the bill.
Thank you, Mr. Speaker. Members, now this is the third in our series of lawsuit reform bills to create jobs in Minnesota and improve Minnesota's civil litigation climate and draw employers and entrepreneurs to our state. This bill doesn't deal with frivolous lawsuits. This bill is a little bit different. It changes the statute of limitations in Minnesota, the general statute of limitations for a number of different kinds of causes of action, and reduces the time period during which claimants may bring suit from 6 years to 4 years. It's that simple. Brings Minnesota more in line with other states. This does not take away anyone's right to any remedy. All it does is reduce the amount of time by 2 years during which a person needs to bring suit. What does that do? That encourages expeditious commencement of litigation. It encourages claimants, plaintiffs, to bring their claims forward sooner so that they do it before memories fade, before documents are destroyed or lost, before evidence goes missing. That means we have better proceedings in court and fairer outcomes for everyone. It also increases certainty for defendants and makes it easier for businesses to plan for and calculate litigation and liability risks going forward. So it reduces costs for Minnesota's businesses in that regard. By increasing certainty and by eliminating the possibility or reducing the possibility for form shopping from by plaintiffs that are coming from states with shorter statutes of limitations than our current statute. This bill is good for the business climate and will create a more efficient civil litigation system that leads to fairer outcomes and more jobs. And urge a green vote on this bill. Thank you.
There is an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 373. The unofficial engrossment as follows. The amendment is coded 569.
The gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Will the Chief Author please yield?
He will yield. Representative Atkins.
Thank you, Mr. Speaker. Representative Wardlow, we just identified maybe 2 or 3 frivolous cases that have been brought in year 5 or year 6 of the statute of limitations period. One of the sorts of cases that you're looking to get rid of.
Excuse me, Representative Atkins, I do not believe the Chief Author has the amendment. Is that correct? Okay, we will pause for just a second until we get the amendment passed out.
Representative Atkins, if I could ask
the gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Atkins, if you could repeat your question, I'd appreciate it. I thought it was regarding the amendment, but I don't think now that it was.
Gentleman from Dakota, Representative Atkins.
And this, Mr. Speaker, Representative Wardlow, this goes directly to what your bill is trying to accomplish. You're trying to eliminate cases from being brought in years 5 and year 6. You want to reduce the time in which folks can bring their cases from 6 years down to 4 years. Just identify for me a couple of cases that would be impacted by that. Frivolous cases or whatever you're trying to eliminate that have been brought in year 5 or year 6.
Gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Thank you for that question, Representative Atkins. Of course, it's difficult. I can't name any particular cases that are stale and would be brought in years 5 and 6 that this bill would affect. That's not the point. The point here is that 6 years is a statute of limitations that is too long and is out of line with other states. By reducing it to 4 years, we bring it back into line with others, more into line with other states, and we encourage people to bring their claims sooner. It doesn't cut off anyone's right to a remedy. It encourages expeditious resolution of litigation.
Gentleman from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Members, just heard what Chief Author said. He doesn't even have any cases that he can point to. It's kind of like the class action bill we just heard about. There are no cases. We're the 11th best litigation climate in the country. He's pointed in his class action bill that we had 8 class action cases last year. Would have made no difference to pass that bill or not. Now we're talking about eliminating claims in year 5 or year 6. He's got no cases that he can point to at all. So what this does, if we're really going to try to create jobs with this bill, it mandates an insurance premium reduction. It's what we did with the auto insurance bill when we did reform there back in the 70s. It's what we did with work comp reform, is that there was an expectation that insurance premiums would go down. This requires a reduction in insurance premiums. Please vote yes. And I'd like a roll call, Mr. Speaker.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. Discussion to the Atkins amendment. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. To the amendment, the market should determine insurance premiums. Please vote red.
Further discussion. The clerk will take the roll. The clerk will close the roll. There being 61 ayes and 69 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Falk moving to amend Senate File 373. The unofficial engrossment as follows. The amendment is coded 607.
The gentleman from Swift, Representative Falk.
Thank you, Mr. Speaker. I'd first like to request a roll call on this.
A roll call has been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Swift.
Thank you, Mr. Speaker. Members, we keep talking about limiting people's rights, limiting their rights to justice, limiting their rights to the courts. And I think it's a clear opportunity for a little reminder about the Seventh Amendment to our Constitution, which is the right to trial by jury, and for the rights of an individual to be made whole if they have been wronged. And so, the purpose of this is, when we're looking at changing some of these legal proceedings, is to make sure that we remember that each and every individual, every person, every American has fundamental rights that shall not be infringed. And I strongly disagree that if your rights are infringed and you do not bring an action within the stated period of time, that doesn't mean that you were not wrongly infringed, or that you are not able to be made whole, or you should not, or you shouldn't be made whole by the person who caused an injurious action to you. And so it's just important to remember that above and beyond all of this, we have constitutional rights that are inherent to each and every one of us, specifically trial by jury. And so this action to limit the rights of individuals for the benefit of corporations, for the benefit of the privileged elite, to go and enshrine more wealth in the hands of a few, it's clearly not in the interests of how our country values the rights of individuals. Right there in the Constitution, very simple. Members, I would ask for your support.
We have an amendment to the amendment. The clerk will report the amendment to the amendment.
Winkler, moving to amend the Falk Amendment as follows. The amendment is coded 309.
The gentleman from Hennepin, Representative Winkler, to the amendment to the amendment.
Mr. Speaker, first I'd like to request a roll call.
There is a roll call being requested to the amendment to the amendment. Are there 15 hands? Seeing 15 hands, there will be a roll call on the amendment to the amendment. The gentleman from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. Members, I don't know if everyone has been following this, but in recent years the U.S. Supreme Court has pushed the concept of corporate personhood to a ridiculous extreme. The Citizens United decision 2 years ago changed the nature of political campaigns in our country, certainly most to the detriment of Newt Gingrich so far, according to reports in Florida, because you can now have unlimited spending in campaigns from corporations who have amendments or have First Amendment rights. In a number of states, including Minnesota, people are beginning to pursue the possibility of changing the way courts interpret the definition of a person. And since we're talking about common sense reforms, it's hard to think of anything more common sense than a person is a person. And so, members, I'd ask for a green vote on the amendment to the Falk Amendment to make clear that in Minnesota we think people are people and corporations are legal entities created by law and not somebody that you can go have dinner with.
Discussion to the amendment to the amendment. The gentleman from Swift, Representative Falk.
Thank you, Mr. Speaker. Members, I would just urge a green vote for this. I think, I feel very strongly that people are people and corporations are not people, although there is an individual in our state currently who has made the common claim that corporations are people. I think Mitt Romney made a stop down in Eagan today, but he doesn't hold the values of most Minnesotans. I wouldn't expect most people, most Americans, to feel that corporations have equal rights as people. It's not the case. I don't know when the last time a corporation smiled or a corporation bled. So, people are people, corporations are people. Vote green.
Further discussion to the Winkler Amendment to the Falk Amendment. The clerk will take the roll on the amendment to the amendment. Clerk will close the roll. There being 58 ayes and 70 nays, the amendment to the amendment does not prevail. Excuse me. Representative Atkins votes aye. Now to the amendment of the gentleman from Swift, Representative Falk.
Thank you, Mr. Speaker. I'd like to withdraw the amendment.
The amendment has been withdrawn. There is an amendment at the desk. The clerk will report the amendment.
Simon moving to amend Senate File 373, the unofficial engrossment as follows. The amendment is coded 373A2.
The gentleman from Hennepin, Representative Simon.
Thank you, Mr. Speaker and members. This amendment would carve out an exception for unlawful trade practices. Because when it comes to a statute of limitation in particular, it's important that we understand what this law really does. This law, unlike the one that we discussed earlier in terms of consumer protection, protects consumers from merchants of any kind who don't tell the truth about what it is that they're selling, whether it's the type of good or service that they're providing or the quality or anything like that. Whether you think you're ordering the grade A roofing materials and it's really grade F or some other transaction, the key thing about this in actual real-world experience is sometimes it does take years for people to figure out that they've been ripped off, to figure out that what they thought they bought isn't what they really bought. And the reason that we currently have a 6-year statute of limitations in Minnesota law as to this particular statute is just that. I'm sure every one of us in this chamber can think of a time when we bought something, a good or service, and didn't find out until sometimes many years later that we didn't actually get what we thought we had gotten. That's the whole premise behind the 6-year statute of limitations in many of these consumer protection laws. And so what this bill would do, if it passed and was signed into law, is it would shrink the ability of consumers like you and me and all of our constituents to go after folks who have wronged them because they didn't give them what they thought that they were buying. So this is a chance for everyone here to stand up for Minnesota consumers, for everyday people, and to make sure that we understand the real world when it comes to buying and selling, and that sometimes you don't know for a very long time what it is that you've really purchased. That's the reason we have it in current law, and that's the way it ought to stay. So I urge a yes vote on the amendment. And I ask for a roll call, Mr. Speaker.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call discussion to the gentleman from Hennepin's amendment. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Members, I urge a red vote on this amendment. There is no good policy reason to carve out unlawful trade practices from the general statute of limitations. So please vote red.
Discussion to the amendment. The gentleman from Hennepin, Representative Mullery.
Thank you, Mr. Speaker. Representative Wardlow, I can't believe you just said that there's no reason to carve out unlawful, illegal trade practices or consumer fraud. Wow. So if somebody's out intentionally committing fraud against the people in my district, you say that's not any different from anything else somebody happened to bump into them. That's what you're saying. And obviously, most of us don't agree with you. I think if you came over to my district and talked to regular people, I don't think there'd be anybody on your side over there. So I thought this bill was bad, but then when I heard the attitude, I understand where you're coming from.
Discussion to the Simon amendment. The clerk will take the roll. Clerk will close the roll. There being 59 ayes and 69 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Murphy and others, Murphy E. and others moving to amend Senate File 373, the unofficial engrossment as follows. The amendment is coded 373A8.
The lady from Ramsey, Representative Murphy E.
Thank you, Mr. Speaker, and again, thank you for calling me a lady. Mr. Speaker and members, I'd like to request a roll call.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. Representative Murphy.
Thank you, Mr. Speaker and members. From time to time, we engage in debate about data privacy and medical records on the floor of the House and in our legislative committees. It's an important issue for us. We put a premium on the protection of privacy here in the Minnesota House of Representatives, and this bill erodes that protection by reducing the length of time an individual can bring a claim against a provider who releases medical records without the patient's authorization or falsifies a medical record. As a provider, I'm not sure there should be any statute of limitations related to unauthorized release of medical records or the falsification of medical records. But I know for certain that this body should not shorten that time frame allowed a person to seek redress if their privacy has been violated. I'd appreciate your support in my efforts to protect the privacy of medical records. Thank you.
Discussion to the Murphy amendment. The gentleman from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Again, members, the intent of this bill is to encourage claimants, plaintiffs, to bring forward their claims in an expeditious manner before memories go stale, before evidence is lost. So, in fact, if we care about privacy, if we care about health records, we want those claims to be brought forward sooner rather than later. Because we don't want to have litigation in this important area based on stale claims. We don't want to have bad precedents set because the precedent is the result of a claim that was brought in where witnesses couldn't remember what was going on and what have you. And also, it is important to keep the statute of limitations intact and not to carve out exceptions in this matter except for very, very good policy reasons, because doing so increases certainty for litigants. And when you increase certainty, you increase the ability of businesses and regular Minnesotans to look at the risks of liability going forward and plan their lives and run their businesses. So please vote right on this amendment.
The lady from Ramsey, Representative Murphy E.
Thank you, Mr. Speaker and members. I think this is a very, very, very good policy reason. Protecting the privacy of medical records is a very, very good policy reason for carving out this exception in this bill that you proposed, Representative Wardlow. You know, the thing is, if a provider has released someone's records without an individual's authorization, how the heck are they going to know that? And why would we shorten the window of time for them to discover that? I think shortening that time reduces an individual's opportunity to discover that. It's a very good policy reason to carve out this exception, and I'd appreciate your support.
The lady from Hennepin, Representative Pepin.
Mr. Speaker, would Representative Murphy yield for question?
She will yield. Representative Pepin.
Representative Murphy, can you remind the body what is included in the Minnesota Health Records Act, what records we're talking about exactly? I don't have time to look it up.
The lady from Ramsey, Representative Murphy.
Thank you, Mr. Speaker and Representative Pepin. The citation is 144.291. I happen to have it on my computer screen, and it's a long definition. It covers a wide array of individual providers and facilities. Thank you.
Further discussion to the amendment. The clerk will take the roll on the amendment. Members, please vote. Clerk will close the roll. There being 60 ayes and 67 nays, the amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Nelson moving to amend Senate File 373, the first unofficial engrossment as follows. The amendment is coded 373A17.
The gentleman from Hennepin, Representative Nelson, to the amendment.
Thank you, Mr. Speaker. And I'd like to start out by asking it for a roll call.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. The gentleman from Hennepin.
Thank you, Mr. Speaker. And what this amendment does is that, again, it carves out an exception for people who are seeking redress when they've been alleged to have obstruction of their right to have workers' compensation. And many times, I'm looking at the statute here, what it talks about is discharging of employees who have been tried to claim workers' compensation or who are not allowed to go back to work after they've been healed as best as they can, and then they're not hired back. So what this is going to do is going to help Minnesota injured workers, and by cutting this down from 4 years or from 6 years to 4 years, just re-injures an injured worker, and it takes away their rights and their ability to seek redress and to continue employment. So this is a good exception. We should put this in there. We should be protecting our injured workers, because if they're not taken care of under the workers' compensation system, they end up falling back in our laps, and they become a state expense. It's a good bill. Please vote green.
Discussion to the Nelson amendment. Seeing no further discussion, all those in favor, a roll call being requested. The clerk will take the roll on the Nelson amendment. Clerk will close the roll. There being 59 ayes and 68 nays, the amendment is not adopted. There's an amendment at the desk. Clerk will report the next amendment.
Knuth moving to amend Senate File 373, the first unofficial engrossment as follows. The amendment is coded 373A19.
Call the member from Ramsey, Representative Knuth, to present your amendment.
Thank you, Mr. Speaker. First, I'd like to request a roll call vote.
Representative Knuth requests a roll call. Seeing 15 hands, there will be a roll call on the amendment. Representative Knuth.
Thank you, Mr. Speaker and members. I ask that you support my amendment. I don't want to see the statute of limitations move from 6 years to 4 years, but there's a few particular areas that I think where it shouldn't be moved, and this is one of them. And this is allowing a wage discrimination case based on Minnesota's equal pay for equal work law to be brought forward within 6 years, not within the 4 years as proposed by the bill. And members, I think it's important for us to note that we have not yet reached equal parity, equal pay for equal work. Women earn on an average of less than 80 cents on the dollar of what men earn, and clearly this is an area where we all want to strive for equality in this state, and I think keeping the statute of limitation at 6 years for these particular kinds of cases will help Minnesota reach the goal of equal pay for equal work. When we're in tough economic times and have such large differentials in wages between people generally, but especially with women, it's important to make sure that people going to work are bringing home a paycheck, and this amendment will help to make sure that happens, and I'd ask for your support.
Discussion to the Knuth amendment. Discussion. Seeing no further discussion, a roll call being requested. The clerk will take the roll on the amendment. The clerk will close the roll. There being 59 ayes and 68 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Atkins moving to amend Senate File 373. The first unofficial engrossment as follows. The amendment is coded 572.
Call the member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. I'd first ask for a roll call, please.
Representative Atkins requests a roll call on the amendment. Seeing 15 hands, there will be a roll call on the amendment. Representative Atkins.
Mr. Speaker, I've practiced for a little over 20 years now, and I'm hopeful that this might be one that Representative Wardlow thinks is a good idea, and then I just withdraw my request for a roll call. The lawyers that I've talked to, and in my own law practice, the small businesses, which is to whom this amendment would apply, small businesses feel with a 4-year statute of limitations, they are forced into litigation at that 4-year mark. Small businesses do not want to be in court. To give them, in fact, Representative Wardlow, I had an amendment that would have actually extended it for small businesses out to 10 years. The last thing that a small business wants to do is be in court. So it would simply allow that small businesses would be able to still have a 6-year statute of limitations, have 2 more years in which to try to settle their claim. If we fail to do this, honestly, the only beneficiary of a 4-year statute is the insurance companies. If you're pro-small business, you'll give them 2 more years to try to resolve their claim and avoid going into litigation. With that, I'd appreciate your support. I will turn it over to my friend and colleague, Representative Wardlow. If you give me the nod that this seems like a good idea, then I'll withdraw the request for a roll call, and it would be a good thing, at least according to the small business lawyers that I know.
The member from Dakota, Representative Wardlow, to the Atkins amendment.
Thank you, Mr. Speaker. To Representative Atkins' amendment, Minnesotans for Lawsuit Reform has 62,000 members through trade associations, 145, I believe, different businesses, trade associations, regional chambers of commerce. They all want this bill. They all want the 4-year statute of limitations. So the business community, including many small businesses all around the state, are asking for this reform. Why? Because it will increase certainty for businesses. It will make sure that claims are brought before evidence becomes stale, encouraging results that are more fair, and decreasing liability costs and risks for businesses, improving Minnesota's business competitiveness and growing jobs, unleashing the power of free enterprise. It's one step in the direction of job creation, but an important step that thousands, literally thousands of businesses of all sizes across the state are asking for. So please vote red on this amendment.
Discussion. Seeing no further discussion, a roll call being requested. The clerk will take the roll on the amendment. The clerk will close the roll. There being 58 ayes and 68 nays, the amendment is not adopted. Seeing no further amendments at the desk, the clerk will give the bill its 3rd reading.
3rd reading, Senate File 373.
3rd reading. Discussion to the bill. Discussion. The member from St. Louis, Representative Moline.
Thank you, Mr. Speaker. And Representative Wardlow, will you yield for a question?
He will yield. Representative Moline.
Thank you, Mr. Speaker. And Representative Wardlow, I may have missed this in the discussion, but I was just wondering if you could tell me how long the 6-year statute of limitations has been in place in Minnesota.
The member from Dakota, Representative Wardlow.
Thank you, Representative Moline. That's a very good question. I believe we've had this general statute of limitations at 6 years since before statehood, I think, or at least since statehood, for over 150 years, or around that. So it's a very old statute. It needs to be updated, frankly, because the way we communicate in Minnesota now, as opposed to 150 years ago, is very different. Witnesses communicate by email. Communications are much faster. Travel is much faster. Things happen at a faster pace. A 6-year statute of limitations made more sense when we didn't have automobiles, before we had telephones, before we had email and computers. But now, it's time to update this very old statute so that we can continue the policy of the statute, so that the policy behind the statute, to make sure that there is repose, because statute of limitations are also called statutes of repose for defendants, so they don't have to worry about claims that are stale coming back to haunt them after a long period of time that they can't defend because they don't have any witnesses around that remember what actually happened, because they can't find the documents or the emails or what have you. Retaining emails for 6 years is a long time. So it's time to update this statute, and by doing so, we increase certainty for businesses and create jobs. So thank you.
Member from St. Louis, Representative Moline.
Thank you, Mr. Speaker, and thank you, Representative Wardlow. The information I have says that Minnesota's had a 6-year statute of limitations since 1841. So that's 171 years, actually. So yes, it is prior to statehood. So, we should take this pretty seriously, that we're changing 171 years of precedence here in Minnesota. Some pretty drastic changes. I don't know that our legal system is so broken that we need to change 171 years of precedence. And more so, will Representative Wardlow yield for another question?
He will yield. Representative Moline.
Thank you, Mr. Speaker. And Representative Wardlow, oftentimes when I file cases on behalf of my clients, we serve the defendant's attorneys first, and then we don't go ahead and file it with the court. And some of that is because filing fees have gotten very high in the state of Minnesota. And some of that is because we hope that we can reach a settlement before we have to file it with the court, so we can avoid the costs of court and we can avoid that burden on the court system. And so oftentimes we serve the opposing party and then we enter into settlement agreements, and oftentimes we come to an agreement before we even have to file with the court. So I'm wondering, Representative Wardlow, have you taken into consideration that lowering the statute of limitations from 6 years to 4 years will actually force a lot of parties into court because they'll be bound by a shorter statute of limitations and that they won't be able to have time to reach a settlement?
The member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Moline, for that question. Thank you. It's a good question. I haven't considered it until now, but now that I do think about it, of course, in Minnesota, litigation commences at the time a complaint is served on the defendants. So when you effect personal service of the complaint on the defendants, then the lawsuit commences. The statute of limitation begins to run at a different time entirely. It begins to run when the incident or breach, what have you, giving rise to the cause of action you're suing for occurs, which could be some point in time prior to when you need to commence the complaint. You need to commence action by service on the defendants before the limitation period comes to an end. So I don't think it has any effect whatsoever on pushing people. It won't push people into court because you commence an action just by service on the defendants. You just need to commence the action by service on the defendants within 4 years after the incident is giving rise to the cause of action instead of 6.
Member from St. Louis, Representative Moline.
Thank you, Mr. Speaker. And, Representative Wardlow, you know that the statute of limitations is always in the back of the mind of every attorney. And, in fact, we have an ethical obligation and requirement to, even if we're not going to take a case, to inform what our potential clients, what the statute of limitations is, because we can be subject to legal malpractice if we don't do that, and so that they then lose their claim because they don't file their claim in time to beat the statute of limitations. But, I think that what really has been shown here just now is that there are all sorts of considerations that haven't even been thought of. And we are changing 171 years of precedents, which is not something to be taken lightly. And these are real people being affected by this. These aren't frivolous claims. These are elderly people that have been defrauded, who are oftentimes targeted because of their age. And, this is not something to be taken lightly. And, Mr. Speaker, will Representative Wardlow yield for another question?
He will yield. Representative Moline.
Thank you, Mr. Speaker. And Representative Wardlow, we've heard not only on this bill but the two prior bills that these are jobs bills, that they're going to create jobs, and that this is good for the business climate. I was wondering if you have some statistics to back that up. Maybe if you could tell us what the unemployment rate is in states that have a lower statute of limitations, but more importantly, how many jobs your bill is estimated to create in Minnesota.
The member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Moline. Of course, it is impossible to determine with exact certainty how many jobs a particular bill will create. Government doesn't create jobs, though. Entrepreneurs, businesses, job creators, obviously, create jobs. Minnesotans in the private sector create jobs. What we're doing here, I can tell you, we do have statistics, for example, from the NERA Economic Consulting, a study for the U.S. Chamber Institute for Legal Reform, October 26, 2011, that tort costs, the effect of the legal environment on tort costs in Minnesota, impose an excess burden of $516 million on the state's economy in a year. And by moving our tort and civil litigation system closer to if we were able to move it to the optimal position. Now, I'm not claiming that all these bills do that, but they're steps in the right direction, and they move us closer to an optimal civil litigation system. We would see an increase in employment, according to this study, of between about 0.5% and 1.2%. That is thousands and thousands upon thousands of jobs. So, this bill is a common sense reform. It encourages expeditious resolution of claims. People bring their claims, are encouraged to bring their claims to court or litigation, or then to mediation, arbitration, what have you, sooner, before memories become stale and documents are lost, so we have fairer results. And reduce costs for businesses is a step in the right direction. It will create jobs, and together with the other three bills, the two bills that have passed the body, and the bill to come, if there is another bill to come, I believe, together, it's a significant step towards that, perhaps as much as 1.2, or who knows, maybe a little bit more, increase in employment in Minnesota.
Member from St. Louis, Representative Moline.
Thank you, Mr. Speaker, and thank you, Representative Wardlow. Last session I was the only member in the body that sat on both the Judiciary Committee and the Jobs Committee. This session I'm no longer on Judiciary. I've moved to State Government, and I see that your bill has only gone through Judiciary and Civil Law. I don't know that there's a member that sits on both Civil Law and Jobs. There could be. But I think more importantly is that we've heard from you and a number of members on your side of the aisle that this is a jobs bill. And I think that, it's unfortunate that the Jobs Committee hasn't heard this bill. It sounds like you have some numbers at least in front of you, and I think it would be of interest to members that sit on the Jobs Committee so we can, actually see how many jobs this is going to create in Minnesota. And normally I wouldn't do this, but just, because we've heard that this is a jobs bill and it's going to create so many jobs, Mr. Speaker, I'd like to make a motion to re-refer this bill to the Jobs Committee.
Representative Moline moves
and I'd ask for a roll call.
Moves to re-refer Senate File 373 to the Jobs Committee. She has requested a roll call. Seeing 15 hands, there will be a roll call on the motion. Discussion to the motion. I apologize. The Jobs and Economic Development Finance Committee, I'm assuming you meant Representative Moline?
I'm sorry, Mr. Speaker.
You wanted to re-refer the bill to the Jobs and Economic Development Finance Committee, correct?
That's correct, Mr. Speaker.
Discussion to the motion. Representative from St. Louis, Representative Moline, to your motion.
Well, thank you, Mr. Speaker. I think I sort of already said why I was making the motion, but this entire day, and we've been here for a few hours now, we've discussed that these are jobs bills, but most importantly, this was touted as a jobs bill last session and again this session, that it's going to substantially improve our business climate here in Minnesota, and that it's going to somehow create jobs by, I guess, limiting people's ability to get redress for their injuries. So because of that, and because Representative Wardlow, who is the author of the bill, has numerous times said that it's a jobs bill, I think that it's only fair that it's vetted in the proper committee, which is Jobs and Economic Development.
Discussion to the motion. Discussion. Seeing no further discussion, the member from Hennepin, Representative Winkler, to the Moline motion to re-refer.
Mr. Speaker, I wonder if the author of the bill would yield to a question.
He will yield. Representative Winkler.
Mr. Speaker, to the question, this is relevant to this motion, I think, more than any place else in the debate, and that is, and I'm going to guess, probably this motion is not going to prevail. So since we're going to have to find out some of this information on the floor, I wonder if Representative Wardlow could explain to us what other reforms he thinks are necessary in Minnesota in order to move us from number 11th in best business climate for litigation to number 1 or 2 or 3. What else do we need to do? What else is on the agenda? What else is coming up? If this is going to be a real jobs push to reform litigation, if moving from number 11 to number 3 is going to do it, what else do we need to do?
The member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Winkler, you're referring to the ranking in the U.S. Chamber survey, correct? Yes. That survey is based on opinions of general counsel in various companies, and that's about it. It's not worth all that much. Having said that, let's just assume for the sake of argument that we're at number 11. It would be good to be number 1, because that means we will be gaining jobs, growing our economy, and putting people back to work in the private sector. But in fact, the Pacific Research Institute has a study that looks a little bit more carefully at tort laws, tort inputs, tort laws, the way court systems are set up. Minnesota ranks 47th. We have the 3rd worst ranking, according to that study, for our tort laws in terms of how unfair they are to business defendants. So there's a lot of room for improvement. These 4 bills are steps in the right direction. They're all very good. They're going to create jobs. And if you want to sit down sometime, we can talk about all sorts of other reforms to further enhance the business climate, like related to tort reform, taxes, what have you. But just because there are other things that maybe we should consider doing doesn't mean that we shouldn't do things that are good and are before us now.
Member from Hennepin, Representative Winkler.
Well, Mr. Speaker, actually that's one of the excuses for poor legislating that we hear all the time. And it was similar to the statement from Representative Hoppe earlier, which is, oh, this sends a signal, as though passing laws and affecting people's rights comes down to sending signals or a step in the right direction without any assessment of cost and benefit. I'm sure Representative Banyan is outraged that we don't have a statement of public benefit to accompany this bill, which weighs costs and benefits. We do know that we are limiting people's rights to get justice, including women to get equal pay for equal work, and bringing pay discrimination. You've specifically said we shouldn't have a 6-year statute, we should have a shorter statute, because we want to protect businesses from having women get equal pay for equal work. Now, it's interesting that Representative Hoppe likes to talk about all the businesses that you talk to in the state, and you know that tort reform is so important because they all say tort reform. And you talk about this Minnesotans for Tort Reform or whatever the name of that organization is, and you say it's made up of all these businesses. Yet you denigrate the study from the Chamber of Commerce talking to corporate general counsels who are the ones who manage litigation and would have a much better understanding of the litigation climate in the states than a libertarian think tank institute based in California. So I think you go by the American Chamber study. And the question is, what else do we need to do? You keep making this argument. We hear about taxes all the time, too. Well, this is a step in the right direction, but you never tell us how far you want to go. You never tell us what the end vision is. We know that we've had 100 plus years of 6-year statute of limitations for the court system in Minnesota. We know we're number 11 on the list of best states for litigation and court costs for business in the country. So we know we've done it for a long time. We know we're doing it pretty well. But by this legislation, we're sending signals or we're taking steps, but you don't tell us the rest of the story. You don't tell us how far you would go. You don't tell us what's coming next. And we end up voting on bills because it's a step, it's a gesture, it's a signal, it's a posture. You need to tell us, if you're going to talk about jobs, you're going to need to tell us what else we need to do, because I think this bill will do nothing for jobs. Nothing. Except perhaps for the jobs of executives at insurance companies who are hoping to make their bonus in 2012. For those jobs, this bill does a lot. So, Representative Wardlow, if we're not going to go to the Jobs Committee, I wish you could tell us what else we need to do. Or is this just one little sliver and we don't really want to do the real work of the legislature to improve the climate? If you say we're going to make it better, I think you should actually offer something besides just a casual opinion or a signal or a symbol. You have to actually offer some substance.
The member from Martin, Representative Gunther.
Thank you, Mr. Speaker. Members, this is just another barrier to growth and jobs in Minnesota. We have high taxes for commercial and industrial. We have high work comp. All barriers to growth. You compare us with other states surrounding us, and we're very high. High unemployment insurance. Cumbersome permitting. High commercial and industrial property taxes. Another barrier to growth is we need this reform to entice businesses, because we don't have any money in the Jobs Committee. I know the other side's answer to job growth is a very, very big bonding committee. Very big bonding bill. That's not the answer. The answer is let's eliminate the barriers to growth and create more jobs to entice businesses to want to come to Minnesota. And I don't need this bill in my committee. Thank you.
Seeing no further discussion, a roll call being requested on the Moline motion to re-refer Senate Files 373. The clerk will take the roll. Clerk, close the roll. There being 59 ayes and 68 nays, the motion re-referred does not prevail. We are on the bill to itself. The member from Hennepin, Representative Mullery, to the bill.
Thank you, Mr. Speaker. And I think everybody should know, Representative Wardlow, that not only is this protecting people against who commit fraud against regular consumers and other people, the regular people in my district and probably in all of yours, including your own district, but having represented hundreds of small businesses as well as a lot of just regular people on the street, I think everybody should know that what this really helps, and Representative Wardlow, you're in a law firm, this is going to help drive up attorney's fees for them, for small businesses, for regular people. I happen to have practiced back before the new rules, where you are basically at the mercy of the courts, let's say, as far as your procedure once you get the lawsuit going. Nowadays, since the courts took over, in talking to administrators, they realize, and the courts realize, they tell me, that attorneys' fees have had to go up because they speed up things a lot, so that attorneys have to do a lot more work on cases rather than letting things be done gradually. And so that drives up the attorneys' fees. So by shortening the period here, when there's when you can file a lawsuit, you're actually shortening the period when things can be worked out with getting into the court system that drives up the attorney's fees quickly. So according to the people that I've talked to within the system, they understand and they say that's true. So this actually helps drive up attorney's fees for small businesses and small consumers. I just think everybody should know exactly what they're doing.
Discussion. The member from Hennepin, Representative Thiessen, to final passage.
Just a point of personal privilege, if I might, Mr. Speaker.
State your point of personal privilege, Representative Thiessen.
Thank you. And it just really is a question relating to an email that was sent to DFL representatives from Representative Cornish about a crime bill, and always was attached is a picture of an empty gallows. And I'm just wondering why that was only sent to DFL representatives, and what the point of sending not a crime bill but a picture of empty gallows would mean.
Discussion to the bill. The member from Hennepin, Representative Downey.
Yeah, thank you, Mr. Speaker. I can't speak with any detailed experience on the particulars of the bills we've heard, but a broader discussion has emerged and actually some fairly strong attacks against these bills as though they have absolutely nothing to do with jobs. And I'm remembering back to one of our first hearings as a small business caucus last year, and a representative from the NFIB came in and mentioned three priorities. One was the cost of health care, another was the regulatory environment, and another was the liability and the tort environment. And I remembered asking him, I think it was after the session, what can we actually do on the tort side of it, on the liability side of it? And he gave me a couple of things, and I didn't really even know how to proceed because I'm not a lawyer. So I'm actually really thankful that Representative Mazorol and Representative Wardlow have brought these bills forward here today. And when you think about the impact of liability on businesses, I want us to especially think about the impact of liability and the incumbent costs on small businesses for trying to manage their liability. And we've talked a lot about how Minnesota may be the 11th best liability environment, tort environment in the country. I think it's important to remember that we are by far the worst country in the world, and we're competing internationally. In fact, the costs of litigation in our country are 2 times the rest of the industrialized world. So being 11th in the U.S. probably means we're 2 times or close to 2 times the rest of the industrialized world in the costs here. And that burden is borne exceedingly on small businesses. When you look at the entire $250 billion plus cost of liability in the United States, 83% of that is cost on businesses that make less than $10 million a year. They represent only 22 million of our total, or 22% of our total GDP, but they bear 83% the cost of liability. And why is that? They're typically very small. They oftentimes can't afford the insurance that mitigates the risk in the first place, protects them from the risks, limits the costs as they come forward. And I draw your attention to the sheet that I handed out. 27% of the tort costs of small businesses come right out of the pocket of the businesses. They aren't borne by insurance. This is stuff that hits direct on a small business. The owner, the innovator, the guy who invented the new product, the woman who's actually their best sales rep, unfortunately gets distracted with all of this. So to sit here and claim that this has no positive impact, reforming these issues has no positive impact on business in Minnesota, I think the evidence is directly to the contrary. And I know the other side of the aisle is convinced that unless state government is spending some money and finding a way to create jobs through their bonding bills or some other great government program by extracting the money from a private sector employer first and then redeploying it through the means of government, that we're not creating jobs. I'd argue that this bill and this series of bills today is not only important on the face of it and for what they do, but we've got a governor that's been running around for over a year now advertising Minnesota as a state for which he wants to raise taxes, grow the cost of government, and unionize an entire industry sector via executive order. That's the sales brochure that our governor is running around advertising nationally and internationally. So you may scoff at the fact that we need to send signals to our business community that we're serious about making Minnesota more business friendly, but I'm here to tell you that these bills will have an impact. And if they do anything even marginally to improve the image of Minnesota in our native business community and those that are thinking about starting a shop here, then these bills have indeed served an important purpose, both in practical reality and in improving our image.
Member from Hennepin, Representative Winkler.
Thank you, Mr. Speaker. I appreciate the opportunity to respond directly to Representative Downey. He hasn't had the privilege of probably negotiating as many business contracts as I have. And in my work outside of here, working on behalf of small businesses, growing businesses for the last 8 years, I have never negotiated a contract involving any significant amount of money between a company and a vendor, or between two companies with a forward-looking business transaction in which insurance requirements were not included. They are always included. And in fact, specific dollar amounts are included. So typically it will say probably that both parties are required to maintain insurance policies of $1 million to $5 million. And those costs and those requirements are not based just in the United States. I've negotiated international contracts. It's true in Great Britain or the UK. It's true in Asian contracts, whether it's South Korea or Japan or Singapore. They're all the same. They all require insurance. And it's not just for American courts. I just negotiated a deal where we took over a business from Great Britain, and it was a contract between a Swiss company and a UK company, and they were required to have insurance. In fact, more insurance than the typical contract that we negotiate here. So by limiting the by shortening the statute of limitations, by enacting these so-called tort reform bills, you're not helping those businesses. They all are going to require the same insurance amounts. I guarantee you that no company I've done business with outside of Minnesota has looked at Minnesota's statute of limitations and said, oh, well, you're in Minnesota, that's a 6-year statute, so therefore you need to have a $2.4 million policy instead of a $2 million policy. Never happens. It probably has never happened. Businesses have insurance for a whole lot of reasons. And the insurance companies who have to step in and defend those businesses when something has gone wrong are the ones who are pushing this legislation. It isn't the businesses. The cost of insurance is not dependent on the litigation or the liability environment of our state at all. Those rates are not related. The amount of insurance that we need is unrelated. It's not just not related to state law, it's not even related to the total amount that we spend on litigation in this country altogether. It's the same across international boundaries. Your argument doesn't make any sense. Members, what we're doing is limiting the rights of people to get justice in court. We are not helping business in any way by doing this. We are helping influential insurance companies try to retain bigger profits, and instead of actually passing those profits on to consumers or to businesses, we're letting those insurance companies hold on to all that money as well. That's what you voted for today. I suspect that's what you'll be voting for shortly, and it's not based on reality. It's based on a fiction. It's based on a myth that is well-funded from those insurance companies who will benefit from it.
Member from Nicollet, Representative Morrow.
Well, thank you, Mr. Speaker. Mr. Speaker, I was inclined to just move on to the vote, but I do have a question. And Representative Wardlow, I'm not asking him to yield. He can correct me if I'm wrong, but I do hope Representative Wardlow is listening at the moment. I assume that he's been quoting the Pacific Research Institute. I'm not sure because I just couldn't hear the entity you've been citing statistics from. I'm not asking you to yield. If I'm wrong, you can correct me and tell me what your source of your study information was earlier. But Mr. Speaker, I'm rising in response in part to what Representative Downey said. Representative Downey, I would remind you of what Governor Dayton and DFL offered in terms of a jobs plan for Minnesota. Is bonding part of it? Certainly public works, infrastructure, roads, bridges, rail, are all important to our business community. I know I attended a meeting at Greater Mankato Growth where business leaders said to me, Terry, you want to help private industry create jobs? Fix Highway 14, fix Highway 169, fix the rail lines that we use to ship our products to the coast and around the globe. So certainly infrastructure was part of the message we were getting about jobs and helping the private sector create jobs. That's part of the DFL jobs plan. But you know, Representative Downey, that's not all. Let's talk about the new jobs tax credit. Let's talk about helping veterans. Let's talk about helping the unemployed, excuse me. Let's talk about helping recent graduates with tax credits that are given to employers who hire these folks. Let's talk about the Help Minnesota Compete for Business expansion, $10 million in additional funding into the Minnesota Investment Fund. And I believe it's Representative Gunther who's talked to me about this being an important fund for Minnesota. That's part of the DFL plan for jobs for Minnesotans. I'm now going to turn the page. What else is here? Well, we've got the Fast Track Initiative, helping underprepared adults succeed in the workplace by integrating basic skills education and career-specific training in fields where there's high demand. Representative Downey, I had an opportunity to travel around the state during the interim, visiting with community colleges all across Minnesota. And what I was hearing was that employers were coming to our community colleges saying, we need people to be trained for the jobs we have. And Representative Downey, I'm going to be proud to stand next to President Keith Stover at South Central College tomorrow and talk about jobs training, talk about job retraining, helping people have the skills that our employers so desperately need. It's much more than bonding. Don't denigrate public works, Representative Downey, because those public works at our colleges, at our universities, on our roads, on our bridges, on rail, all support the economy and job creation, plus the tax credits for helping employers hire and helping Minnesotans get the job retraining they need. There's a great deal of the jobs plan, and that is what Minnesotans expect of this legislature, and we should be turning to those items of legislation as soon as possible.
Member from Stearns, Representative Gottwald, to the bill.
Thank you, Mr. Speaker. Well, Mr. Speaker and members, to this bill, and really, Mr. Speaker and members, to others that have been on the floor, I've sat here all this afternoon and I've listened to really kind of a tale of two caucuses. We got one caucus that accuses the majority caucus of not really dealing with jobs at all, that tort reform really is not an issue, that lawsuit reform doesn't impact businesses. Believe us, people, it really doesn't. So it has nothing to do with jobs. We're just trying to hurt people. And so that's what I hear from the left side of the aisle, and that their idea for jobs creation is about taking tax dollars and spending them. Another stimulus package, another withdrawal from the taxpayers to be spent in ways that government decides, growing government. That's their answer to job creation. They're going to take that on the road, by the way, members. They're going out over the next couple of days. They're going to tell everybody how more government spending is going to create the kind of sustainable job creation Minnesota needs. And then I listen to these bills, simple proposals. 6 years I've been here in the legislature almost, listening to reasonable ideas for bringing Minnesota in line in the area of lawsuit reform. Just a little bit of relief. And my friends on this side of the aisle, I would encourage you, go out and talk to the small businesses who create 80% of the new jobs in this country. Go out and talk to them and ask them about lawsuit and tort reform, the costs that it brings to them, and whether or not that impacts job creation. Just go ahead and ask them like we have, over and over and over again, and it comes back every time as a high priority. So here we are today trying to pass a few reasonable reforms, and all we hear from the side protecting, you want to talk about special interests. I don't think you want to go there, my friends on this side of the aisle, the left side of the aisle. The special interests of the trial lawyer lobby that have been preventing reasonable tort reform for year after year after year after year, blocking it, protecting it. Why? Because of their own special interest. Not on behalf of victims, but on behalf of the big rewards that they get out of representing people. I mean, let's at least be honest about that. So, members, I'm going to encourage you to vote yes on this bill because these are reasonable reforms. They're not out of line. They try to bring Minnesota in line with neighboring states. They save money for employers so that they can, in fact, create jobs. It is about jobs, members. Vote yes on this bill.
Member from Olmsted, Representative Quam.
Thank you, Mr. Speaker. Fellow members, today I hear a lot of droning on and belittling of these bills. I hear people asking, what is enough Where do you want to go? While I do not hazard to speak for others on this subject, I do have an idea of where I want us to go, where I think my constituents and the citizens of this state need us to go. We need to go to a place where they've got the jobs they need and deserve and the prosperity that they deserve. Not every single bill is going to get us there. There is no silver bullet. And what we're trying to do with these bills and other bills is take those little steps down the path to change us from where we're at to where we need to be. And that's why I support this bill and the others we've talked about today, because I know we've got to take the baby steps here and there to get us there. And I ask that you support this bill. Thank you.
A member from Grant, Representative Westrom.
Mr. Speaker, members, I'd like to respond to what Representative Moline was talking about with the settlement of cases. Representative Moline, the one thing that is also possible in many cases is what they call tolling the statute of limitations. If the parties are trying to work out a settlement and year 4 is coming close, they can agree to extend the statute of limitations or not raise it as a defense. The courts aren't going to throw it out unless the defendant raises the statute of limitations as a defense, and if they've agreed to it ahead of time to try to work out a settlement, that is another option that can go forward. And so, Representative Moline, that wasn't part of your discussion. That is an option that can be pursued. In talking to many attorneys that represent cases that we focus on the injured, personal injury cases, but there's others that also are affected by shortening the statute of limitations. Generally speaking, there's better justice served the sooner you can bring a case into suit, or the sooner you can bring it together so you can discover the facts and find resolution. And so that's what this bill does today, is tries to speed up that resolution. It is consistent with what several other states have for a statute of limitations. Some of you were here probably 12 years ago when we actually extended the statute of limitations for medical malpractice from 2 years to 4 years. So in those cases, we are already at 4. And the discussion revolved around how long is too long. Many of us agreed that 2 years was too short for a case of medical malpractice. Representative Van Dellen spearheaded that issue back in the late part of the 1990s. But we do have other statutes that are in place that are 4 years, which is what this bill is purporting to do. And so, members, there are ways to extend the statute beyond 4 years if you are close to a settlement, as Representative Moline was questioning the author about. And so that is an option that's also can exist today or exist under this new bill that would pass. And I just wanted to share that with members, so that is an option that can go forward and also encourage settlement. It's ultimately going to bring faster resolution for the injured party if they prevail by having to file their suit sooner. And of course, there are the scenarios where maybe somebody didn't discover their injury in time and the statutes have run. That goes on today also with the 6-year statute of limitations. So this is ultimately a balancing act of at what point do we wipe the slate clean and at what point do we ensure justice for everybody. This bill is going to continue to ensure justice. It's not taking away somebody's right to sue. They just need to enact and react to the situation sooner than later. And so 4 years is very consistent with what several states already do, consistent with what we have on other statutes, and I'd urge members to vote for this bill.
The member from Olmsted, Representative Liebling.
Well, thank you, Mr. Speaker. I just had to stand and comment on the discrepancy or the conflict between this bill, which is cutting the statute of limitations, and the last bill that was just passed in this body, which makes lawsuits drag out. The one on class action suits that say that you can suspend the action and wait in the middle of a lawsuit. So which way is it, members? I mean, I think the thing that unifies these two bills, it's not about whether people whether memories will be lost or all of those good public policy things that we really should be considering. No matter what you say, if you think it's okay to make class action lawsuits go on and on and on and drag out because the defendant wants to appeal the class, then why would you think that now on this bill that we should shorten the statute of limitations to make lawsuits go faster because memories are lost and all of that? You can't have both. And the thing that holds these two together is, again, that this is a bill that helps the powerful defend themselves against the weak. And that is the wrong way to go. So members, vote no on this bill.
Discussion to the bill. The member from Hennepin, Representative Thiessen.
Thank you, Mr. Speaker. Just quickly, I know we're focusing on Wisconsin and Iowa and South Dakota and North Dakota. Representative Wardlow, do you know what the statute of limitations for contracts is in those states under current law?
You're asking Representative Wardlow to yield. He will yield. Representative Wardlow.
Thank you, Mr. Speaker. Representative Thiessen, could you repeat the question?
Yes.
Representative Thiessen.
Thank you, Mr. Speaker. Do you know what the statute of limitations for contracts in Wisconsin, Iowa, South Dakota, and North Dakota is?
Member from Dakota, Representative Wardlow.
Thank you, Mr. Speaker. Representative Thiessen, I don't have right in front of me the statute of limitations of those states, but 32 states have general statutes of limitations that are at 3 years. So one half what we have here in Minnesota at 6 years. And neighboring states, on even the chamber legal liability index, are above us in terms of climate for businesses and costs of the tort system. So nearby states, neighboring states, have better business climates in terms of tort costs and civil litigation than we do. And this bill simply moves us into line with 32 other states that have shorter statute of limitations than even what this bill proposes.
Member from Hennepin, Representative Thiessen.
Thank you. Well, Representative Wardlow, that wasn't entirely accurate about the chamber, but we'll let that go. It's 6 years in our neighboring states, those places that have this great climate. Their statute of limitations for contract is 6 years. Same with debt collection. Same with a number of statute of limitations. They are where we are. So if your argument is we need to compete with those neighboring states, that doesn't make any sense. If your argument is that is what creates a great business climate there as opposed to here, it doesn't help us whatsoever. The bottom line here is there's no reason for us to take away we're not going to speed up lawsuits by doing this. You're just taking away the rights of people to file those lawsuits. And in those 32 other states, I imagine there's actually a discovery rule in place, which we don't have here in Minnesota for a lot of these cases. So you're comparing apples to oranges. We need to have an honest, factual discussion of these things, not an ideological discussion. And we actually need to get back to talking about creating real jobs. The DFL has already put out, I believe right now, 9 very specific proposals, which don't, Representative Gott, will go out and spend a lot of money, all of them. The bonding bill, that's borrowing money, but I don't think anybody on that side of the aisle should be complaining about borrowing money this year when you balanced the budget last year by issuing tobacco bonds that borrowed $650 million. It's going to cost us $1.2 billion to pay off for one-time spending. If we're talking about a bonding bill, at least we're talking in long-term investments that are going to be with us for a long time. So you're a little bit on shaky ground complaining about bonding this year at all based on what you did last July in borrowing from our schools and borrowing the tobacco bonds. We have very specific programs to get proposals to get people back to work. We laid out 3 more of them today that I think if you actually looked at them, you'd find that they're actually something that you could support. They're not spending a lot of money, if any money at all, and it just gets people back to work now. That's what Minnesotans need.
Further discussion. The member from Hennepin, Representative Simon.
Thank you, Mr. Speaker and members. I just passed out some articles on the floor, 2 from the Star Tribune, actually all 3, I think, from the Minneapolis Star Tribune from last year. And the point I think they make, and the point I want to make, is somehow when we discuss these tort reform bills, we never seem to discuss business-on-business activity in the courtroom. It's always about individuals suing businesses. Here we have one headline, Thrivent sues lenders for massive fraud. That's Minnesota's own Thrivent. Then we have another headline, Murdoch firm to pay Insignia, a Minnesota company, $125 million. And then third and finally, St. Jude wins $2.3 billion in trade secret suits. When you hear many of the backers of tort reform talk about it, they don't talk about these lawsuits because they're happy to have these lawsuits. So am I, in the sense that if a Minnesota company recoups what it's owed, if a Minnesota company is a plaintiff in a lawsuit because it's been wronged, if it's been defrauded, it's Thrivent claims, if there have been trade secret violations like St. Jude claims, or if there's some other commercial dispute like Insignia claims, and they get paid because a jury decides that they've been wronged, why is that a bad thing? I would argue it isn't. But somehow when it comes to individuals, whether it's soldiers and sailors, whether it's farmers, whether it's everyday consumers, then suddenly we want to hem them in, we want to restrict them, we want to cut off their ability to sue, whether by shrinking the statute of limitations or, as I suspect we're going to see later on, decimating attorney fee provisions, which give them rights and abilities that they otherwise wouldn't have. Suddenly we're trying to hem them in. But when it comes to businesses, far and wide, using our court system, justifiably, by the way, to make sure that they're made whole, that isn't a problem. So when you hear these statistics, like Representative Downey and others talked about, in terms of the costs of lawsuits in this country, it's only one side of the ledger. There's another side of the ledger, too, which is there are businesses who actually received money because of lawsuits in our courts. And none of those statistics, not a single one, talks about the net effect. It's all one side of the ledger and what the payouts are, without realizing that Thrivent and St. Jude and Insignia and other companies, big and small in Minnesota and elsewhere, are on the other end, too. Businesses bring things to court. And businesses, often Minnesota businesses, win big because they've been wronged in a big way. And I just hope, as we're voting on these, and I think we all know how we're going to vote, that we realize that most of the time when we're talking about tort reform, it's really only a one-sided discussion. We're talking about hemming in and limiting individuals, everyday people, and not businesses. And I think that's unfortunate. I think there needs to be more balance in this debate.
Seeing no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 71 ayes and 56 nays, the bill is passed. Its title is agreed to. Next bill on the calendar today is Senate File 429. The clerk will report the bill.
Senate File 429 on the calendar for the day, unofficially engrossed and reprinted for the House to include committee amendments, an act relating to civil actions.
Call the member from Hennepin, Representative Mazorol, to present your bill.
Thank you, Mr. Speaker. Members, Senate File 429 relates to the award of attorney's fees to a prevailing party. As a general rule in Minnesota, each party is responsible for taking care of their own attorney's fees, but there are some exceptions in statute, about 300, that apply here to allow attorney's fees to be awarded to a prevailing party in specific types of cases. What this bill does in subdivision 1 is it provides that in those cases pertaining to money damage awards, while allowing the judge to still have discretion in the award of attorney's fees, it states that the judge must take into consideration the amount of fees to be awarded as they may relate to the damage award actually made. Subdivision 2 of this bill relates to an offer of judgment. That is a process by which a defendant is able to offer judgment to a plaintiff sometime during the course of litigation, and that judgment, the plaintiff has the opportunity to either accept or reject the damages that are awarded or that are offered in that offer of judgment.
If the plaintiff, the claimant, should decide to reject that offer of judgment and continue with litigation and later recover less than is actually than has been offered, then the attorney's fees to be awarded in that case under this statute would be limited to the attorney's fees incurred up to the point that the offer was made. Mr. Chair, I move passage of Senate File 429.
There is an amendment at the desk. The clerk will report the First Amendment.
Atkins moving to amend Senate File 429, the unofficial engrossment as follows. The amendment is coded 578.
Call the member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. I'd like a roll call, please.
Representative Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the amendment. The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. Representative Mazorol, what this amendment would do, there is a very specific statute, Minnesota Statute 325F.71, that applies to seniors and disabled persons who have been intentionally defrauded. Sometimes it's only for $500, sometimes it's for $100, sometimes it's for $1,000. Under your bill, it would make it virtually impossible for them to get an attorney to represent them. So this accepts or exempts the application of your bill in cases where a senior or a disabled person under Minnesota Statute 325F.71 has been intentionally defrauded. At least let them still be able to bring a claim against the party that intentionally defrauded them. With that, I'd appreciate a green vote.
Discussion to the Atkins amendment. Discussion. The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins, thank you for offering this amendment. The provision, as it's intended to be changed here, would just require that the judge, in any case awarding attorney's fees, needs to take into consideration the factors of the award of judgment. This bill does not in any way limit what the judge might award. It does not prescribe a certain weight to be given to those factors. It does not prescribe a formula. It just says that the judge must take into consideration the size of the award when making the award. Again, the judge retains discretion in making the size of the award on the money damages of the case.
Discussion. Seeing no further discussion, the member from Hennepin, Representative Loeffler, to the amendment.
Thank you, Mr. Speaker and members. I think we need to take this amendment very seriously. And respectfully, Representative Mazorol, the people who are most likely to be intentionally defrauded, who are seniors and who are people with serious disabilities, are people of extreme poverty. That's the only way oftentimes they can qualify for the medical assistance that allows them to get the wheelchairs and the assistance that they need to bathe and be fed, to have their daily needs met. Many of them are seniors who, because of increasingly frail health, are of limited ability to really focus on the papers that are put in front of them by that really nice, friendly, socially warm person who showed up at their door and was concerned about them and offered them a product or a service, and they signed on the dotted line. Many of these are socially isolated, quite honestly. They're just delighted to have the attention if it seems like someone who's really caring for them. We've seen way too many stories in the paper. That's not to say most seniors and disabled people are easy victims, but we all know there are people who are. And I would seriously ask all of you to join me in supporting this amendment. Thank you.
Discussion. The member from Hennepin, Representative Mazorol.
Mr. Chair, Representative, I think as we go through discussion of this statute, we need to keep in mind that certainly these are the types of parties that we do want to assist, and it's exactly because of this that an exception is made in statute to allow the award of attorney's fees. Remember that the general rule is that parties pay their own fees. That is retained. What is retained is that in these cases of exception, attorney's fees are still to be awarded, and in fact a judge has discretion in the amount of that award.
The member from Hennepin, Representative Mullery.
Thank you, Mr. Speaker, and Representative Mazorol. First, after seeing your bills today, thank you for deciding at the last instant not to join our law firm. This, as having been represented the Minnesota Senior Federation legal panel for many years, having represented numerous litigants on the consumer fraud statute cases, Representative Loeffler really points out an important fact here is you are really taking away, what you're doing is taking away the rights of regular, ordinary citizens to go to court because they just can't afford the attorney's fees. And you're saying that all this is say the judge can decide on it and consider it. Representative Mazorol, I assume that you've been in court on some consumer cases where these are maybe not. I have, and the judges already take into account, so there's no need if it was just what you're saying. But you look also, this gets into the issue of if an offer is made. And so that is hugely inhibiting on the attorney and the consumer that doesn't have enough money to go ahead with the case. You're completely ignoring that part of your statute. So basically, just once again, these bills are just hitting the regular people in my and your district, and I assume that you have a lot of people too that aren't really rich and can afford to go to court and pay the attorney's fees up front, can pay the attorney's fees no matter what happens on the case. And plus, in many cases, these also would be asking for maybe injunctive action against somebody from ripping off other people, and so they're, even if they win, they're not getting money. So this is just, it's just a bad bill, but to really go after seniors is even worse, and disabled.
Seeing no further discussion, a roll call being requested, the clerk will take the roll on the amendment. Clerk will close the roll. There being 58 ayes and 68 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Mullery moving to amend Senate File 429. The first unofficial engrossment as follows. The amendment is coded 589.
Call the member from Hennepin, Representative Mullery, to present your amendment.
Thank you, Mr. Speaker. And members, you claim you're supporting small business and that National Federation of Independent Businesses are supporting your bills. Well, I actually was the one that carried and gotten written up in the National Federation of Independent Business for getting through the Equal Access to Justice Act a few years ago. It's an act that's very important to them. And so basically now you're taking away part of their rights under that act for NFIB. So I would hope that you would at least exclude the effect on NFIB from your bill.
Representative Mullery. You still had the floor, Representative Mullery.
Sorry, Mr. Speaker. Roll call.
Representative Mullery has requested a roll call. Seeing 15 hands, there will be a roll call on the amendment. Discussion to the Mullery amendment. Member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Mullery. No rights are being taken away by this bill. It's directing that the court take into consideration the size of the award when making its discretionary award of attorney's fees, and there's no intention here to favor one type of party over another, including small business. I speak and urge a no vote on the amendment.
Discussion. The member from Hennepin, Representative Mullery, to your amendment.
Thank you, Mr. Speaker. Representative Mazorol, that isn't completely correct because part of your bill also gets into the offer of judgment issues, so it does take away the rights from small businesses.
Seeing no further discussion, a roll call being requested. The clerk will take the roll on the amendment. The clerk will close the roll. Representative Green votes aye. There being 57 ayes and 69 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Khan moving to amend Senate File 429, the unofficial engrossment as follows. The amendment is coded 579.
I call the member from Hennepin, Representative Khan, to your amendment.
Mr. Speaker, I guess I'd like a roll call vote.
Representative Khan requests a roll call. Seeing 15 hands, a roll call will be called on the amendment. Representative Khan.
Mr. Speaker, one of the things that happens is that we seem to be continually undoing things that we just did. And this section, which I say that this section does not apply to attorney's fees awarded pursuant to Section 149A.98. Now, I'm not sure that members of the House really remember what Section 149A.98 is, but will Representative Erickson yield to a question?
She will yield. Representative Khan.
Representative Erickson, do you happen to remember House File 128, which was enacted in 2005?
The member from Mille Lacs, Representative Erickson.
Thank you, Mr. Speaker. Representative, I might have a vague recollection.
The member from Hennepin, Representative Khan.
I'm a little surprised because I think you were the chief author of that bill. And what that section says, now enacted into law, is that a funeral provider who prevails in an action for the recovery of fees for services provided under this chapter may be awarded reasonable attorney's fees incurred in the action, if provided that the funeral provider otherwise complied with the requirements of this chapter in connection with the provision of these services. Now, I'm surprised that you've forgotten it, because I remember you giving very emotional statements about the small town funeral providers and what the problem it would be when they didn't get attorney's fees. So, you know, just in terms of trying to protect the actions of my colleagues, I would like to really protect that bill, that law that you worked so hard at. And so what this section just says is that this section does not apply to attorney's fees awarded pursuant to Section 149A.98. And I hope that you will stand and support me with this, and I hope that your colleagues will also have the same interest in supporting what you worked so hard over in 2005, and also support me in this amendment.
The member from Hennepin, Representative Mazorol, to the Khan amendment.
Mr. Speaker, members, I urge a no vote on this amendment.
Discussion. The member from Hennepin, Representative Khan, to your amendment.
Well, I guess now that I've informed Representative Erickson about what the amendment is, I would like to hear. I know we don't get to ask people how they're voting on an amendment, but I would like to hear her talk about how important she thought the law was that she passed in 2005.
Discussion.
So I'm asking Representative Erickson to yield.
Representative Khan
for that point.
Representative Erickson will not yield. Representative Khan, you have the floor.
Yes, I certainly understand why she wouldn't want to yield. I think I wouldn't want to under the circumstances also. So I guess I'm finished.
Discussion. Seeing no further discussion, roll call being requested, the clerk will take the roll on the amendment. Clerk will close the roll. There being 54 ayes and 71 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Moline moving to amend Senate File 429, the unofficial engrossment as follows. The amendment is coded 598.
Call the member from St. Louis, Representative Moline, to your amendment.
Thank you, Mr. Speaker and members and Representative Mazorol. I want you to really seriously consider this amendment. I think that it's really important. It's pretty narrow. And, you know, I'm not just doing this to hold up the bill because I have to drive home tonight, which is 200 miles away. So, you know, I'm bringing this before the body because I do think it's an important addition to the bill. And my amendment simply says that this section does not apply to attorney fees awarded in workplace sexual harassment. It's specific to only sexual harassment occurring in workplaces. Under Minnesota statute, sexual harassment is unwelcome sexual advances, requests for sexual favors, sexually motivated physical contact, or other verbal or physical contact or communication of a sexual nature. And 3 times that can happen when submission to that contact is required to obtain employment, submission to that contact is required to basically keep employment or to get a raise, or that conduct substantially interferes with someone's employment. And the reason that I think that that's so important in this case is because we're talking about really the ability to pay attorney's fees. So if you're being sexually harassed at work, a lot of times before you would bring that claim, you would maybe quit your job. Or maybe you would refuse to submit to the sexual advances or the physical contact that's being ordered by your supervisor or another coworker, and you would be fired from your job. So a lot of times we're talking about women that no longer have a job and they're bringing a claim of sexual harassment against their employer, oftentimes under the Minnesota Human Rights Act. And so I think that when we're talking about the ability to pay for these women, this is specifically important here that we make sure that, you know, they're not barred from bringing their claims basically because they can't afford an attorney. The language here that has to take into account the amount of damages when assessing the attorney's fees would basically bar small claims. You know, not all women would have to quit their job or leave their job, but some may be bringing a small claim for sexual harassment and not be able to afford it. And so I'd ask you to take into serious consideration amending your bill to include an exception for sexual harassment in the workplace. You know, I don't think that sexual harassment claims are necessarily bad for business. Godfather Pizza would probably disagree with that, but I do think that sexual harassment is really bad for business. And more importantly, I don't think we want to be a state that prohibits women who have had to leave their jobs, who have gotten fired because they're being sexually harassed by their supervisor. I don't think that we should be putting up barriers for them going to court on those sexual harassment claims. And so, Mr. Speaker, I'd ask for a roll call, too, on this.
Representative Moline requests a roll call. Seeing 15 hands, there will be a roll call on the amendment. Discussion to the amendment. The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Moline, thank you for that amendment. I urge a no vote on this amendment, and in fact, I believe Chapter 363A has its own provision for attorney's fees in these types of cases. Urge a no vote.
Discussion to the amendment. Seeing no further discussion, a roll call being requested. The clerk will take the roll on the amendment. Clerk will close the roll. There being 56 ayes and 69 nays, the amendment is not adopted. There's an amendment at the desk. The clerk will report the next amendment.
Atkins moving to amend Senate File 429. The first unofficial engrossment as follows. The amendment is coded 591.
Calling the member from Dakota, Representative Atkins, to your amendment.
Thank you, Mr. Speaker. I have a slight modification on line 1.5 for the Chief Clerk. After the word discrimination, insert the words or wrongful termination.
Representative Atkins modifies his amendment. The Chief Clerk will report the author's modification of his amendment.
Atkins moving to modify his amendment to Senate File 429 as follows. On line 5 of his amendment, after discrimination, insert the words or wrongful termination.
Representative Atkins, to your modified amendment.
Thank you, Mr. Speaker. I'd request a roll call.
Representative Atkins requests a roll call. Seeing 15 hands, there will be a roll call on the amendment. The member from Dakota, Representative Atkins.
Thank you, Mr. Speaker. This amendment was introduced with respect to the prejudgment interest statute. I'm now offering it with respect to this one. You've had 4 hours to reconsider, folks. This bill is far from a job creator. It's a job killer. What this does, if we don't adopt amendments like this one, it provides businesses with a license to fire people and not have to face ramifications for that. This bill, if it isn't amended, is absolutely devastating to people with wrongful termination cases. What this amendment specifically addresses is a situation that on Monday we had a former Senate staffer who said he's hired a law firm to pursue a wrongful termination against the Minnesota Senate and the Minnesota Legislature. 2 days later, we're taking up Senate bills that would devastate that former employee's claim. No other business in Minnesota can do this. You all keep saying this is for Minnesota businesses. Minnesota businesses don't get to change the rules midstream, and yet that's what Representative Mazorol is asking us to do today, to the devastating impact upon a former Senate staffer and the claims that he is in the process of bringing against the state of Minnesota. That's wrong. This amendment would address that, and I'd appreciate a green vote.
Discussion to the amendment. The member from Hennepin, Representative Mazorol.
Mr. Speaker, Representative Atkins and members, I urge a no vote on this amendment. There are approximately 300 statutes that relate to this particular bill. I urge no.
Discussion. The member from Dakota, Representative Hansen.
Mr. Speaker, I rise for a parliamentary inquiry.
State your point of parliamentary inquiry, Representative Hansen.
Mr. Speaker, if the House of Representatives has retained an attorney against potential litigation, how can we vote on this bill?
Representative Hansen, that is not a point of parliamentary inquiry. Discussion to the bill.
Mr. Speaker.
Representative Hansen.
I rise for a parliamentary inquiry.
State your point of parliamentary inquiry, Representative Hansen.
Mr. Speaker, I was looking at rules relating to in Masons, relating to differences between the bodies, between the executive branch, the legislative branch, and the judicial branch. And if we have the legislative branch taking action with its employees, it has some protections from the judicial branch, but not all. How does this bill relate, and how does the consideration of this bill relate to those protections for the separation of powers?
Again, Representative Hansen, that is not a parliamentary inquiry. That is you're asking for a judgment. As Speaker, I will not issue a judgment on that. Discussion to the amendment. Seeing no further discussion, a roll call being requested. The clerk will take the roll on the amendment. Members, please vote. The clerk will close the roll. There being 57 ayes and 67 nays, the amendment is not adopted. Seeing no further amendments at the desk, the clerk will give the bill its third reading.
Third reading, Senate File 429.
Third reading. Discussion to the bill. The member from Hennepin, Representative Hortman.
Thank you, Mr. Speaker. I'll be very brief. I know people are ready to move on, but I do hope that people will strongly consider voting no on this bill. I had 3 different amendments in civil law, exempting actions in consumer fraud cases, exempting discrimination cases, and exempting cases in Deceptive Trade Practices Act. Those are all cases where the attorney's fees award are very disproportionate to the damages. If somebody were to rip off all 134 members in this body $5 each, for us to stop that person from those actions, we need statutes to allow attorneys to be able to recover their fees. Otherwise, they don't have any incentive to go forward and stop people from ripping off other people. The other case is very low-income people in discrimination cases. They have very low-paying jobs, so their damages are small, or in housing discrimination. They have very low rent, they have very low out-of-pocket damages, and if attorneys could not recover their fees, those people's civil rights would not be vindicated. So I really think of all the bills that we've considered today that this is the worst, and I really hope that people will consider voting no.
Discussion. Discussion to the bill. The member from Dakota, Representative Hansen, to the bill.
Thank you, Mr. Speaker. Would the author of the bill yield?
He will yield. Representative Hansen.
Representative Mazorol, has the Minnesota House of Representatives retained counsel against potential litigation by an employee?
The member from Hennepin, Representative Mazorol.
Thank you, Mr. Speaker. Representative Hansen, I don't know the answer to that question.
The member from Dakota. Seeing no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 76 ayes and 49 nays, the bill is passed. Its title is agreed to. Next bill on the calendar today is House File 56. The clerk report the bill.
House File 56 on the calendar for the day, the first engrossment, an act relating to veterans.
Calling the author of the bill, the member from St. Louis, Representative Dill, to present your bill.
Thank you very much, members and Mr. Speaker. House File, I believe it's 56, has to do with veterans. And I very quickly will give you the story. This has not received a no vote in any committee, including in last year. If you work for IBM or 3M or Dill Enterprises or Drzowski Enterprises or Thiessen Enterprises, and you go and have a deployment, you then are assured by state law that you will get your job back, unless the company isn't in existence. You will get your job back upon the return of from your deployment. If you work for the federal government and you are deployed, when you come back, you will get your job back without a question. But if you work for the state of Minnesota and you come back and they don't have your job for you, you have no recourse because the state has sovereign immunity from suit. So one of my constituents, a colonel, went to Iraq and was the chief in charge of guarding Abu Ghraib, which is a famous place. 4 terms he spent there as the chief in charge of security. He was a professor at a Minskew college. He came back to get his job back, and the job had gone away because it went online. And at least partially online, and they didn't need that anymore in the Minskew system because of those circumstances. So he sued in federal court, and the court found that because the state had sovereign immunity, that he had no standing. Exactly opposite of that, who working for any enterprise in Minnesota or the federal government where they would have standing. So what this bill does in relationship to the USERRA laws is waive sovereign immunity of the state so that this person would have had standing. Interestingly enough, this person was in his middle 50s. Interestingly enough, he ran against me twice as a state representative. He is a well-educated man, and he decided after this treatment that he would go to law school so that he could fight for other veterans. I'm happy to announce that in this short time, in 3 years, he has graduated from law school and is preparing a practice to do this type of litigation on behalf of other veterans. So that's simply the bill. It makes it so they all have the same standing, whether you work for the state, the federal government, or a private employer in the state of Minnesota.
Seeing no amendments at the desk, the clerk will give the bill its third reading.
Third reading, House File 56.
Third reading. Member from Hennepin, Representative Simon.
Thank you, Mr. Speaker. I know everyone wants to leave. It's the last bill, but I can't help but notice the irony. I'm going to vote for the bill. It's a great bill. But this is a bill to make it easier for veterans to sue the state of Minnesota, which I'm for under the circumstances. And we just spent several hours trying to clamp down on, hem in, and limit the ability of other Minnesotans to also utilize their rights in court. I find the irony astounding. I'm going to vote yes. I hope it's a unanimous vote. I suspect it might be. But I hope the point is well taken. That we've done here is for one class of people, a very deserving class, we're opening up the doors and making it easier for them to use the courts. And for a whole different class of people, that being everyday, ordinary folks that we represent, we're saying, no, we're going to limit you, we're going to push you down. That's what's happened today.
Discussion. The member from St. Louis, Representative Dill.
Well, I'm just happy that there aren't any questions because this is so straightforward. I thank you for your support and look forward to the bill passing. And I'm assured this year that there will be action in the Senate. There was no action in the Senate last year for whatever reason, but there was no action. But Chair Perry was here today and assured me that it would be moving forward over there.
The member from Washington, Representative Dean.
Thank you, Mr. Speaker. Thank you, Representative Dill, for bringing this forward. Just like the last 4 bills, this is bringing government and the private sector together, trying to make things a little bit easier, a little bit more even for the state of Minnesota. Thank you for bringing this forward. Appreciate a green vote.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 125 ayes and 0 nays, the bill is passed. The title is agreed to. Representative Dean.
We don't have to do that.
Motions and resolutions are a copy of the non-controversial motions at the House desk and online. If there are no objections, we will take action on these motions first. Hearing no objections, the motions prevail.
Dean moves that, that the House accede to the request of the Governor for a joint convention to hear the State of the State message of the Governor at 7 p.m. Wednesday, February 15, 2012. That the Chief Clerk be instructed to invite the Senate to meet in joint convention at 6:45 p.m. and that the Governor be advised accordingly. And that the Speaker appoint a committee of 5 members of the House to act with a similar committee to be appointed by the Senate to escort the Governor to the joint convention.
Member from Washington, Representative Dean, to your motion.
Thank you, Mr. Speaker and members. Members, this is out of courtesy and custom an invitation to the Senate and to the Governor to hear his State of the State address in our chambers.
Discussion. Seeing no further discussion, the motion prevails.
Dill moves that House File 2022 be recalled from the Committee on Environment, Energy and Natural Resources Policy and Finance and re-referred to the Committee on Governmental Operations and Elections.
Calling the member from St. Louis, Representative Dill, to your motion.
Thank you, Mr. Speaker, and both chairs have been consulted on this and have no objection to my knowledge, and I'll stand for question.
Discussion. Seeing no further discussion, the motion prevails.
Erickson moves that House File 1843 be returned to its author.
Calling the member from Mille Lacs, Representative Erickson, to your motion.
Thank you, Mr. Speaker. I'm asking this bill to be returned because it had technical errors, and I've had a new bill redrafted and introduced.
Discussion. Seeing no further discussion, the motion prevails. Announcements by the Speaker.
Announcement by the Speaker. The Speaker announces the appointment of the following members of the House to escort the Governor to the joint convention on Wednesday, February 15th, 2012. Vogel, Banyan, Keel, Allen, and Moran.
Announcements. The member from Scott, Representative Beard.
Thank you, Mr. Speaker. Members, I rise at the moment as the Chair of the Legislative Audit Commission. Members, in your mailbox today, you received the annual solicitation for topics for the Audit Commission's Topic Selection Committee, chaired by Senator Roger Reinert this year. The House members are Representative Rick Hansen, Representative Sandra Erickson. Members, if you think of things you'd like the legislative audit tour to look at in the upcoming year, please jot those down and forward them to Representative Rick Hansen, Representative Sandra Erickson. And we have a couple of weeks to do this, and we'll gather some good ideas. Thank you for your attention to the matter.
The member from Ramsey, Representative Lesh. Announcements.
Thank you, Mr. Speaker. I would like to invite all of you to the Welcome Back to St. Paul party down at the Ordway going on right now, and I've been told there's still plenty of food down there. We have, and it's good food. You may remember last year, if you're around, you heard Bill Murray do his famous line from Caddyshack about jumping ship in Hong Kong, making his way over to Tibet. Well, I'm sure there'll be something as interesting or more interesting this year. Complimentary valet parking in the Ordway, so just pull up in front of the Ordway, and we hope to see you there on behalf of all members of the St. Paul delegation and the City of St. Paul. Welcome back to St. Paul.
Announcements. Member from Washington, Representative Dean.
Mr. Speaker, I move that when the House adjourns today, it adjourns until 12 noon, Wednesday, February 8th, 2012.
Representative Dean moves that when the House adjourns today, it adjourns until 12 noon, Wednesday, February 8th, 2012. All those in favor signify by saying aye. Aye. Opposed, nay. Motion prevails. Representative Dean.
I move the House do now adjourn.
Representative Dean moves that the House do now adjourn. All those in favor signify by saying aye. Opposed, nay. The motion prevails. The House stands adjourned until 12 noon, Wednesday, February 8th, 2012.